Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, my friends. Today's Wednesday, June 11th, 2025, and day 31 is about to begin of the re-persecution of Karen Reed out of Norfolk County, Massachusetts. It's a modern day Salem witch trial. We've been doing this for a long time. We're going to hope today we don't have any technical difficulties with YouTube. Did anyone ever find out like what the crazy witchery, sorcery was going on the other day when everyone got blacked out and everyone got teleported to different streams? And did anybody wake up today with like a new sense of purpose, a new feeling of hope? This trial not only is going to be over soon, but we are very soon going to hear the magic words "not guilty." Did anybody else get that feeling? Because I gotta say, I was a little, I've been a little worried, but just I don't know, just like I just didn't know if the jury was really gonna get it, this time, because we've seen this film before and we didn't like the ending. And we're hoping for a different ending this time. But like I said, I would never put money on a jury to do anything ever. But after yesterday, it did. It felt like redemption day. It felt like I woke up today with a new sense of hope and purpose. And I mean, I've known in my heart that I have been on the right side of this since I started looking at it, talking about it, digging deeply into it, because I started really looking into this case. I would say September of 2023 is when it came to my attention, and I started looking at it behind the scenes, and I didn't start publicly speaking about it. It's like I came out talking about the Karen Reed case in January of 2024. And it's been a long, hard road for those of us that have been in the trenches from the beginning. It has not been easy. The public backlash that we have faced, and if you know, and other creators know, that anyone who thought that Karen Reed not only did not do this, but that John O'Keefe was not even hit by a car, really, because it's really what it boils down to. Whether you like Karen Reed or not, she did not hit John O'Keefe with her car, because we finally heard yesterday from a witness who said that John O'Keefe was not hit by a car. It's impossible. It could never have happened. It didn't happen. Well, how fast was the car going? Do you even know how fast was the car going? Said Hank in his best whiny voice. And she said, it doesn't matter because it didn't happen. And I felt this sense of relief. And although, redemption song. Yeah, perfecto. Although I've always known in my heart of hearts that I was on the right side of this, I felt validated by Dr. Lapasada yesterday in a way that I have not before. After Dr. Wolf, I was thinking there's gonna be some person on the jury who's gonna say, well, look, there's a video of it happening just exactly the way that Judson Welcher tried to say that it happened. Or they don't know about Schubert Paul, or they're not somebody shouldn't, unless they watched the first trial. And quite frankly, they live in Norfolk County. Maybe they did. I don't know. But I just feel like it's a different feeling today. And so I'm glad that you're here with me for this because it feels good. It feels good. I almost feel like, I hate to say this because I love Crash Daddy Andy, but it's like they don't even need to, it doesn't matter what he says. I mean, and we know what he's going to say, positive things, and good things that are good for Karen. But after that mic drop testimony yesterday from Dr. Laposada, I'm good. I'm good. I think the jury's good. And, so many people are second guessing the defense team, not calling Proctor or Higgins, every rando witness that was called last year by mostly the Commonwealth to fill in blank. I don't think any blanks need to be filled in. It's like the jury shouldn't have to go back there and figure out a mystery. And it's not Karen's job to figure out the mystery either, or her defense team who did it. He wasn't hit by a car. Something else happened to him that did not involve a car accident. And I think that is really what the jury needs to know. And there's a lot of differing opinions on that. And I respect them all. But the defense team is sitting there every single day and they are getting a sense of what the jury is thinking. And although you never really know what a jury is going to do, I think the vibes from this jury are different. There's 18 of them that have been sitting there this is day 31. They've given up their lives to be there. And do you really want to risk losing them by calling a whole bunch of NPCs? That's a term that I just learned this year. If you don't know what it is, look it up. Because I heard somebody try and shade somebody else. I think it was a line from a movie, like, oh, you're just an NPC. I'm like, what does that mean? And so the defense team is watching the jury and they're seeing every day. And you even heard the judge say it, which I think was completely improper in front of the whole entire world. Like, the jury's had enough. The jury's had enough. They just want to get this case. They just want to get this case and go home. Maybe she can sense it too. They're done. They're not paying attention to Brennan. They're laughing at him now, I think certain reporters have said. And I think that they're very interested when Alan Jackson gets up to speak, and any Alessi and Dave Unetti and Liza Little and any member of the defense team. And they're more engaged with the defense witnesses and they nod and they, listen, I have subtitles on my face. It's hard for me to control my reactions to things. And they're jurors. They're just jurors. People, lay people. I don't know if some of them may be doctors and lawyers and engineers and may have more knowledge about the things that are being talked about. But the one thing that they all have, hopefully, is common sense, because you don't leave your common sense at the jury at the door when you come to sit on a jury. You don't leave your common sense at the door. You come in with your personal experiences, your life experiences, your everyday knowledge, and hopefully that's going to be enough here. You shouldn't have to be an expert. It's good to hear from the experts, and you have to understand. And Dr. Laposada was very, very good at explaining the points that she wanted to make. And she's highly experienced. She didn't rattle. She didn't let Hank shake her and try and break her. It didn't work. I don't think I've ever seen an expert hold up like that. I mean, you saw a professional Dighton police sergeant get up on the stand, Nicholas Barrows, and God bless him for getting up there and telling the truth. You can't even say do the right thing, because everyone should tell the truth, right? And Brennan seemed to try and be able to not just make him second guess himself a little bit on cross about things that didn't really matter, but who knows what matters to a jury, right? You just don't know. And she was amazing. She won the internet yesterday. She's the queen. She's the queen. Queen Elizabeth. I called her on I did have to change my thumbnail yesterday, and it was worth it. Today, the title of the thumbnail is "Who's Your Daddy?" Because Daddy's coming in today, and he's our Mariano. He's our closer. This guy, and he's gonna bring it home. I think he's gonna bring it home. He is going to connect all of the proverbial dots together for us, for the jury, for the world. And then, I look, I've disagreed with just about everything Hank Brennan has done in this trial. I think his strategy is slim and none, and I can't figure it out. Nor do I want to even waste my time or breath or minutes trying to. But his rebuttal case is going to be a piece of garbage. Like it's not even going to matter. It doesn't matter. It doesn't matter. They weren't dog bites. I mean, I'm sorry, they weren't injuries from a car. And the fact that his witnesses are going to come in and say they couldn't find any dog DNA when they finally decided to test for it, something like almost 2 years later, with clothing that had no chain of custody, was soaking wet, thrown in a bag altogether. Doesn't matter. I don't think. Do you think it's gonna, it's gonna sway somebody back onto his side to find out there was no dog DNA found on John O'Keefe's sweatshirt when only maybe 1 or 2 of the holes on the outside of the arm were swabbed by a technician who failed her proficiency exam, had never swabbed for DNA, canine DNA before, used the same 2 Q-tips on a couple of arms of the holes on the arms that I don't even think she remembered what holes she swabbed or how she chose them, and used the same 2 swabs to swab each hole and then threw them in an envelope and mailed them off to California. Is that her testimony? Because I, to be honest, I didn't go back and watch it again from season 1. And then Terry Kuhn is going to come in from UC Davis and say, I tested those swabs and I didn't find any dog DNA, but what I did find is pig DNA. Dogs chew on pig ears for treats. A lot of people have pointed that out. I think there was some talk that John O'Keefe may even have had some loaded potato skins at the bars. I don't know. But is it going to make a difference? Dr. Lobsada couldn't say they were dog bites, but she could say they were animal bites. They know the dog disappeared. I don't know. I don't know. The clothing could have been washed. The DNA degrades when it's soaking wet, kept in a bag, all thrown together. You got to look at the methodology. And so this is not at me. Our jury's gonna, is the jury gonna say, well, it must have come from the taillight because it didn't come from a dog? Let's see what Rentschler has to say today. I don't think so. But like I said, I would never put money on what a jury's going to do because all it takes is one holdout. All it takes is one holdout, and we're looking at another mistrial. And will Massachusetts try her again? Probably. Do we want a season 3? No, we don't. No, we don't. This is exhausting for most of us, many of us, even you guys who are sitting at home. I know how exhausting it is. Good morning, Robert Bourbon says. In a TV interview, Karen said she dropped John off at the driveway and he went into the house by the side door. If John O'Keefe went into the house by the side door, would he have been seen by other people? If John went into the house by the side, there's 2 side doors. Okay. There's the side door. So there's the front door that is in the center of the house. As you're looking up, you would have to walk up the driveway and to the left on the path to get to that front door, the main front door where people take off their shoes when they get inside. Then there is the side door breezeway where there's a side door to go into the house, and then a door that goes into the garage. And I've been saying this for a while. What if somebody said to him, come to the side door, and he went to the side door and he went in the garage door? Oh, thank you, Auntie Deb. It did work. I was watching Auntie Deb morning pre-show, and I heard him saying, I'm gonna teleport you over to the dean after this, the dean of students, because Jimmy's a teacher. And I thought, okay, if that dean of students is not me, I'm going to be mad. But it did. It teleported me over to my own stream. So thank you, Jimmy. Love you. Love you. For those of you who don't watch Auntie Deb's morning show, you should. Auntie Deb came into this case. He's a comedian and he's funny. And he started doing TikToks imitating or impersonating all of the characters in the Karen Retrial. And my personal favorite that he did from season 1 was Jessica Hyde. It was amazing. But we also love his Auntie Bev because he puts a wig on, he crab walks. It is like nothing you've ever seen, and he has got an amazing. morning show, and he will keep you laughing in the morning because we all need to laugh. Otherwise, we're going to cry. So let's keep laughing today. Snark Tank. You guys are called the Snark Tank for a reason. I love my chat. Love my moderators. Show some love to the mods today because their job, they're doing the Lord's work over here, trying to keep it classy, and it is not easy. What have you been seeing by the other people? So the other people were inside partying, playing their music real loud, listening to apparently It's Raining Men videos, and they're sitting on the other side of that side door. I don't know if that side door goes exactly into that little area by the kitchen where there's a table. And there's also a door that goes down to the basement inside the front door. So, everyone says they didn't see him. Well, we've heard two people only this year be called to the stand, Jennifer McCabe and Sarah Levinson, say that he didn't come in the house. Could he have gone into the garage? Could somebody have been waiting for him at the top of the driveway? We know Higgins called him at what time? 12:20. You coming here? Jennifer McCabe and all those phone calls she deleted from her phone that she made to John O'Keefe, and her text messages, pull up behind me here at 12:45. She testified in the first trial, maybe in this trial too, that she was looking out the window. She saw Karen's car move 3 different times. It was at the driveway, and then it moved up, and then it was by the flagpole, and then it was gone. And her last text message to John was at 12:45. In the first trial, Matt McCabe, her husband, also testified. He wasn't called this time. He's the guy who texted to everyone, tell him the guy never went in the house. He's the one who was scoping out the neighborhood the other day and said, they're here, but they're by the Asian house, meaning investigators, state troopers. He was curtain twitching too. He was looking out the window, said he saw Karen's car, I think, move 3 times too, right, Matt McCabe? And so I've been saying maybe he had never been to the house before. So maybe when they said side door, if they said side door, maybe he went into the garage. Maybe the dog was in there. We don't know. Whatever happened could have been an accident. I'm not saying anybody did anything intentionally. Maybe the crime was in the cover up. And so the answer is, if he went in the side door, I don't know if people would have seen him, because I don't know if they were yelling, screaming, drinking, partying. They were celebrating Brian Jr.'s birthday. We didn't even get to hear the great story from Julie Albert, Colin's mom, how she delivered donuts the next day for Brian Jr.'s birthday because it's a family ritual, she said. Family ritual that she would drop off donuts for Brian on the morning of his birthday. But she was going to leave him in the car. She was just going to leave the donuts in his car. The frozen, she was going to, do you believe that? We didn't get to hear it this time. You guys, if you're here for only season 2, you didn't get to hear it. And we come to find later that she also brought, like, I don't know if it was coffee and like the box of Joe from Dunkin', because there's a Dunkin' like every 3 blocks in Massachusetts. And was she going to leave the box of Joe in the car too? So there's so much sus behavior that we didn't learn about this time. Or if you're new, you didn't learn about it. Does it matter? I don't know. I think they did the right thing by focusing on the science and the physics and the medicine, showing that it's impossible that he was hit by a car, and then everybody goes home and let the FBI sort the rest of this stuff out later. That's what I say. We have handcuff emojis for members in addition to many, many, many other emojis. Frozen donuts can also be used as hockey pucks. Oh, thanks, Kindergarten Cop. There's a fun fact. And we love that Crash Daddy Andy also talked about his work with the NHL yesterday, because I'm a hockey fan. And I love my Rangers. Paul's here. Justice via women like Dr. Russell and Dr. Laposada. Isn't it interesting how the older women are bringing it home this time? They're bringing it home. I'm loving it. Thanks, Paul. On top, thanks for your super sticker. Mrs. McMack, great song for the playlist in honor of Dr. to honor Dr. Laposado and the Crash Daddies is You're the Voice by John Farnham. Much love from Australia. 10:55 p.m. on June 11th, 2025. You know what? Did you already recommend that song to me? Because I did not know John Farnham, and somebody recommended a song by John Farnham to me, and I put it on the playlist. I'm not sure if that's the exact song. It's an artist that I'm not familiar with, but I hear that he's Australian, because I did do a little deep dive into that. Let's see. For those of you who don't know, we have a mixtape for the Karen Read trial. Season 1 and Season 2 are combined into one mixtape. It's on Spotify, and you can find it in the show notes below this video. It's in here somewhere. A lot of interesting, like Dominic Fike, someone else I had never heard of, dancing in the courthouse. Someone suggested that to me. Confetti by Charlotte Cardan. Artists that I was not familiar with. And there's some Irish artists in here. It's pretty cool. It's a pretty cool playlist. Macon and Clancy there's a song called The Liar that someone suggested, an Irish viewer, I think. And so I thought I put it in there. If I didn't, I will. Thank you, Mrs. McMack. For you 20. Marianne, thank you so much. Says I'm a beautiful cupcake in a world of muffins. Well, I'm just trying to hear to spout the truth. Thank you for helping us. You guys help me just as much as I help you. Trust me. Thanks, Marianne. Chloe and the red solo cups. Why does this thing think I'm talking to it? Please shout out to hubby Chris, who is now super into the trial with us cupcakes after 2 years of me shouting at the TV with you. Love you with all of my heart. It's so hard, isn't it, Chris, to live with someone who is obsessed with this trial when you have no idea what she's talking about. So feel your pain for having to deal with it, but aren't you so glad you did? Aren't you so glad that you're watching now, because you too are seeing the horror that's going on? It's like a horror movie that we can't get out of. It's like a mix between a horror movie, Groundhog Day, The Truman Show, and that reality show Jury Duty on Amazon Prime, which I highly recommend to everyone if you haven't seen it. Jury Duty is amazing. That's what it's like every single day. You think every day can't get worse than the day before, and somehow it does. It just does. So shout out to Chris. Thank you, your wife, for the super chat. And we're just going to keep on keeping on because that's all we can do. P. Barrows Truth Daddy says, my new merch is being delivered today. Yay, I'm going to wear it every day until this nonsense is over. Civil trial too. Oh, thank you. Good morning, Mrs. Bouquet. I love you too. Thanks for tuning in from across the pond. Cat's Meow says, I can't believe what we saw yesterday with the Commonwealth. Who is behind the curtain? Tell Auntie Bev what to say and do. Your guess is as good as mine. I just, there's somebody behind the curtain. Is it the Wizard of Oz? I don't know. Is it someone good or someone bad? Is it, I just, look, I hate to accuse any judge of corruption, and I'm not doing that here, but something is amiss. Something's in the water in Norfolk County, and it goes far deeper than the Karen Reed case, and that's what I think. Again, I'll point out to you that judges in Massachusetts are appointed. They are not elected. Do with that little nugget what you will. Good morning, Sandy V. You're on time today. I wasn't. Better you than me. But we're still waiting, so it doesn't matter. Jenny 3 times is here. Good morning. Let's be our girl Karen Reed. Love it. Love when you guys change your usernames to things that I just off the cuff say. And Jenny 3 times was one of them. That was a thumbnail. Jennifer McCabe said everything 3 times. And people that have pointed out to us, Truth Revealed is one. He has an amazing YouTube channel. He's a CIA interrogator or something such as like that. I'm not sure his credentials, but his life's work has been interrogations and knowing when people are lying. And he has done an amazing work on the Karen Reed case and all the witnesses that have testified. And he points out when he thinks they're lying, when he thinks they're not being truthful. He goes through their testimony. He highlights things in different colors. It's fascinating to watch. And he says that when somebody says something 3 times, it's because they are lying and they really, really, really want you to believe them. 3 is the magic number. Does anybody remember that? Was that like a Schoolhouse Rock thing? 3 is the magic number. I'm dating myself, but I don't care. I'm old. Gen X. Unite. Sergio Denaro. Yes, he's amazing. He's amazing.
Do not do that today.
Oh, I hear a sound. Somebody just said, do not do that today. And I'm not sure what that was, or something such as like that. Thank you, Call Me Jeeves. Finally checked the playlist today. AC/DC, Hard as a Rock, is not on it. No, there's some other AC/DC on there. You're the first one to suggest that. Thank you. In on the joke. Looking forward to real justice for John and Karen. It may be a while. It could take years, but we're going to wait. We're here. We're not going anywhere. Kat says, I'm so worried Bev will deny the missing witness motion. What do you think?
Have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, you shall be heard. I state the Commonwealth of Massachusetts. Court is now open. You may be seated.
God save the Commonwealth. of Massachusetts.
And refrain from discussing this case with anyone since we left yesterday. Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from? Everyone said yes or nodded.
The jury's here right away, but look at what the captions just
Follow the
said.
instructions and refrain from. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation?
Oh, I thought it said something different.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or?
She needs a
Dr.
curtain.
Rentschler again, please.
She needs one of those ugly curtains on the other side to match that curtain, because now the sun is coming out of the other window and it's right in her face. So that ugly hospital curtain that they got from wherever they got it from is not doing the full-on job. Good morning, Eugenia, my favorite court officer.
Doctor, on Monday, you're still under oath.
Yes.
Thank you.
Good morning.
Good morning, Your Honor.
Happy Crash Daddy Day. Happy Crash Daddy Andy Day to those of us who celebrate. Praise be under her eye. Let's get this party started.
All right, Mr. Jackson, whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your
Born
Honor.
ready.
Dr. Rentschler, good morning.
Good morning.
Yesterday, when we last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's not for identification.
He's going to save his objections for when, comes time to enter it into evidence, or each slide individually he'll object to will be here all damn day.
KK for ID.
Let me know whenever you, pardon me, let me know whenever you're ready, Dr. Rentschler.
Sure, you want me to bring up the PowerPointer?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here. There we go.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer. Ask the question again.
Sure.
Why can't he say
Did
alleged
you seek
theory?
to
It is alleged.
undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing?
Sustained.
Ultimately, were you in receipt of a PowerPoint presentation and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation?
So I'm going to see you both at sidebar for just a minute, please.
Okay. ARCA did extra work on this case to the tune of 50 grand. Originally, they were hired by the FBI to determine two things. Does the damage to Karen Reed's Lexus, they didn't know it was Karen Reed, match up with the injuries to John O'Keefe? And do the injuries to John O'Keefe match up with the damage to Karen Reed's Lexus? And their answer was no. They built a cannon. It was awesome. Now they've done some extra work because now the Commonwealth has changed its theory, hired Judson Welcher. He was not here in season 1. And Shannon with one N Burgess. And they did extra work and extra testing to refute these new claims by Dr. Welcher, the Blue Man Paint Group test, and the, Shannon Burgess's, I can't even remember at this point what he testified to. That was the whole purpose of this testing. Hank Brennan is going to fight like hell to keep it out because he knows his case is over. It's over. It's over now. Boz Skaggs said it best. Now he's going to kick and scream, pull out the binkies and the boss baby emojis because he's got nothing else now. He's grasping at not just straws, wet paper straws, the kind they give you at McDonald's that last for 30 seconds until they're mush. He's grasping at wet paper straws. Good morning, Keschik. Thank you. Worried that Bever will mislead the jury. Well, if the jury's so, thanks for tuning in, by the way, from Australia. If the jury's already getting pissed and they want to go home and they're done and they have their minds made up, Hank calling for a sidebar every 5 minutes is not going to make them feel all warm and fuzzy this morning. It's just not. Were the x-rays just introduced? Yeah, we've never seen them before. In fact, people pointed out and clipped portions of Judson Welcher's testimony where he said x-rays were not done. So was he not given the x-rays? We heard Dr. Labasada say that it's something that is done at autopsies. And we did not see these x-rays in season 1. We did not know that they existed. We heard Judson Welcher say that they didn't do x-rays of the arms. So Chloe bit me. If that's what you're asking, that is the answer. Whether they were just introduced or marked for evidence and are in evidence, I don't recall from yesterday. So I'm not sure. There's a little nuance in your question there, and I don't want to mislead you, but it was not in season 1. Grateful Dead Eyes of the World for the plays. I'm talking about Randy right now. I love that name. I think that's my takeaway so far. My best quote from the trial, the funniest quote, is when Hank Brennan said, "I'm talking about Randy right now." If you can think of a funnier quote, tell me. I'll take nominations. Eyes of the world. I say that all the time. You guys are the eyes of the world. Wake up to find out that you are the eyes of the world. The eyes of the world are on this case. I hope I put it on the playlist because I'm a deadhead. And tonight, I have a date with Dave Matthews. If you know, you know. So we're not going to be here too long after this is over. Hopefully it'll end a little bit early because it's going to be a beautiful day here today. And it's date night with Dave. Good morning. My job depends upon this. Morning, beautiful people. Red's daughter says, new song for Queen Laposada, I'm Every Woman. That's a good one. Or I am woman, hear me roar. So many. Happy hump day. I honestly think Hank tried to hire Dr. Laposada and she said no, he was not a car. Thoughts? Oh, you mean for his case in chief?
May I?
Yes.
Did you undertake to review analysis and testing that was done by Aperture as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCA, yourself included, undertake testing based on your review of the testing by Aperture?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis, that's the second point on your PowerPoint, what was the biomechanical analysis that was undertaken after you reviewed the Aperture reports and Aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those 3 separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So next question, and I'm going to strike that. Next question?
Is there an element of differential
Methodology.
diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that for us, please.
Let me demonstrate. So there are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank you.
Correct. This is injury reconstruction biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual opinion.
And describe that method just a little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing if it's possible?
Absolutely, yes.
Explain that.
In fact, let me explain. Let me get through here. You know, I just had a couple examples here. This third slide, another reference about biomechanical analysis. Again, it's...
Two things. Hank Brennan has been squealing, crying, stomping his feet, and whining about this entire trial are articles, peer-reviewed articles, and methodology. Crash Daddy Andy just said both of those things. How's Hank going to attack him now?
all throughout the literature, very well established how to do this. Now, it's all based on the scientific method, okay? And the scientific method, which it was really established back in the 1620s, but this tells you how to do a proper scientific analysis. So you have an observation, you observe something. So in this case, you might say, all right, there's superficial abrasions to Mr. Keefe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature, you find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this occurs or is a common occurrence, it should be in the literature. You should be able to find information about it. Then you form a hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start to go into your experimentation. You have to develop tests to get data to actually back up your hypotheses. So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle, we ran into it, to determine what's going to happen when that occurs. Do we get the right circumstances, the right loading to actually occur in that case? So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate it. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not. So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis, and that's what's important. You know, I have 3 kids. I have a 9-year-old who's actually...
So I'm going to ask you to wait.
Don't tell anybody about your
Okay,
kids,
sure.
please.
Was there an
Trust me
example
on
that
that.
you could use of sort of a real-world example that you might want to use to explain some or part of the scientific method?
There is, yeah, and I would like to explain an
Please.
example of what's important with that. So I was going to say I have 3 kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have 2 older ones.
All right.
Happy birthday, Kai. Everyone say happy birthday, Kai. Why is it that the Commonwealth witnesses are allowed to narrate and drone on and on and on without questions? And this man just wants to give an example. He's helping us all with science fair projects, by the way. Moms, dads, if you dread the science fair projects as much as I used to, bookmark this for later because he just told us how to do a science fair project. You're not going to allow him to throw in a personal anecdote about his kids so he can explain to them what he's talking about. The fix is in, the jig is up. Handcuffs are coming, but not for Karen Reed. Listen, she's gonna. Happy birthday, Kai. Double digits, dude, double digits.
actually turning 10 today. Happy birthday, Kai. And I have 2 older ones.
All right, we're gonna stop this. Another example.
We're going to
Go ahead.
stop this?
Less editorializing. just-
Minus all the personal.
I'm sorry, Your Honors.
Go ahead.
Details matter, okay? Details in an investigation matter, and details matter here. You need details. You have to explain how things happen, okay? You, as an expert, I can't come in and just say,
Sustained. It needs to be more question and answer.
Why do details matter?
because your opinions have to be based on the facts and the evidence.
Why is that?
Because that's what determines your conclusions. I can't come in and say, I think.
Next question.
What if you don't have all the details and facts?
If you don't have details, if you haven't performed a proper analysis, then you can't come to a conclusion that something happened. You can't depend just on your experience. You have to have the analysis, the evidence, and the details to come to a conclusion in a case.
How do you best get details to come to a conclusion in a case?
You need research, you need peer-reviewed articles, you need evidence, you perform testing. You have to demonstrate what you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
The form.
I agree, Team Brittany, but I don't think she was trying to protect him. I just think that she did not want him narrating anything. I don't think it was done to protect his family, and that's where I have a problem with it. Why can the other doctor talk about making cappuccino for his wife? And we heard all about Dr. Welcher's dad wanted him to be a doctor, but told him not to be a doctor. He got to go into all of that BS. But what's good for the goose is not good for the gander. But I do agree that children should be protected, and I'm not happy that anybody knows this kid's name, or because these people are crazy. The people who hate Karen Reed out there on the World Wide Web are insane. Trust me.
Can you get that in lab testing?
Absolutely.
Can you get that in field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
Let's go to the next slide. Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from, these two slides?
These two slides are from the PowerPoint presentation that Aperture provided.
Here it is, the Nickelodeon Blue Man Group, Prezzo. Come look at your screen.
All right, so you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. O'Keefe, the arm would be at about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis, the fact that the individual, the surrogate, as you use the name, was adorned with the same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter, so we look at the clothing that was worn and the evidence found with respect to that. that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. O'Keefe was wearing this sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to with what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because the clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but it can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is, yes. Look at the damage to the clothing. Look if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another detail, and part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing clothing of individuals that may have been involved in vehicle pedestrian incidents?
I do, yes.
How often has that played a part in your biomechanical analysis, the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing, you need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry, my question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the paint transfer test that was performed by Aperture. And what they did was take a surrogate the same approximate height and weight as Mr. O'Keefe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm. And the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. O'Keefe's arm.
Did you utilize these photographs and videos from the Aperture report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the Aperture report, and the third conclusion is that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX57.
How did you interpret the phrase geometry?
To me, geometry just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that Aperture performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. O'Keefe's forearm.
Did this test, in your opinion, establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial abrasions.
Is there a difference between a laceration and an abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
Strike.
So I strike the end of that.
Good.
Would you describe the injuries on?
Welcher called them lacerations. He was wrong. They're abrasions because that's what the medical doctor said. And happy birthday, Brendan wants freaking Karen Reed for his present. Let's make it happen.
Mr. O'Keefe's arm as lacerations?
No,
Would they be more properly described in another way?
it would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force, they're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step in the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back of the skull, on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities, it's superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken.
Are autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on?
I want to freeze on the slide and see if I can just cover it with the captions because YouTube hates this picture. And every time we show the picture, the entire stream gets flagged as unfriendly to advertisers. It gets shadow banned. But I want you to see what they're highlighting with regard to the autopsy report. So let me just do my magic here. Well, I can't really because, well, I'm going to try here. So here, and I think this is Welcher's slide that he used here. Right arm injuries limited to superficial, or I'm not sure. Did he say that it was his? So here's the final diagnosis. We have not had access to the autopsy report at all. It's not public. It's been sealed and with good reason. it's very blurry, but you can read that. It says final diagnosis. This is the autopsy report drafted by Irene Scordivello. Blunt impact injuries of head and extremities. A, abrasions and lacerations, subscapular hemorrhage, multiple skull fractures, base of skull, and I can't read what that says. Calvarium, I think it says. Calvarium, subarachnoid and subdural hemorrhages. C, report of neuropathologist. That was Dr. Renee Stonebridge. I did a great show on Dr. Renee Stonebridge. They didn't call her. And then it talks about the extremities, and it says that there are 3 centimeter superficial abrasions on the right medial upper arm, multiple abrasions 2 to 3 centimeters, and up to 7 centimeters on the posterior right arm and forearm. It's super blurry. It's not my eyes. And then it talks about contusions on the dorsal aspect of the right hand, on the outside of the right hand, 2 red contusions. And then there's some super, super small print that I can't read, but that is part of the autopsy report, and that is in this slide. Okay. All right. Now I have to take, see, look, I just showed it to you, and now I could get in trouble, but you've seen the picture before. You don't need to see it again.
They are the sources you go to determine what the injuries are. Yes.
Did you see, you reviewed the entirety of the medical records as well as the entirety of the medical examiner's file? Is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay?
He's going
X-rays.
to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
We've never seen the X-rays before, shockingly, but not really. Because all that Sally Port video is hidden too, from us in season 1. Let's take a minute while Mr. Woke, the AV squad guy who took over for
I'm going to
Craig
say
Bates.
226. I may be wrong, Your Honor.
Craig
I'll
Bates.
get the right nomenclature in just a second. This is one of the exhibits, one of 3 exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record, medical records or AE's records?
It was a series of the X-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see, have you looked at X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at X-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at X-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore X-rays, if they existed?
No, if X-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Guess who didn't? Judson Melcher. He wasn't given them by the Commonwealth. Did they withhold them intentionally, or did he ignore them? Was he given them? Did Hank Brennan have them? Did Adam Lally have them? I have so many questions. Happy birthday, Lindsey Gray. Thanks for being here with us today. It's going to be a good day.
See any injuries represented or any defects represented in this X-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to
Okay, weren't we told, old timers, weren't we told that he had boxer's fractures to his right hand, or am I conflating my cases? Andrew Rentschler says no fractures to the right hand. I just remember that being a talking point in season 1 or even pre-trial season 1, that the word was out that he had boxer fractures in his right hand. Let me know if you know.
to 229
There are
B's
none,
and
apparently.
Bravo with the court's permission?
Yes.
You see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229 C as in Charlie,
Team Brittany pointing out boxer
what are we
bruises.
looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the bone is the
The humerus.
humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint either.
What is your opinion in conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back.
No fractures to the right arm at all. Boxer
If we go
bruising
back to
is what
your
I'm being told.
PowerPoint.
Maybe it was Colin, maybe it was Brian Albert. Okay. Bleeding. This is like ice cream for breakfast, says Poppy. It's like Christmas morning, kids.
Can we go to the next slide, please?
Oh, excellent. Thank you, Jennifer. Because Andrea Burkhart is
Maybe.
actually a boxer. Boxer fractures, according to Andrea, is just a saying. It doesn't actually mean a fracture. Thank you, Jennifer Duncan.
See if I can start back on it here. Okay, there we go.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. O'Keefe had on at the time of this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keefe's hoodie play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these series of photos?
So let's move to sidebar for a minute and Mr. Jackson, bring your PowerPoint.
Are holes of the hoodie with a ruler next to them. These are photographs that were taken by Maureen Hartnett, I believe, the criminalist who swabbed it for dog DNA, and they're trying to get ahead of the dog DNA rebuttal testimony. And for some reason, not some reason, the fix is in, the judge doesn't want to allow it. So they're going to go to sidebar and argue about whether or not he should be able to talk about Maureen Hartnett's photos. Remember, she's hired and still does the Massachusetts State Police Crime Lab. She's the one who swabbed the shirt. And for some reason, Hank Brennan really, really doesn't want him to be able to talk about it. She's wicked, says Lisa. Yep, under her eye. Every day, it's like we gotta shake the magic 8 ball. Will she allow it? Let's see. Let's shake the magic 8 ball this morning and see what she says. Will she allow it? Because the magic 8 ball is just don't count on it. It says don't count on it. That's what magic 8 ball says this morning for whether or not she will allow this. We'll see. Somebody should keep track. Zoe, are you here? She's our resident statistician. How many times the magic 8 ball is right today? Becky. Hi, Becky. Good morning. I wonder what Welcher will say about the x-rays. As he said, there were no x-rays taken. If that's what the Commonwealth doesn't keep objecting to stop the defense. Doubling down, Debbie says, Googled Guzman score. Hilarious. Guzma, I think is what it was. Debbie, I did I clipped it and yesterday and put it up on Instagram. If you don't follow me on Instagram, it's linked below the show notes. Trending with the snarkiest comments. Did you realize how many folks are watching with much disdain towards this man outside of the snark dick making history? Yeah, somebody said that I was trending on Twitter at some point yesterday. I do not play on the cesspool of Twitter, but this is Guzma. This is Guzma. After Hank Brennan yesterday said, "Are you familiar with the Guzma coma score?" We all laughed because many of us do know about the Glasgow coma score. Some people say you don't pronounce the W. I don't know. But we do know that it's the Glasgow score. It's a town in Scotland. And this is Guzma. He's in Pokemon. He's the leader of, tell me, the Skull Club or something. So now we know Hank Brennan is a Pokemon fan because he fought with her about it when she said it's called Glasgow coma score. And he said, well, there's Glasgow coma score, but do you know about the Guzma coma score? And he really doubled down on it. And boy, he made himself look like a worldwide fool. Pirouette Randy needs a vax says, good morning. Twitter says one juror not taking notes worries me. Is that the juror that is sitting? Hi, Edmund. Good morning. Is that the juror that's sitting in seat number 1? I had a conversation with someone last night and I said, if the juror who is sitting in seat number 1, who is the young gentleman, I think, is not taking notes and is made the 4-person, the fix is in. So we're going to wait and see. Chandra, why do you suppose John O'Keefe's family staunchly holds to the belief that Karen killed him despite the overwhelming evidence to the contrary? I have 3 words for you. Jen McCabe. Jenny 3 times, got in Mrs. O'Keefe's ear immediately, from what I understand, may have been the reason why the niece did not go to the prestigious Catholic school that she had just been accepted to when Michael Camerano and John O'Keefe went out to celebrate. Both of their daughters were accepted to Bishop. Tell me, is it Bishop Fian? Because I keep wanting to say Bishop Loughran, but I think it's Bishop Fian. And after John O'Keefe's murder, good morning, Olivia Nile. Kaylee did not go to Bishop Fian. She wound up going to Canton High School. And a lot of people think that Jennifer McCabe is the reason. Hey, guys, I know you're watching out there. The watch party is probably ongoing for the McCabe's and Alberts. I don't know if they watch me, but I'm pretty sure at least some of them do because they love to talk about what I say on the internet. So, hey, shout out to everyone watching at the VFW or American Legion Hall, wherever your watch party is today. People think Jennifer McCabe got in the ear of the O'Keefes and has not let go since, and has been a fixture, let's just say, with Mrs. O'Keefe and the children. And so perhaps that is why. Wouldn't they want the real culprits to be held accountable? Love the show and community. Have you heard of Stockholm Syndrome? Because that could apply here too. And I can't say for sure, but that's word on the street. And it makes sense to me. Gaslighting, Stockholm Syndrome, lots of things and stuff. Canoni's Baloney says, I'm wondering now if Higgins' Jeep was hidden in the garage. There's a reason for the story about plowing the drive and then parking by the mailbox. I don't know, but I feel like bringing him in to talk about all that would be confusing the jury. And just like you and me, they'd be trying to figure it out too. And we don't want them doing that. We want them getting in there, getting it done. Was John O'Keefe hit by a car? Yes or no? If the answer is no, we all get to go home, right? So I don't know. Was it parked up by the top of the driveway? Would it have fit in the garage? I have many questions, and none of them, maybe many of them will never ever be answered. Kelly, any reason Jackson can't cross Welcher versus Alessi? If Alessi did the direct on Welcher, which I believe that he did, but every day is blending together, he should also be crossing him on the rebuttal case. I don't know about the Massachusetts rules and whether they could switch up their attorneys on rebuttal, and that is a good question, Kelly. And I think we will find out who will be crossing Welcher in rebuttal. But again, because Alessi is so knowledgeable about every detail of that cross, and remember, every attorney is assigned certain roles and certain witnesses. I think it would be too difficult for Alan Jackson to all of a sudden jump in. And I don't think it would be the right move because Alessi probably knows his testimony like the back of his hand and his reports and everything else. And so I think that they should stick with what they've got. And I don't know if they'd be allowed to anyway. In on the Joke says, let's all meet back here to watch Karen Reed testify at the Brian Higgins M trial. Justice is better when you're surrounded by cupcakes. Oh, yeah. In on the Joke. You know, I am coming back for every single bit of all of the post-production of this season. James is proud that Dr. Lapisato is a fellow Rhode Islander, makes up for John DiPetro. Didn't she handle his attempted impeachment of her credibility about the station nightclub fire with such incredible grace? She had all the answers. She had them. She was ready. She was so ready. Holly points out that Dunkin' Donuts was founded in Massachusetts. Thank you very much. There seems to be one on every corner. Thanks, Bianca, for gifting a membership. Good morning, Shannon. I think Friend of the Devil is on the playlist. Pretty sure it is. Because it's so appropriate in so many ways. Tom Petty, waiting is the hardest part. That's been on there for quite some time. But yeah, we played that. We can't play it on YouTube because they are really serious about music rights here, and with good reason. But yeah, the waiting is the hardest part. Deborah pointing out that Dr. Lapisata said she only received the x-rays a few weeks ago in her testimony. True. Pamela Bailey quoting Dr. Lapisata, a brain is soft like tofu. No, gross. That was a great quote also. One of the funniest quotes. And Paul says, Alan Jackson saying grave concerns yesterday to the judge about Hank's DNA. Well, actually, I think he said it yesterday, too. He said, I have grave concerns. Was it about the dog DNA or Welcher? I can't remember. It's conflating, but he did say it yesterday. He may have said it one other time, too.
Jurors, I apologize that took so long, but it was necessary to do rather than sending you out. So, sure.
Three Little Birds is definitely on there, I'm sure. Every little thing's going to be all right, Patio.
Tori, can you give me a couple of these? Tori.
Come here talking.
Okay.
LSD McJD pointing out, I guess it only matters if your father told you not to be a doctor, not because it wasn't worth it to help people, but because it wasn't financially worth it. Yes, Dr. No, is he a doctor? Judson Blair Welcher. He sounds like a character from Gossip Girl.
Dr. Rentschler, my eyes aren't good enough to see the upper right-hand corner. What slide number is this?
Number 12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13,
Good, they're in.
Please? Did you also look at and consider these photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions regarding this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yeah. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keefe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the yellow indicators?
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
Oh,
Can you scroll to slide 22 quickly, please?
9 defects
What is this?
in the shirt, but 36 on the arm,
This is
37?
a slide, again, from Aperture from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover.
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently. What did you
How did you
analyze?
interpret that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the tail light, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from Aperture?
These are all from Aperture. I did not put any of those on there.
You see the small, it's it's vertical photograph of Mr. O'Keefe's arm?
I do, yes.
Did you note anywhere in the Aperture report a denotation of the number of abrasions, counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of and all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons.
Could be one of the most important pieces of testimony today. The injuries to the arm are not consistent with being hit by a taillight. There it is. You heard him say it. And now he's going to explain why.
That I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or.
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about
Yeah.
to say contact with the taillight.
Yep, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
Yeah.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Sustained.
What was the condition? Let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. O'Keefe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time,
With the 9 holes in the right sleeve.
with the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure. Let's go to the next slide, please. What is this?
These are, the top two and bottom right slide are from the Aperture PowerPoint.
How did you interpret the the 2 photographs on the right, the parallel lines and the red lines in that slide?
The parallel lines correspond to an area of the fractured tail light, and then the red dotted line corresponds to an area of abrasions on Mr. O'Keefe's upper arm, and there's a red arrow pointing to part of the fractured tail light.
Can we go to the next slide, please? What are we looking at in this slide?
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the tail light and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
That's very important.
Why?
Because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the
It's on loop. They just keep playing him knocking into the paint. Raise your hand if you would have loved to have been a fly on the wall the day that the ARCA witnesses watched this video by Judson Melcher. Me.
the still photograph to the left in slide 24. Is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher, as it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear tail light of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the Aperture data?
I did, yes, sir.
What were you seeking to determine when you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25?
Duncan headquarters
What are
in
we looking at in
Canton.
this slide?
AJ's beard.
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in as demonstrated by the paint test with the arm at approximately 90 degrees.
What was the import of this, this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to
How
slide
many of you engineers, medical professionals, so many of you have sent me emails with this exact point? The injuries on his forearm would have been direction-wise, the other direction from which they appear in the photos and in real life. It is impossible. That is exactly what BN Trouble 31 said in one of his many videos, one of his early videos. Now we're hearing it from the mouth of Dr. Rentschler. Nurses in the chat, Mac RN is screaming.
26, please.
Let's hear that again.
You would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please?
Should be horizontal. And they're not, they're vertical.
This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the taillight cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up with the type of kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
If the arm was positioned as it was indicated in the paint test done by Aperture, would you expect to see this pattern of injuries on Mr. O'Keefe's arm if in fact it contacted the taillight and if in fact it was abraded based on the taillight?
You would not. You can't get, for instance, horizontal abrasions on the upper arm and somehow get vertical and angled abrasions on the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please? What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or of the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same, well, it's only approximately the same area.
So I'm going to strike that, so next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that in that right photograph?
Nothing, no types of measurements whatsoever.
Can we go to the next slide, please? This is, on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please?
He just kind of bumps into it drunkenly.
Did you see what you were describing in that video?
I did, and I can slow it down. So you can see, even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of paint on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that paint pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the next slide, please.
He's not allowed to criticize that's
What
not
is this?
proper scientific
And
testing.
so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm to get that pattern.
Your Honor, this man is not allowed to make fun of my expert. Objection. And the circus music is on the playlist. That's
Thank
funny,
you.
Burby.
Can we move to the next slide, please? This is slide 30. And
As
let's
is,
go to 31.
Yeah, this is 31.
I'm sorry, 31.
as is the Benny Hill theme song.
What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this part, this approximate part of your arm, because we don't even have any measurements for it. That's the only thing that that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The
for those
basis
opinions?
is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide,
There we
please?
go. We're getting funny now.
Actually, slide 33. I may have just a moment, Your Honor.
Yes.
We have room to scooch here. Scooch, scooch.
Of the paint transfer. Did any of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, or the sweatshirt, with 9 holes in it?
That's sustained. You have to ask that differently, Mr. Jackson.
Did you determine, based on the testing by Aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts paint on the arm.
Right.
So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible,
Preach.
would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no
offended.
research data, and the only test that was done that links the injuries to the taillight cover is this paint test,
He's
Is
offended
that the paint
personally by
test in which
this.
the arm was leaned into the car?
in which the elbow was shot forward and then the arm and upper arm was leaned into and against the cover.
Doctor, did you also go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved?
I did, yes.
Can you describe that for us, please?
Sure. So one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm.
I just have to say, does anybody remember when Trooper Paul was asked by Alan Jackson about kinematics? And the look on Trooper Paul's face was like he saw a ghost. He was like, kinematics? He said, do you know what kinematics is? And Trooper Paul said, no. In fact, we watched Trooper Paul's testimony during the Super Bowl at halftime for entertainment. Yes, we did. That was great. That was fantastic.
The arm, you need to look at the motion of the arm. If the arm hit the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies, they use the 50th percentile arm to look at airbag deployment. One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often. So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar to if your hand was hit by the back of the arm was hit by the back of the car and propelled forward. That's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm, and here we have an SUV actually contacting the rear of your arm.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go. Thank you. What's depicted here?
So this was testing done at 15 miles an hour. So this is with the hybrid arm and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage. As you can see, it catches kind of the hand and the forearm. And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
How you like me now with your glancing blow at 15 miles an hour? Because you can't commit to a speed this season, Mr. Brennan. Season 1, it was 24.2 miles an hour. We know, we were there, we heard it. Judson Welcher said it would have with a glancing blow, the taillight would have exploded at 8 miles an hour. They did the real test. You can tell because the Lexus is a different color. It's a lighter color than the one that Aperture used because they bought one. They bought that Lexus at Aperture. 15 miles an hour. It didn't shatter the taillight with a glancing blow. Hello. As if the case wasn't already closed. This is the icing on the cupcake, my friends. And it's delicious.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm. So at that position, if there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50 times faster than you can blink.
Can we go to the next slide, please?
Wow, look at
And
that.
what are we looking at in this?
So this is lab testing at 17 miles an hour. So the housing and the cover was basically propelled into the forearm of the dummy at 17 miles an hour.
What was the acceleration that was noted on the arm?
So when you look at the arm, the acceleration here is almost 300 Gs.
What does that mean just to us?
So, 300 Gs, if you look at weight, if you say the weight of the arm is 10 pounds, 300 Gs means there's 3,000 pounds of force acting on that arm.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to to tear ligaments?
Absolutely, yes.
Yes.
What about the bones in the hand? Are those stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller and it takes much less force to fracture your hand bones compared to your ulna or your radius.
Let's go to the next slide, please.
I've been saying this.
What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour.
Oh, my.
That's what it looks like if you have your hand out and it's struck by an SUV.
Is the arm accelerated in this? Do the same physics apply? Is the arm accelerated up to the speed of the car in milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's sticking out there is immediately going to get accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the Hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
No, it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle?
Randy's getting upset. Randy's getting upset. They're calling him a dummy. He doesn't like it. His wife, Debris Field, she doesn't like it either.
What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24-mile-an-hour test, were there forces on that dummy that were perpendicular to the car such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of your body is basically your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But the center of mass of your body isn't going to move. You have to get struck by the vehicle to have the body actually move in a specific direction.
Can we go to the next slide, please? What is this showing?
So this is a slow-mo of the overhead from the real time. It was a GoPro that was recording that real-time video, and this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm as it's being contacted in those milliseconds where it's being accelerated up to 24 miles an hour?
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like ripping imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for the 24-mile-an-hour impact?
G-force, let me see exactly.
Could you pause that video for a second?
Sure.
Because I want to ask you a couple of questions about it as well.
Let me see exactly what that G-force was.
Do
Shattered.
you refer to something?
Yes, my report.
With the court's permission?
Yes.
Thank you.
Shattered is on the playlist. Rolling Stone's been on there for a long time, and it's appropriate right now. That's all I can think every time I see that.
The accelerator at
Car hit
24
Randy's
miles an
arm.
hour for the arm, the acceleration is 302 Gs, and for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Thanks, Aaron.
Pause it where I ask you.
Cynthia
One
says
more frame back.
Welcher should
One
be
more.
embarrassed.
Right
We all
there.
think that. I wouldn't
What's
come in if I
happening?
was him.
Physically to the arm to the right arm at the point of impact?
So there is a force on the hand, on the forearm, where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm. That's not how your arm is actually articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. O'Keefe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle and the car comes back and hits your hand, it's going to strike right on the knuckles. The force is going to be applied right at that joint. And then it's going to likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Well, it's somewhat of an abnormal shape because the arm should be level with the body. The forearm should be even with the shoulder. But you can see as it gets pushed forward, it's accelerating that forearm away from the arm and the rest of the body.
Does that abnormal shape suggest anything to you in terms of what you would expect regarding the bones in that arm?
Again, certainly there's thousands of pounds of forces acting on the arm. And also on the joint itself, not just the arm, or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
No
Did you see
dislocated
any
elbow.
evidence based on your review of the medical records, including your review of the x-rays, any evidence of any dislocation?
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
Fractures or broken bones at all?
Correct, nothing.
Not a one.
Can we go forward
Zero.
another frame? And at this point, the arm has already been struck and accelerated, is that right?
That's correct.
Do you see the taillight material?
I do, yes.
Okay, it's basically now broken, is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward. And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
It's going forward.
And where is the arm?
The arm has been pushed away. Now, you have to remember, as that arm, if it contacts and fractures the taillight, it's not exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics, yes.
Is there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact when the arm's being deflected away from the vehicle?
It is not, I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now, you can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the motion
Nobody ever took measurements.
of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest, before he even has a chance to get to where they find him.
Let's go to the next slide, please.
He's telling them everything.
What is this slide showing?
So this is just frames taken from that actual video showing the interaction from the top left then you go down to the bottom left, and then the top right and the bottom right just shows you the progression of the contact and the movement of the arm.
Is the bottom left frame the same frame that you stalled on just a second ago at my request, showing the deformation of his right arm?
That's correct, yes.
Thank you. Next slide, please. And is that just a close-up of the same?
That's just a close-up of the same, yes.
Okay, next slide. And is that a final close-up of the arm after it's been deflected out of the way?
That's correct, yes, sir.
Does this also illustrate what you just described in terms of the trajectory of the broken taillight fragments?
It does, yes, sir.
Do you see any defect at all in the right sleeve of that hood?
There is no defect in that right sleeve of the dummy. No,
Was
sir.
the dummy's sleeve examined following this test? Closely examined up close rather than just a photograph?
It was examined and photographed, yes, sir.
Was there any defect in that right sleeve at all?
No defects at all were noted in that sleeve. No.
Next slide, please.
Oh,
What are we seeing here?
This shows some of the photographs taken of the sleeve and the arm to show that there's no defects whatsoever, and it shows the damage to the Lexus. And again, at 24 miles an hour, not only do you get damage to the taillight on the fender there, but you also get damage to the taillight on the liftgate.
Was there any damage on the taillight of the liftgate in the subject SUV?
There was not, no.
Next slide, please. What are we looking at in this video?
And so this was 29 miles an hour with a suspended hybrid 3 arm.
Was the arm in the relative orientation that you saw depicted in the paint transfer test by Aperture?
It was, and in fact, in this one, there's actually contact. We moved it in so that you would get contact with the elbow and the upper arm as well. So it's in the position after Dr. Welcher moves his elbow in and rolls his shoulder into the taillight cover. We evaluated that position with this test.
And do you see any damage to the liftgate taillight based on this test?
There's extensive damage at this speed, yes.
What about the damage to, damage would you expect to see to the arm itself at this speed and in this orientation?
Yeah.
At this speed, I mean, we're talking 4,000 pounds of force on the forearm, and with the hand, 1,400 to probably 3,000 pounds. I mean, well above levels where you would get fractures.
Next slide,
Shadoobie,
please.
Shadoobie,
What are we looking at in this
Shadoobie.
slide, these two photos?
This was the final test that was conducted in using a dummy, and it was impacted at 29 miles an hour. And this was a center of mass impact.
Why was it
meaning-
important, Dr. Rentschler, why was it important to do a center of mass test?
Because if we have an auto pedestrian impact and you want to see where the pedestrian ends up, you have to evaluate how they were impacted by the car. In order to have the pedestrian move any substantial difference, it has to be hit at the center of mass. Again, it has to be hit at that belly button area to propel the body in a certain direction depending on the speed and direction. If there's no center of mass impact, how does someone get to the point of rest?
Right.
You can't correlate a side swipe where the arm gets contacted and say if someone ends up 20 feet away, there's no way to correlate that arm impact caused them to somehow move 20 feet away. It wouldn't be as a result of the actual incident. It wouldn't be a result of the impact pushing their body in that direction.
And he says that with such certainty that you just can't not believe him. So if you, this time, Commonwealth, you're going to go with the glancing blow or the clipping, because Karen Reed said clip in one of her interviews. So you stole that from her. And now you're saying he was just clipped. This witness is telling you that there is no way he could have been thrown to where he was allegedly found on the lawn. It couldn't happen that way because physics, science, and common sense. Praise be Dr. Rentschler. Praise Dr. Forget about Keir. Praise Rentschler.
From a physics standpoint, is it reasonable to believe that your arm could be struck, just your arm could be struck as it's out in front of your body, and you could be propelled backward, say 7, 8, 10, 12 feet as a result of that strike?
No, it's not reasonable. That's not physically possible. And you look at the arm itself, and we're looking at talking about the injuries and the abrasions compared to fractures. So if Mr. O'Keefe's arm was hit at 24, 29 miles an hour, what this suggests, and there were only abrasions, what this would suggest is that if the taillight doesn't cover or fracture, you can have your arm hit at 24 miles an hour and you wouldn't have any injuries at all, which from a biomechanical standpoint doesn't make sense.
Right.
If the claim is that the fractured taillight's the only thing,
So I'm sustaining the objection to that. I'm going to strike that portion, Mr. Jackson.
Sorry, why?
Let's go to the next slide.
Because it's devastating to his case.
What are we looking at in this video?
Jim Carrey.
so here's
in
the
my head.
video showing that strike at 29 miles an hour with the center of mass impact to the dummy.
What's the import of this particular test? Why was this important, and what did you conclude following this
Wow, look at
impact
this.
test, the center mass impact test?
There's a couple of reasons. A, it shows there was extensive damage to the rear of that Lexus. So if you had a center of mass hit, you would have damage to the liftgate, to the fender, to the sheet metal. You would have substantially more damage than what we had in this case. And secondly, which I believe is just as important, it shows the post-impact trajectory of the dummy. So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side of the vehicle. So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the
Are you picking up what he's laying down? Whether he was hit by the corner of the taillight, whether he was hit at center mass, whether it was a clip, a glancing blow, no matter what they say happened, his body never would have ended up on the lawn. Case closed. Wait for us. We have the emoji, wait for us. That was from the season 1. David Yannetti said, wait for us in his opening, and he was masterful, and he's the Velvet Hammer, and I love King David, but I also love King Andrew. No matter which way you say he was hit by that car, his body never would have landed up where it landed up. And we really don't know where it landed up because nobody took any freaking measurements because the investigation was so piss poor. But what they do agree on is that somewhere his body was near the flagpole because that's where they took that leaf blower and blew away the layers of snow to find the clear cocktail glass and yet no pieces of red taillight. That was Canton PD. This highly qualified, educated man, wicked smart. No matter which way you cut it, his body never would have ended up there. Period. Full stop. Thank you. Good night, everybody. Listen to that again.
By the Lexus, the dummy. And it shows the post-impact trajectory of the dummy. So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side of the vehicle. So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the taillight material to be distributed straight back in the same center line as the vehicle is traveling?
Yes, absolutely.
Would you also expect the body to be struck and move in the same center line as the vehicle?
Sustained is too far.
Sure. What about the body? What directionality would you expect on a center mass hit?
The body's going to move in the direction that the vehicle is moving. That main direction, that main force, moving straight back, the body is going to move primarily straight back.
Did you reach an opinion or a conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John O'Keefe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please?
Anybody else?
And I could have just a moment, Your Honor.
Sure.
Anybody else have closing time playing in their head? Closing time. Every new beginning, some comes
On
from
what do you
some
base
other beginnings.
your opinion that you just told the jurors?
That looking at the kinematics of the arm, it's inconsistent with the evidence we have, with the actual abrasions to the arm, the evidence on the sweatshirt, and that at these speeds, you would likely expect fractures, certainly to the hand, and likely to the ulna and the radius and the forearm, if your hand or arm was struck by the rear of the SUV.
Yes.
Can we move to slide 48, please?
Yes. I'll allow it, baby girl.
What are we looking at in this slide?
Rentschler is
This was a study where they used an impactor and they contacted the dorsal or top part of cadaver hands. And they looked at the force that was
study.
exerted and they looked at how many fractures were produced as a result of that.
Did you review scientific literature regarding hand injuries under this sort of impact loading? Is this representative of that?
It is, yes.
Next slide, please. What is this?
So this shows the position, and this is taken directly from the aperture paint test. You can see the position that Dr. Welcher had his hand against the tailgate right at the time of impact. And you can see that corresponds, the contact areas correspond to the areas of the hand that were actually tested in this case.
Next slide, please. What is this showing?
So this shows the forces produced during the test as well as the forces produced during our testing. And maybe the next slide here actually better. If you look at the knuckles, which are the blue middle region, and then the metacarpal bones, which are the lower one. So for the metacarpal phalangeal joint, the knuckles, on average, it took 397 pounds of force to fracture that joint. Well, the 15-mile-an-hour test produced a minimum of 483 pounds. And more realistically, that's just with the hand weight. There's going to be more weight because it's attached to the wrist. More realistically, it's twice that, so it's around 900 pounds of force. But what these tests show is that the force produced on the hand, as represented by the PowerPoint from Aperture, even at 15 miles an hour and likely below that, you would expect to get fracture of the hand bones, of the knuckles, metacarpal interphalangeal joints, and the metacarpal bones if you contacted the rear of that vehicle at that speed.
Did you see any indication in the x-rays you saw or the medical records that you reviewed that Mr. O'Keefe's hand was damaged in such a way that you would expect?
There were no indications whatsoever of that, no, sir.
Nope.
Next slide, please.
How do you
What
like
are we looking at in this
now?
slide?
This was a test where they actually looked at the force on the elbow. So this is a direct longitudinal force against the elbow. Now, there's no indication of exactly, the paint test has the arm horizontal, but there's no indication, there's evidence of whether maybe it would be angled or if it's straight horizontal. But even if your arm's angled a little bit at the point of impact, the forces, again, on the right are what we determined from our testing, and those are minimum. Again, that's just with the forearm. If you include the entire arm, it's about twice that.
Oh.
So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that
And if
enough to break it?
that's enough. If you strike the elbow, that's more than enough to actually fracture the different bones of the elbow.
If an arm was hit at that speed with those forces, would you expect the x-rays to show no trauma, no broken bones, no fractures, no hairline fractures?
I would not expect that, no, sir.
Next slide, please.
I would not expect that. No, sir. Again, period, full stop, game over. But let's keep hammering it home. There were no fractures in his arm because all of a sudden, magically, the x-rays have appeared. He looked at the x-rays, no fractures. Dr. Laposada said no fractures to the arm or the hand. He is telling you, no matter what Judd Welcher says and all of the crazy experiments that he did, that hand would have fractured. The bones in your hand are very small, very thin. It doesn't take a lot of force to break the bones in your hand. And the arm would have likely been fractured. And the elbow. Hello? Hope some people are eating crow today.
What are we looking at in terms of this slide?
So these are just more articles that I referenced, and they look at impact force on the forearm, so the ulna and the radius. It takes, just to have a transverse blow right against the bone, it takes about 1,100 to 1,200 pounds of force to cause a fracture. We're at that level already at a 10-mile-an-hour impact.
What about a 24-mile-an-hour impact?
24, we're at 1,400 to 2,800
Yeah.
pounds of force.
Did you see any trauma on John O'Keefe's arm that was suggestive of an impact of that nature, of that size, of that force?
There was no trauma, there were no fractures, there wasn't even an indication on the arm of where it would have contacted the vehicle. So if there's fracture at the taillight, there's going to be a force at that point on the arm where it actually contacts the taillight and causes that, right? There's going to be a force riser to cause that damage.
Oh, yes.
There was no bruising, there was no lacerations, there was nothing at the alleged point of contact which would indicate an impact that produces thousands of pounds of force on the arm. No evidence of it whatsoever.
You just mentioned this in your answer, but I want to ask a little bit further. We've talked a lot about bone fractures and ligament damage, et cetera. What about bruising? In any of these tests, would you expect to see bruising, at least bruising, all over the arm at the points of contact?
Absolutely. Bruising occurs when the blood vessels just below the skin are ruptured, and it causes blood to flow into the arm.
Was there any indication that John O'Keefe suffered even a minimum amount of bruising on his arm at all?
No indication of any amount of bruising whatsoever on the forearm.
No bruising.
Next slide, please.
No bruising.
And let's go to the next slide. I think we want to jump to slide 50. What slide are we on?
John O'Keefe was not hit by a car, and a
This is
car did not hit John
55.
O'Keefe.
Let's go to the next slide. There we go. That's what I'm looking for. What are you looking at here?
So this again is from the paint test, and it shows, even as the arm gets pushed in, the vehicle's not in line with the center of mass with Dr. Welcher here. So it's not a center of mass impact. And this is important because we've just looked at the arm, and we've looked at the kinematics and the force and whether that's consistent with what happened and the injuries. The next step is to look at what happens if the arm gets hit. How does Mr. O'Keefe end up where he does in the yard? So that's post-impact movement or trajectory of the body. You have to evaluate that if you want to link all these events. If you want to link the head injury to contact with the car, you have to know what happened in between. You have to know the details. And so the next part was to evaluate that.
Is there any indication in any of the testing that you did or any of the review of the medical records medical records of John O'Keefe, including the autopsy records, all of the autopsy records, the x-rays, and the hospital records, any indication that John O'Keefe was struck center of mass?
None whatsoever.
None.
No indication at all that he was struck center of mass.
Do you have an opinion or conclusion to a reasonable degree of scientific certainty about whether he was struck center of mass?
I do.
And what is that opinion?
I don't believe that he was. The evidence indicates that he was not. If he was struck center of mass, imagine that. You're getting hit at the pelvis. You're getting hit on the
Thank
thigh. You're
you.
getting hit at the knee. And then the body's being propelled forward. Your arm would get pushed into your body, into your ribs, into your torso. You would have very significant and substantial loading to your body, initially the right side of your body, as that impact occurred. And there's no evidence whatsoever that occurred.
Thank you.
To a glancing blow, a blow of just the arm, not the center of mass, but just the arm. Do you hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only would propel Mr. O'Keefe 7, 8, or 10 feet perpendicular to the line of travel of the vehicle?
I do.
What is that opinion?
It would not be possible. Our testing demonstrates that. The peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or a sideswipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Not
Do you
possible.
hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please?
Not possible for him to land up where
And
he
let's go to
landed
the next slide.
with their glancing, clipping blow.
Let's keep going.
I
Okay. What are we
is-
looking
what
at
is
in
it
this slide?
across?
So this slide, it's a paper that describes how to evaluate vehicle pedestrian impacts and how someone moves in the projection of that body.
Did you seek to analyze a fulsome understanding of whether it was possible that Mr. O'Keefe was hit on his lower extremities?
I did, yes.
Why did you do that? Why was that important?
Well, because with automobile pedestrian impacts, the lower extremity, your legs, your ankles, your knees, that's the most injured part of the body during auto-ped impacts. So if he's going to be impacted at that speed, especially at center of mass, there's likely going to be injuries to his leg, to his knee. The bumper lines up with the knee. That's one of the most commonly injured parts, as the bumper pushes into the knee, fractures the tibia, the fibula, or damages the knee joint.
Bumper mark.
Did John O'Keefe suffer any injuries to his lower extremities suggestive of a vehicle impact?
No, I believe the only injury was a half-centimeter abrasion on the outside of the right knee.
Could Mr. O'Keefe have suffered a half centimeter abrasion on the outside of his right knee by being struck by an SUV at 24 miles an hour?
I don't believe so. I don't see how those kinematics would work.
Sustained.
He doesn't like science, Hank, but he loves articles.
Do you have an opinion as to whether or not that injury was from being struck by an SUV at 24 miles an hour or somewhere around 24 miles an hour?
I do.
What is that opinion?
I do not believe that injury is consistent with being struck by an SUV at approximately 24 miles an hour.
No,
Do you
not the
hold
knee
that
injury
opinion
either.
to a reasonable degree of scientific certainty?
I do, yes.
No, knee injury
Did Mr.
wasn't caused by
O'Keefe
the
suffer
car either.
any other injuries to his legs or his lower extremities other than that small, how big was it? How many centimeters?
Half-centimeter abrasion.
That small half centimeter abrasion. Did he suffer any other injuries to his lower extremities indicative of being struck by a vehicle?
I don't believe so, no.
Let's go to the next slide. Taking a look at the photograph on the right, concentrating on that for a second. How did that SUV get in that condition?
That was by striking the dummy at 29 miles an hour, and that was a center of mass hit with the dummy.
Were you able to review photographs of the subject SUV, Ms. Reed's SUV?
I was, yes.
Did her SUV suffer or suggest any kind of damage anywhere close to this?
No, the only real damage was to the outer taillight cover on the fender itself was fractured.
Next slide, please. We've seen this. This is the video that was the center mass impact.
That's correct, yes.
The photograph that we just saw previous, what relationship does that photograph have to this field test?
That was the condition of the SUV after it struck the dummy here at 29 miles an hour.
Can we go to the next slide, please?
Don't try that at home, kids. That's a stunt
What are we
driver.
looking at in this series of diagrams?
So this is some more recent testing that was done, and this test compared impacts between a small sedan and an SUV, and show it's looking at damage or injury to the legs as a result of this type of an impact. And these impacts are actually conducted at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadavers and struck them at just about 24 miles per hour.
I was today years old when I realized that you could donate your body to science to be used as a crash test dummy. There's a study for this. It was at 24.7 miles an hour. 6 post-mortem human surrogates were used. They were tested in full scale with vehicle pedestrian impacts with a small sedan and a large SUV at an impact of 24.7 miles an hour, which is interesting because 24.2 miles an hour was what the Commonwealth said he was hit at the first trial, right? Listen to this again.
At all the sedan and compared, this is some more recent testing that was done, and this test
Jim Clark.
compared impacts between a small sedan and an SUV. And show it's looking at damage or injury to the legs as a result of this type of an impact. And these impacts are actually conducted at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadavers and struck them at just about 24 miles per hour.
Did this support your opinion and conclusion concerning the lower extremities of Mr. O'Keefe and the possibility that he was hit by an SUV at speed?
It does. If I can go to the next slide, it actually.
Sure.
So this shows you for the SUV, it's the last column on the page there, the last three columns are the injuries associated with the SUV strikes. There's fractures to the pelvis, left knee injury to the ACL, the MCL, fracture of the tibia and fibula. There's extensive damage to the legs of all three of the cadaver subjects that were struck at 24 miles an hour with an SUV.
Did Mr. O'Keefe show any signs of any of these injuries?
He did not, no.
Next slide, please. Is this, what are these photographs and diagrams on the
Killing me,
right?
Smalls.
So
You're killing me.
this was taken from the PowerPoint from Aperture. And so it shows that the medical diagram shows the 1.5 centimeter abrasion. And if you look at the picture on the left of the surrogate, you can see, so the bumper would line up from the knee all the way up to the pelvis. So a vehicle at speed of 24 miles an hour, if it impacts that knee or that leg, it's not going to produce only a 0.5 centimeter abrasion. It's going to get the leg, and it's going to cause significant damage to the knee and to the leg itself.
When you say from the knee to the pelvis, are you talking about the width of or the height of the bumper itself being from the knee to the pelvis?
I am, yes.
Would that be the contact area that you would expect if there was even a glancing blow to the knee and the hip?
That's correct. You can see on that picture there where that bumper, the rear corner of that bumper, where the bottom reflector is, it extends from the knee all the way up to the pelvis.
Can we go to the next slide, please? What are these diagrams?
Again, these are just reports, peer-reviewed articles demonstrating that auto pedestrian impacts result in lower extremity injuries and fractures.
Did you review all of these peer-reviewed articles that you've told the jurors about, the academic articles, in furtherance of coming to your opinions and conclusions?
I did, yes.
Did you see any reference in the Aperture report that you reviewed and the PowerPoint slides that you reviewed that the concomitant peer-reviewed articles were sought in the paint transfer test
No.
or cited?
There was only one article that was cited in that report with respect to automobile pedestrian impacts.
Did it have anything to do with the paint transfer test?
It did not, no.
Next slide, please. And let's keep moving until we get to the, yes, there we go. What does that slide depict?
So this is the opinions that were offered in the Aperture report. And if you look at the top, number 4, it says the totality of the evidence is consistent with the right rear corner of the Reed Lexus, again, impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground.
I'm going to freeze frame this in case you want to come back and screenshot it for yourself so you can read the report of Welcher
And when
later.
you look below that, it basically has the references or the support for that one conclusion.
At least this page anyway.
I'll see you both at sidebar for a minute.
I mean, these are the conclusions that Welcher cites in his report. He says the totality of the evidence is consistent with the right rear corner of the Reed 2023 Lexus LX570 impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. And this is what he considered. This is Welcher. Cell phone data, physical evidence around the body, taillight from the Lexus bar glass, cell phone location under body, blood only at point of rest, arm, forearm laceration, 3 above, citing his slides, air temperature and frozen ground, hat line and fracture location consistent with fall and posterior head strike, fall versus assault, head most commonly injured body region in pedestrian impacts. That was a study from like 50 years ago that Welcher cited. And there's been a more recent one that says the head is not the most commonly injured body part in a pedestrian accident. It's actually the lower extremities. The range of occipital bone fracture force has been reported to be between 1150 and 21. And you can come back to this later. Mr. O'Keefe is 6 feet, 1 inch tall. The location of the laceration on the back of his head is approximately 4 inches down from, and then it's blocked by the chyron. And then it says drop test conducted by me with a hybrid 3 falling backwards, measured G's of approximately something. Remember, he hugged it out. He hugged it out with the crash test dummy. Welcher did before he did the drop test on poor Randy. Talking about Randy now. And then here is the rest of the conclusions that you can read later. And now they're at sidebar, arguing about something else. See who's in the courtroom today. There's Matt Johnson from Court TV, some other people, Sue O'Connell. If you are on the cesspool of Twitter, Sue O'Connell has some really good tweets during the day about your reactions.
Okay. 70, Mr. Jackson?
I have just a moment, Your Honor.
70, Mr. Jackson?
That's what we're, I was just.
She said, could I have,
I wish my eyes were better.
said, could I have a moment to get my glasses?
Nope.
Thank you. Okay, what are we looking at in slide, this is slide 7, yes. What are we looking at in slide 70, Dr. Rentschler?
So this was the one article that was referenced in the Aperture report with respect to automobile pedestrian impacts. And there was a chart from there that was referenced in the PowerPoint that indicates the head's the most commonly injured body region in pedestrian impacts.
And what significance did that reference have in your analysis?
Well, that's not accurate. This article was written in 1979. And the first modern SUV, the Jeep Cherokee, wasn't manufactured until 1984. So this is an article that's 46 years old that doesn't actually relate to this type of an impact. And that's the only peer-reviewed reference with respect to automobile pedestrian impacts that was cited in the entire Aperture report.
Can we move to slide 71? Do you recognize what's depicted in this slide?
I do, yes.
What is depicted here?
So this was the hybrid. This is the 50th percentile hybrid 3, the same dummy that we utilized. And Dr. Welcher performed a test where
Can I interrupt you?
Sure.
So this ATD, anthropomorphic test device, was not a 95th percentile test device?
It was not, no.
Is it 50%?
It was a 50th percentile, yes.
Is that the same exact, not the same exact, same exact sized ATD that ARCA utilized in all of its testing?
It was, yes.
Okay.
And to get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay. Go ahead.
So this test, what he did, he took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Next slide, please. By the way, Dr. Rentschler, did the last slide include a video?
I believe.
Can you hear me now? Can you hear me now? I can't be on mute for my whole stream because somebody must be streaming me. They need to mute the Zoom room in Turtle Boy's trial. Aiden Carney's Zoom room needs to be put on mute for all the people watching. It's good, Will? For those of you who have two devices and you are no, not can you hear me here? Can you hear me on Turtle Boy's Zoom? On Aiden Carney's Zoom?
And then let it drop backwards and strike its head on a concrete surface.
Next slide, please. By the way, Dr. Rentschler, did the last slide include a video?
I believe it did, yes.
Can we go back?
Or I'm not sure it's on this slide, though. That's just a screenshot.
I see. I
Yeah.
see.
Yeah.
Okay, so let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion of the center of the screen, you see Dr. Welcher holding the ATD. Is that correct?
That's correct.
Did you review a video of what happened next? This is not the video, but did you?
Born a Hawkeye, I don't want who to stream because it takes away from my views. I don't think you're picking up what I'm laying down here. Somebody is streaming Aiden Carney's trial on another channel. Somebody in the Zoom room for Aiden Carney's trial was also streaming me on another device of theirs, and my voice was going into the Zoom room on Aiden Carney's trial. I don't care who streams what. It's not a competition. Not a competition. The Glare is streaming Turtle Boy's trial. If you want to go watch it, go watch it. That's not the point. The point is that my voice was coming through the Zoom room in another case. And I think now it's fixed. I think it's fixed now. Will says it's fixed. My God, man. Listen to this, for crying out loud. I can't shout out Billy Tibbetts. He's not a good guy, apparently. Yeah, maybe it's Grant Smith. Oh, for the love of the traveling Mary. See? Everyone smash the like button for me because this is not easy. Andrew Burkhart was apparently playing in the Zoom room also. It's not my fault, John Monagle, but I don't want to interrupt. I don't want to disrupt his trial. And I don't want to have to be muted on my own stream because of people playing my stream in his. Do you hear what I'm saying? I don't think anybody's picking, a couple of people picking up what I'm laying down, but whatever. Here we go. I don't have the Zoom on my screen, so that it's not me. Okay, it's better now. Thank you, Lottie's mom. Thank you. That's all it takes. I think Albert did it. Oh, duh. Thank you.
For the size of an ATD?
Yesterday, you scale
Well, here he's hugging
the
it out.
acceleration results.
Well, I mean, now we have to, I'm glad we have to rewind because look, he's hugging it out with the crash test dummy. Okay. Here's Welcher hugging it out with Randy before he drops him on his head. He's a flat lever. He's a flat lever. Here we go.
To get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay. Go ahead.
So this test, what he did, he took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Next slide, please. By the way, Dr. Rentschler, did the last slide include a video?
I believe it did, yes.
Can we go back?
Or I'm not sure it's on this slide, though. That's just a screenshot.
I see. I
Yeah.
see.
Yeah.
Okay, so let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion of the center of the screen, you see Dr. Welcher holding the ATD. Is that correct?
That's correct.
Did you review a video of what happened next. This is not the video, but did you review the video?
I did, yes.
Describe for the jurors, since we don't have access to the video, what did you see happen from this point forward?
So Dr. Welcher releases the dummy, and the dummy just falls rigidly backwards, almost like a tree, and impacts the concrete.
Can we jump from your PowerPoint to a video that I have and ask you if you recognize it with court
Welcher
permission?
video.
Is the video in evidence?
Strange things
It's in
happen.
it's in Dr.
Strange
Welcher's
things
PowerPoint.
happen when while on a mission from God.
Before the jury, is it in?
Yeah,
It is.
Randall.
Okay.
We're doing the Lord's work here, and it's not easy. Oh, we have room to scooch. Good, because we had to stop.
Yes.
Is-
Interrupt the whole class.
Okay. Do you recognize this?
I do, yes.
Is this just look like the same screen, basically same thing that you just took a screenshot of?
It is, yes, sir.
Okay. If we could play the first couple of seconds of the video and pause it. As that video began to play, did you recognize this as being the same video that you reviewed earlier?
I mean, he's playing grab ass with Randy. I'm not going to lie. Take a look. Tell me what you think. Is this like the grab ass we saw between Higgins and Albert in the waterfall? There's a little grab ass going on here. I'm just saying.
It is, yes, sir.
And did you utilize this in coming to your opinions?
I did, yes.
Opinions and conclusions in this case?
I did, yes.
Thank you. Let's go ahead with the court's permission. Can we play the video? Thank you. What did you see? Describe what you saw in this video.
So this is a passive rearward fall of the ATD dummy. So just releasing and let it fall. Obviously, it's a dummy. There's no musculature. There's no response to that dummy. So this is what would happen if a rigid individual just fell backwards onto a concrete surface.
Can we see it one more time, please? I want to ask you one other question.
Please let us see this one more time.
I'm going to ask you to take note, Doctor, of the impact location.
Well, that's not
See
Randy.
that?
I did, yes.
What kind of surface is that floor, if you can tell?
That, I believe it indicates it's a concrete surface, concrete floor.
He's
Did you
playing
notice
grab ass
if
with
the
it.
falling backward like that, the dummy slid across the floor or was propelled across the floor, anything like that?
It did not. It just dropped and angled backwards and hit directly on the floor.
Okay, let's go to the next slide. I'm sorry, if we could revert back to your PowerPoint.
Why does this dummy have a name? It's the
And if you could
thrust.
pull up slide, I think it's 72.
Let me, every time we do that, I have to restart.
Looks like Dr. Welcher took Randy to the
Howard,
prom and it's their
thanks.
first slow dance. Randy is,
Okay.
it's not Randy. Randy was the ARCA dummy.
Why did you
remember?
include this video one more time in your PowerPoint here?
Because, again, this is the pain test, which indicates the position, at least that Dr. Welcher had himself at to get the impact with the taillight cover. And notice, again, so it's not a center of mass hit. It hits his arm and then he slides by. So if that were to occur, he would rotate or move to the left. So if Mr. O'Keefe did that and somehow ends up falling backwards, rigid directly onto his head, he's going to have to rotate at least 270 degrees and then stop and then fall directly backwards onto his head. There's no explanation of the kinematics.
Sustained us to the end of that. I'll
Vindication for Trooper Paul, because Trooper Paul may have been right about that pirouette. And I am saying that, Trooper Paul, we hereby vindicate you. You may have been correct about a potential pirouette. And Lord, you're doing the Lord's work. You were trying to reverse engineer this thing, and you did a better job than the $400,000 job that Aperture did. Trooper Paul, you gave us some amazing. Oh yeah, Paul O'Keefe is over there streaming me in the courtroom. That's why Paul O'Keefe is gone, because he has to go testify, I think, in Aiden Carney's trial right now. Vindication for Trooper Paul. He's the only guy sitting at home, like, eating popcorn, like, I told you guys, I told you it was a pirouette.
strike the end.
Do the kinematics support what you just suggested?
He didn't even know what kinematics was.
What do the kinematics support?
Objection.
I'm going to see you at sidebar for just a minute.
Of course you are.
Jurors will be taking our break.
Oh, you're taking the break? Okay, good, because we're a little bit behind. You are vindicated, sir. Trooper Paul, I hereby vindicate you. You didn't know what kinematics was, sir, but you did know that there could potentially have been a pirouette in order for the ridiculous theory that they gave you to work out at 24.2 miles an hour. He did some kind of experiment. I don't know what Trooper Paul did, because he didn't know calculations and stuff. He didn't really have anything other than a couple of courses. I don't even know if he had a college degree. No shade, Trooper Paul. You did the best job you could with the garbage that they gave you. And therefore, today, we honor you, Trooper Paul, for all of the comedy you gave us. Weekend at Bernie's with the crash dummy. That's what okay. Motion to call the crash dummy Bernie. Let's call him Bernie. So we got Randy and Bernie. Done.
May I continue?
Yes.
Thank you. Dr. Welcher, based on your review of everything...
Rentschler.
Did I do that again?
Oh my God, he called him Welcher again. That's
This is Dr. Welcher in the video, correct?
Correct.
All right. I was staring at that. I apologize. Dr. Rentschler, based on your review of the video in which Dr. Welcher is positioned, as well as the drop test that you saw, as well as the discussion of being of the body placement, where you discussed the body placement, do you have an opinion as to whether or not the testing that you reviewed from Aperture is consistent or inconsistent with John O'Keefe being struck by the vehicle, propelled perpendicular, backward, say 7 to 10 feet, and falling straight back onto a hard surface as depicted in the drop test?
The testing's inconsistent with those types of kinematics or that type of scenario.
couldn't happen.
On what do you base that opinion, sir?
That's based on the testing that was performed, the evidence available in this case, and the kinematics of how somebody would move post-impact after being struck by an SUV.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Can we go to the next slide, please? May I have just a moment, Your Honor?
Yes.
Room to scooch. Trooper Paul may have an associate's degree. Okay. Good. He's just as qualified then as Shannon with 1N Burgess, apparently.
Finally, Dr. Rentschler, do you have an opinion, or did you reach a conclusion, whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto
And
the
do you
back
hold
of his
that
head.
opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Your Honor.
Okay. So now we'll take our break, folks. We'll see you in about 20 minutes.
Please rise for the jury. Jurors ready to display.
Well done. Mic drop testimony.
You are muted.
See, that's what's supposed to happen in Aiden Carney's courtroom. They're supposed to mute everyone on the Zoom, and some person was playing my stream really loudly, and it was going into the courtroom there. And I was yelled at to turn off my stream of the Zoom on Aiden Carney's trial. And how could I be streaming that when I'm streaming this with you? Let's see how far we are behind. Hold on. Let's scooch about maybe 5 minutes. Randy saved the day. Well, that wasn't Randy. That was Bernie. We renamed him Bernie, right? All right. Let's go to some questions. Trooper Paul said John ended up 30 feet away. That is correct. That is correct. The jury is not dummies. The jury is not dummies, are they? This is a great question, Kimberly. Honestly think that Hank tried to hire Dr. Lapsada for this case. And she said, no, he was not hit by a car. Thoughts? My thoughts are that if he did consult with her and tried to hire her for this case, she would, in my opinion, she would have a conflict and she would not have been able to be hired by Karen's team. Sort of like when people get a divorce or high net worth people, let's say, get a divorce. They tell one of the spouses to go visit every single high-powered lawyer in town and just consult with them and pay them an hourly fee for a consult so that their spouse can't hire them. Kind of like that. So yeah, I don't think so. But we do know that Hank hired Dr. Laposada in the past. And oh boy, do I have a great paralegal who sent me a transcript of Hank Brennan, a transcript of Dr. Laposada in a different trial, I believe. Hang on, I don't need to show it to you right now, but that Hank Brennan asked Dr. Laposada almost word for word the questions from said transcript in a case called Commonwealth v. Tompkins, which was a Northampton case back in 2022. And it was the same prosecutor that prosecuted Brian Camp, Steve Gagney. Interesting fun fact about the questioning of Dr. Laposada may have been pulled directly from a transcript. Are you surprised? I'm not. Not surprised at all. That's the case he quoted. Yep. And he had the transcript, and he I think he might have used it word for word. We'll see. We'll check it out. Haven't had a chance to read it yet, but I have an amazing paralegal. Jayla, what are the odds defense asks Welcher if he knows he wasn't given the x-rays? I think the jury should know this. Love you too. I love you too. Court's on a break for a couple minutes. We'll take this down. I don't know if he's going to be allowed to be asked that with this judge. We don't know what's happening at sidebar, but I think he absolutely should, because he said in his direct testimony or on the case in chief that he said he saw no x-rays, and I wonder if he's been given them now. Sidebar chick. The Shakespeare quote, though she be but little, she is fierce, suits Dr. Laposada's testimony yesterday. She's a boss. This is very Shakespearean in nature, isn't it? Everything about this is Shakespearean. I have sometimes called Judge Cannoni Lady Macbeth, because we are watching a Shakespearean tragedy unfold in real time for the second time. And I wonder what the ending is going to be this time. Paul Munz says it's amazing to see inspirational women like Dr. Russell and Dr. L saving Karen while effortlessly destroying Hank with poise and elegance. Women versus boys. M. Majel says, sun finally came out today in Massachusetts. It's heading into the 80s after a couple of miserable weeks of rain and cold. I mean, we've all had it. We've all had it on the eastern seaboard here. Feels very symbolic after Dr. L's exculpatory testimony yesterday. Yes, sunlight is the best disinfectant, isn't it? I think Karen Reed said that in one of her interviews, or maybe after court. Deleted comment queen says the Guzma coma score is what Bev and Hank will have after a few tubs of Ben and Jerry's in Chambers after today's over. It's Glasgow, or Glasgay if you're Scottish, or I don't know what that GAE, but we'll allow it. Love you. Well, here in the US, they say Glasgow coma score. So I understand that it may be pronounced differently in Scotland. Glasgow, that's the town. But I'm going to go with doctor. And it also depends on who teaches you in law school. I had a professor who called it a Daubert hearing because it's French. A lot of people say Daubert hearing. So it depends on who teaches you. But either way, thank you for your super chat. It's very kind. Proud mama of two. Thanks for being here during this traumatic time. Did anyone rule out John tripping over the wooden pallet under the flagpole shown on Google Maps? We have no idea when the Google Maps image was taken. I don't trust that stuff. And no, nobody ever brought that up. But good on you for going to Google Maps. People have said that the house is blurred out on Google Maps. I don't blame them. I'm sure the new owners can do that. You can have that done, by the way. You can have your house blurred out on Google Maps. It is a thing. And they will do it for you. And I suggest to many of you that you might want to do that. It's a very smart thing to do. Pro tip, very smart thing to do. Wearmouth. Before a defense witness gives testimony, I get a knot in my stomach as I just know Bev and Hank will try their utmost to interrupt, object, make comments from the bench to try and stop the flow of the witness. It's going to be interesting. Welch says not guilty would be a great Father's Day present for Mr. Reed. We were here last season on Father's Day, and some people made Father's Day t-shirts for Mr. Reed, and it was lovely. To all the boots on the ground out there doing the Lord's work, supporting Karen outside the courthouse, cheers to you guys. Today's so far a really good day. Really good day. Tons of fun 911. Watching the defense team have to fight with an arm or sometimes two tied behind their back has been so emotionally draining. I know it is. Can't imagine how lawyers like you feel witnessing this. Oh, it is hard, especially if you're an empath. It's very hard. Grateful for you and your coverage. Thank you. I'm grateful for you guys just as much as you're grateful for me. Thank you, Fairy Raven, for gifting a membership. She's here from Ireland always. She's amazing. Bat Mama, thank you for your super generous $50 super chat. My dream show, the two best women on YouTube, you and Samantha Benigno from I Don't Belong Here. My day, your wicked smart knowledge and humor. Her night, her unique behavioral analysis of the evil players in this horror show. I guess thanks for shouting her out. I've never watched any of her content. I'm not quite sure who she is, but thank you for your 50. I appreciate you so much. I'll check it out. JJ from the UK is so happy to find the group. Thank you so very much. Fairy Raven says, I was so excited to see Dr. Rentschler today and Sweet Baby Jesus, he hasn't disappointed. Nope. R&M says, I'm an hour behind. Sorry, but it's not Stockholm syndrome. I checked with Brennan. It's Susma syndrome or Guzma syndrome. Free Karen Reed. Well done. Aussie Steve is here. I'm down under. At this point, after Rentschler's evidence, Welcher is in the fetal position lying next to Randy. Thank God for experts. Free Karen Reed. Case closed. At this point, Welcher should just stay home. Like, what do they need him for? What do you think? Do you think they need Welcher? I don't know what he's going to be able to say. It might just make him look even more ridiculous. Thank God he sold his company to Aperture for $270 million. I don't know how much of that money he got to keep if he had other investors that he had to pay back. I don't really know. But thank God he did, because I can't imagine that Aperture is going to be rolling in business after this trial is over. Maureen says, Dr. Rentschler to Welcher, here's your participation badge. Take your grade school finger paint and choreography and leave the biomechanical testing to the adults. Well done. Rebel says, whoever that is, Jim, with the coughing and sneezing is loud. I think they need some over-the-counter meds to help with the courtroom cough. I was going to DoorDash him some cough drops. Some cough drops, the most disgusting kind that I could find. Fisherman's Friend is pretty gross. And I hate black licorice, but I don't know. Call me crazy. But it seems like Jim's coughs seem to come at times that are good, about, around the time that some good testimony is going to happen for the defense. I don't know. Could be a juror. Somebody said a juror was sick earlier in the trial, but Jim, we saw what you did with the bingo balls during season 1, and I don't think it's going to fly this time, Jim. Because we saw how Margaret did it at the Turk trial. She showed everybody the bingo balls representing each juror, laid them all out on the table for all to see, put them all into the drum, rolled the drum, and as she pulled out the alternates, she held the bingo balls up for the world to see. That's not what you did, Jim. We know we did a side-by-side comparison during the Turk trial. I know Fisherman's Friend is good for you, and it has zinc, but I don't think they taste very good. But they're supposed to be very good. Look, no shade to the brand. They don't sponsor me. I'm not sponsored by a different brand. Brennan, not sorry, not sorry, Esquire. This witness is a true expert. The truth has been revealed no matter what excuses Crybaby Brennan has. Case should have been dismissed long ago. The case never should have been brought. This case never should have been brought. Prosecutors across the country, ethical ones, have said, I never would have prosecuted this case. Thank you, Kathleen, for your super sticker. What should look like a hit and run motor vehicle accident is clearly not that. A car did not hit John O'Keefe. John O'Keefe was not hit by a car. And finally, the world is seeing it. Well, it's your shadow days, John Mayer. Your shadow days are over, Karen. Nothing but the best for you. I love John Mayer. You know I do. You had me at John Mayer. Chloe Albert's Revenge says, correction, Trooper Paul has an associate's degree and stuff. Do not defame him. I'm sorry. I wasn't defaming him. I was vindicating him. Yes, agreed, Lee. It's really sad that it took an expert to explain the obvious to the corrupt court. And here's the difference between Season 1 and season 2. Let me take a drink because I'm parched and the vocal fry's killing me. Season 1, pre-production. Defense attorneys were not allowed to speak to Dr. Wolf and Dr. Rentschler. Somebody made a motion to call Dr. Wolf Crash Daddy, and we're going to call Dr. Rentschler Smash Daddy. If you have any other nicknames for Dr. Rentschler, I will consider them. Hot mics in the courtroom? Defense attorneys were not allowed to speak to them. They were not allowed to prep them. All they had was the report because they were still under contract with the feds. This is the difference in the testimony when you are allowed to hire the experts yourself and prep them and ask them to conduct additional experiments. Because Karen didn't have $400,000 to hire someone like Aperture. It is sad. Very sad. Dr. Russell parachuted into this case, as Hank Brennan likes to say. She's the one who saw something about it in the Boston Globe because she had a free subscription, and she called a DA in LA and said, "Hey, I may be able to help. I see there's some question about dog bites. How can I help?" That DA put her in touch with Alan Jackson. The rest is history. And she's been nothing but, well, we glorify Dr. Russell here. I call her the matron saint of the Karen retrial, but she has been destroyed on the internet. Not that she cares, because she probably doesn't care. Paul said, Nikki says, "Thank you for letting me be myself." Oh, I don't know who Nikki is, but maybe that's your lady. Maybe that's your lady, Paul. Be yourself. Jenna, can you explain a proffer? It's all over TikTok about Higgy doing this. All over TikTok like today, Jenna? Well, here's how that works. So Brian Higgins, there had been rumblings before season 1 that Brian Higgins had gone into the feds and made a deal. So a proffer is kind of like a deal. It's like, let me show you what I can give you. And if you like it, can you give me something in exchange, like immunity from prosecution if I tell you what really happened? Something like that, right? This is a broad overview of what a proffer is. Brian Higgins is also a federal agent, ATF agent. I don't know if he's on desk duty. I don't know what his deal is. Kind of like a plea deal, kind of. But it's like, if the feds think that what you have is valuable enough, they may offer you something like immunity. Mark, I mean, that's a good way to put it, right? And so we don't really know if he ever did enter into a federal proffer before season 1, because when he came into court to testify, his lawyer was with him during season 1. And now we have also learned during season 2 that when he went to meet with the prosecution team, and I don't remember now if it was Lally or Brennan, that he had the meeting at his lawyer's office, right? In his lawyer's house. Am I conflating again? So he was lawyered up right away. He made the word on the street, or the T, was that perhaps he made a federal proffer, but we don't know if it's true. So I don't know what TikTok is doing today, because although I have it, I don't get a chance to go on there very much because it would just suck the entire life out of the rest of my day. It was Yuri who testified about that. Oh, so it was Yuri. Thank you, because I knew it got in somewhere, Jams. Okay, so Yuri went to interview Higgins at Higgins' lawyer's office. And was that when he brought in all the text messages that his friend Matt Kelch from the FBI showed him how to use the kiosk in the FBI lobby to extract the text messages from his phone? Aha. Okay. Lori points out that Sue O'Connell tweeting from the courtroom that as Rentschler offers his opinion, there's a dog incessantly barking outside. That's great. Okay, so it's been a rumor that's been out there for a long time. We don't know if it's true or not, because look, the feds don't tell us what they're doing. And how would that even get out? And we don't really know. What I can surmise for you is that the feds are watching this very carefully and very closely, and that maybe someday, somehow, there will be justice for John O'Keefe. But convicting Karen Reed is not justice for John O'Keefe because John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. Moira Leslie says, I won't tell you why I didn't hire her again. That is what you're right. That's what Brennan said about Dr. Lopesada. I hired her a couple times, but I'm not going to tell you why I didn't hire her again. I figure it's because she can see right through me. And there's got to be a song in there somewhere. Oh, it's in there. It's Alanis Morissette, another queen of the angry women. Alanis Morissette, part of the soundtrack of my life. Not that I'm an angry woman, but sometimes. Karen Reed said after court one day, when a reporter asked her, how do you feel about Paul O'Keefe staring you down every single day? She said, I see right through him. And that was the day that Alanis Morissette, that particular song went onto the playlist. So thank you for that. Canton is the Twilight Zone says, my granddaughter, 11 years old, can see Karen Reed is innocent and said, how can she go to jail with no proof and so many lies? We're in the Twilight Zone. Is that on the playlist? Yes, the Golden Earring version. I think more than one version of a Twilight Zone song is on there, but your 11-year-old granddaughter is wicked smart. Keep up the good work, Grandma. Sam Jackson says, the interesting thing, 34 Fairview Road and Brennan's office are blurred out on Google Maps. One Meadows is not. Why is that? Also, thanks for all your coverage on this, because you have to go to Google Maps and request it to be done. And so Brennan probably did that, or someone in his office did that so that nobody would go to his office and they wouldn't know what building they were looking for. And 34 Fairview owners didn't know they were buying a murder house. They're not happy about all the drive-bys that happen. And so they did that too. And it's a smart thing to do. Janelle was listening to the trial and my 10-year-old said Karen hit John's arm with her car and it didn't break. Not guilty, case closed. See, you have a wicked smart kid too. I don't know about this, Elle, because somebody found some documents. Aperture didn't buy Welcher's company for 270 mil. Aperture merged with Welcher's company. There was not a sale for 270 mil. I don't know that that's true, because there were I found some publications and some business as such publications that said that there was a sale. So I'm going to have to go back and find them. But why would he do that? He even said that I thought he even said that it was bought. Why would he become someone's employee? It doesn't make any sense to me unless there was something financial in it for him. But thanks for your super chat. Alicia, I have a daydream. The feds swoop in after the not guilty jury verdict that eliminates Karen Reed as a factor in trying the conspirators. A girl can dream, can't she? I say she can. Let's go to some more questions here while we wait for the morning break to be over. Thank you, Nurse Jones, who says if chest compressions were in progress, then the wound could bleed. That goes to yesterday's testimony about whether he was alive. Thank you, Deanna, for your coffee donation. Christina, what about frostbite? If he was laying in the snow for that many hours, wouldn't he have frostbite on his fingers, ears, anything? Yes. Yes, and that is what Dr. Lopesada said yesterday. There was no frostbite. There was no frostbite, and he did not die from hypothermia. Kelly, Hank was the defense attorney for Nancy Kerrigan's brother. Oh, that's interesting. What was he charged with? And hired Lopesado in 2010 or 2011. That's interesting, T. Kelly. Thank you. Thanks, Judy, for your Venmo. Thank you, Deanna, for your gift card. I appreciate that very much. Carla, free Karen Reed. Thank you for loving my coverage. Thanks, Steve. Julie says, thanks for your insight. Thank you. People are getting kicked out of YouTube left and right and kicked into other people's streams. I'm appearing on Zoom. At least my voice is anyway. In Aiden Carney's Zoom room. Crazy stuff's going on here. Thank you, Lisa. Says, let's go. Dennis says, I sing your intro day. Happy day 31. They're back. Comic relief. Thank you, Kathy. Stephanie, very generous. Cannot get over the outrageous lies and pure gaslighting. What a cluster F. Love you with all of my heart, too. Thank you, Stephanie. You're very generous to me. Thanks, Betsy. Says, love your shirt. Keep on keeping on.
This court is in session. Please be seated.
All right, Mr. Brennan?
Thank you.
Oh, boy. Here we go. Buckle up, buttercups.
Dr. Rentschler, facts matter, don't they?
They do, yes, sir.
You said it many, many times. Facts matter. Isn't that correct?
It was details, but facts matter too.
Do details matter, doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you
Yeah.
think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask.
Yo, mofo, he didn't come to play. He didn't come to play your little games. Spanky Danky. I don't even know what to call him anymore at this point, Pee Wee Herman. Fresh hell. The reason people hate lawyers. He didn't come to play. Nobody knows. You don't know either. And I think he at one point said 8 feet. Here we go. We're gonna roll that back. We're gonna roll tape back to 1, and we're gonna hear it again.
Impact was in this collision.
total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So
Excuse
go ahead
me.
and ask the
You-
question.
Dr. Rentschler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Play exhibit 2, please.
There's no evidence.
When you
Nobody
were giving
does.
your estimate 10 to 20 feet, Dr. Rentschler. Did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen
If you're not looking at your screen, this is very blurry dash cam video that is time-stamped 6:09 a.m. from January 29th of 2022. Have you seen this video from Canton PD? We need a support. This is a support group. We have a support group here. This is it. Emotional support group. Here we go.
this before.
Yes.
And when you look at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure. Yes.
Sure?
Yes.
20 feet, Dr. Rentschler?
Can't see the bottom.
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do. Yes,
You
sir.
take that down, please. Did you speak to anybody today before you testified about Dr. Welch's testimony in court?
I did not today. No, sir.
Before today, did you speak to anybody about Dr. Welch's testimony?
I did not. No, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so. No, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did. Yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all. No, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue. No, sir.
Well, you know that the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight from Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration, but the acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio of force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
You want to bring the FBI up, Hank? Go ahead. Go ahead. Throw the dynamite into the cage. Let's go. Let's go. FBI hired them. You want to go there? Go.
You testified under oath last year. You were getting updates from your employer about details of this case, weren't you?
Objection, Your Honor.
Maybe we can
Yeah.
approach briefly.
Because if he wants to open up the door to the FBI, let him open up the door to the FBI. You can't use it as a shield and a sword and say, we don't want the FBI to be mentioned, but now we're going to inquire about the FBI, which is who hired them. Thank you, Norman. You got to kick the door in sometimes. Go ahead. We were hired by the FBI, who is investigating this sham of a prosecution and maybe some other things in this county. And they told us what to do. And they told us what some of the so-called experts for the Commonwealth testified about before trial 1. And we came here not having been prepared by the defense team at all. Tara says, regarding the juror not taking notes, my brilliant adult son is dyslexic and dysgraphic and rarely takes notes. That could be as well. The juror who doesn't take any notes may have a photographic memory. He may just think this whole thing is a sham, and he may just be like, I don't need to hear any of it. I've heard enough. I've stopped taking notes too, and I have at least 7 or 8 pads full on this trial. But I don't need any more notes at this point because nothing else matters. There's a song in there too. Nothing else matters. Thanks, Elle. The $270 million value is the total amount of capital the attorney has. Well, the company was a consulting firm. The only value is him. Love you. Thanks for the stream. Awesome. He didn't get paid any money? That's a rumor? Thank you. I figured he's so rich he just doesn't care that he ruined his career on the stand here. Like, he doesn't care because he's got a lot of money.
Before you testified last year, you were receiving information not from the defense, from your employer, about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Any more questions? Krish Daddy Andy is a pro. He's a pro. Flip your papers all you want, Hank. Maybe help from the Beatles should be on the playlist.
Voir dire 2, 118, line 15.
Voir dire 2. Pull out your transcripts.
Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all, no. It doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare?
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question, and I want you to give me a very specific answer.
So just go ahead and ask.
Badgering again.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter, so let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? Are you denying it?
Yes, he's denying it.
I'm going to allow it.
Yeah, I don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question. Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
I'm going to allow that.
I don't even think that it did. I don't understand that. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
Allegedly, I love it.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
This is all he's got.
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualifications, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mm-hmm. Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
So you don't believe?
Yeah, there was no need to.
That's not the question. Details matter. Was there any attempt?
So the objection's sustained. I'm going to strike that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations
to portray yourself as independent, as far as your arrangements were concerned in coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
Did you have a conversation about that you were thinking
Are we forgetting that Tully picked up one of his witnesses and drove him from the airport? Are we forgetting that part? What a moron.
about taking an Uber?
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Well, did you have any bias forming in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people, and so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich. Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about the testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and documenting? Right?
Oh my God.
There were a lot of cameras, yes.
You know that
Is he going to play a clip from like the cutting room floor footage? Because Karen did have a documentary team following her around with cameras during the season 1, and then they released it on Max or wherever they released it. Is he going to really play video of him laughing at lunch? And how funny that ham sandwich has entered the chat, because Saul Wackler, the Chief Justice of New York, once famously said that a good prosecutor could get a grand jury to indict a ham sandwich. And that's what they did in this case. They indicted Karen Reed for bogus charges, but they did not indict the sandwich of Karen Reed and Aidan Carney on conspiring to intimidate witnesses. That grand jury didn't buy it. How funny that ham sandwich is brought up. And if he tries to play a clip from cutting room floor testimony footage, this is a joke.
might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and their answers and laughing it up a little bit?
I have no idea, possibly.
You were
it was
involved in
over?
conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a
jealous.
conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember any,
what we would have talked about.
do you remember
Hank Brennan has no friends. He has no friends, and you can see why.
Accolades you might have been receiving because you had given
Accolades.
certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea.
You remember?
I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response, well, the physics doesn't change. You remember?
I don't specifically remember that, no, sir.
We do.
And how long were you at the table eating your ham sandwich with the folks there enjoying
What do you got against ham
the event?
sandwiches?
How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, You got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport, ultimately, your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you
Wasn't
know that
400
the
grand.
defense paid that though?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCA. I have no idea how much ARCA's been paid.
How much has ARCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company's going to get for the work that you've done and continue to do on this case? You have no idea.
Yeah, it's not my concern. It's not my department, so I don't.
That's a no?
He's on
That's,
salary.
yeah, that's a no, sir.
Now, when you communicated with the defense, you texted, didn't you?
When?
At any point?
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with, yes, with whatever I had.
Did you
Yes.
have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense last year during the trial?
Do you think the jury cares?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
I'm going to allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
All
Do
messages.
any of your colleagues use Signal to have conversations with their clients?
I'm going to allow that you're aware.
I have no idea what my fellow employees or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yes?
That-
You worked very closely with him on this case,
The
didn't you?
username.
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
Does he eat ham sandwiches? Canoni's swiveling chair says, wow, I'm going to tip
When
over.
you
Well
worked
done.
on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
But Scott Klein is another engineer at ARCA that worked on the case, correct?
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf are in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that?
Sustained.
Bring up the FBI. Go
Let me
ahead.
ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted?
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You, though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
From the
I mean,
FBI?
there was budgets, and we had to stay within certain values. So I wouldn't say I was given free rein because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget, so.
I want you to be detailed. I don't want you to guess.
So without that preamp, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Since your memory is difficult,
Sustained. Okay.
Since your memory is difficult, Your Honor, it's about time that you took the reins in this courtroom and perhaps chastised your baby boy Brennan from treating the witnesses like absolute garbage. But you know what? Actually, don't. Let him do whatever he wants because he is making himself out to be the fool that we all know that he is. And something's funny over there on the O'Keefe side of the bench. But, you know, the jury's not going to care if he used Signal. The jury knows what Signal is. A lot of people don't need Signal. All iMessages end to end are also encrypted. All attorneys in Massachusetts should be using Signal because Hank Brennan wants to get into your attorney-client communications. So good luck with your bad self having a career after all this is over, in my opinion. Everything is backhanded, it's snide, and if she's not going to let the FBI in, but allow him to keep badgering this witness. Sue from NBC. Sue O'Connell said that Alessia is very agitated at the defense table. Thank you for that. Hank is the fool on the hill. My Instagram from yesterday is me talking about the Guzma coma score, and Fool on the Hill is playing in the background. Thank you, man. Shannon with one
to
N.
remember things, do you write them down?
Quash that.
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
Okay.
Spicoli should order a pizza to the courtroom right now. And that would be great from D&E. It's the only thing that would make the day
Provided
better.
a CV, which is a resume.
That's correct, yes.
Resume outlines your education,
You're going to go to his resume?
Yes, sir.
Okay.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer-reviewed.
Correct.
And peer-reviewed publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003, is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school, correct?
Have you had any peer-reviewed articles since 2003?
Probably not, no.
And your peer-reviewed articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them, yes, sir.
The next one, intelligent walkers for the elderly.
Most of his papers, I looked at his resume yesterday, are all about, and he's got a very long list of peer-reviewed articles that are all about wheelchair design, elderly. You want to go there, dude, go there. I have pinned the Karen Reed Defense Fund link in the chat, and I am I'm not asking, I'm suggesting, or, just take the suggestion for what it's worth. If you have an extra $1, $5, donate it to the Karen Reed Defense Fund, because this is what Norfolk County is paying for. They've paid ridiculous expert tons of money. The defense fund is over $1 million. Most of it is spent already on the experts that are here, and this trial is continuing, and who knows how much longer this is going to go on. It's pinned in the chat. We could crash it. Crash Atty, crash the website. You're going to now dig into him because he has something to do with wheelchair design? Okay, you try that. You try that.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3, yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yes, sir.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
Okay. And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
I can't. His voice gives me an agita and nails on chalkboard. Between living that GP life sloth style, who gifted 10 memberships, and she's like Texas, who gifted 20 new memberships. There's at least 30 new members in here due to the incredible generosity of these two amazing people. Thank them if you were gifted, and welcome. And I'm just going to say, if you guys want to super chat me, super chat it over to the Defense Fund today. Super chat it to the Defense Fund. I love you all with all of my heart, and I appreciate each and every super chat that you send to me, but consider it. Because this is an outrage. This is outrageous. This should not be happening. She's lost everything. And maybe we can do that for Karen Reed today. Thank you for coming to my TED Talk. And now let's listen to him bloviate on a bit more.
Any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter,
Yes, sir.
Smart Technology for Aging,
Yes, sir.
and again, nothing on
Backfire.
pedestrian accidents.
Backfire.
That's correct.
Expanded abstracts, you've written a few.
I have, yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
It's more concerned about Signal than who killed John.
Looking at
Never,
your
never,
CV,
right?
you can note any area of specialty you'd like. Correct?
You can put down whatever you like, I suppose, sure.
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 Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Your expert used a peer review study from the 1950s or from 50 years ago, and he lied to the jury and said that pedestrian accidents most commonly involve head injuries. That's the most common injury. His study was from 50 years ago. Pedestrian accidents have been studied since then, and it's now determined that the most common injury from pedestrian injuries are lower extremity injuries, none of which John O'Keefe had. And this man is now on the cutting edge of science and trying to prevent wheelchair injuries, and you're going to shade him for that? Okay, let's see how that works out. I can't, Janelle. I can't make it make sense. Brennan's lack of self-awareness.
Now,
Well done.
Doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, Would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at times, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
Oh, I talked to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
It's the
That's the
arm.
diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welch, correct?
Sustained.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion, or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray as diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking
You know who's regurgitating? Every single one of us. It's like that Monty Python movie where the guy is just like throwing up into buckets and he's obese. Is that Life of Brian in the restaurant? And then at the end he explodes. That's what's happening here. Our heads are popping off. They're going into buckets. We are all regurgitating so much that it is like a Monty Python movie. Again, another Monty Python reference for those of you who participate. You're making everybody regurgitate, Hank. I can't imagine that the jury doesn't want to barf too, listening to you still on day 31 of season 2.
up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report, or were you doing a certain kind of...
Sustained.
Were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
He said it 3 times.
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
4
Uh,
times.
Sustained
Regurgitating 4 times.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In
no.
x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an x-ray. Yes?
No.
Sometimes x-rays are the best for looking at bony fractures. MRI is looking at soft tissue injuries.
Speaking of
But do you know about the Guzma coma score, Dr. Rentschler? There's Guzma. He's in the corner. He's a Pokemon character.
wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Like dog bites.
Have you ever seen collisions where more than one person was hit or struck by the
You ever
vehicle?
seen one? Like passing by?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience.
I'm going to allow that.
Have you ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or, in some cases, no injuries? Has that ever happened in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people and different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries?
We're not talking about South by Southwest, where a car goes up. Remember that music festival where a car went up and killed a whole bunch or injured a whole bunch of people on the sidewalk? That's not what happened here. It is your theory that one man was hit or sideswiped or clipped by Karen Reed's 6,000-pound Lexus while she was driving it like Mario Andretti in reverse at some speed that you have now abandoned. This is not what is happening here. Why is the judge allowing him to go into ridiculous hypotheticals? That's not what happened here. And the judge should stop allowing it.
You've never seen that.
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries in another case where you look at where there was a similar type of collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cars? It's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow
This
that.
is ridiculous that she's allowing
Do you
this.
mean hit the same way with the same type of car at the same speed with the same force?
I'm going to allow it. Can you answer it?
I don't believe I've ever seen a case where two people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
This is so stupid.
I
that
doubt
it's
that it
deathable.
shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Yeah. Well, sure. The testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that.
Well, he's going to tell you anyway.
No, it's not funny.
Okay.
So I'm going to,
He asked them if it was funny. This is exactly what they've been discussing at sidebar, in my opinion. The constant badgering, the constant nasty, snarky comments that he's making about to every witness that the defense has called, that the judge is allowing because she has zero control over her courtroom, despite the fact that she's Kim Jong-un. She has zero control over Hank Brennan. Why? Why? The world is watching. Could you at least give the appearance of lack of bias? Could you at least give the appearance of impropriety? Just the appearance. Listen to this again. He says to him, is something funny? This is not the way ethical prosecutors behave, you guys. It's just not. It's just not. And I'm sorry if I get wicked mad, but I get wicked mad because this hurts my soul. It hurts my soul as an attorney for decades who has, conducted my practices, and I take it very seriously. I take my oath very seriously. I take the code of ethics very seriously. This hurts my soul to watch this go on and to watch this clown show happen in America in 2025. It hurts my soul. And this should not be happening. Listen to this again.
Personal experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that.
Nobody's ever seen a case
Is that
like
funny?
this.
No, it's not funny.
Okay.
so
One more time. I'm sorry, I talked over it.
where you get these types of abrasions.
Well, I didn't ask you that. Is that funny?
No, it's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
Now she's over
When
talking.
you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not, no, sir.
There was no need to.
You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please? Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm
He
going to
needs to
see
be
counsel at
punished.
sidebar.
He's right. That I am asking you to admonish Mr. Brennan. This is like a child who has no ramifications for his behavior. Parents, you know what I'm talking about. What you allow continues. He apparently has been asking at sidebar for Brennan to be admonished, and mommy will not admonish Brennan. And he needs to be admonished in front of a worldwide audience, because the fact that this is allowed to go on in the United States of America, in Massachusetts, where your constitutional rights go to die, that this man who is a hired gun for Norfolk County DA's office, he doesn't work for them. They have more than 50 attorneys on staff that are being paid a salary. This is the hot potato case of Norfolk County. Nobody else wanted to touch it. So they had to go out and hire Hank Brennan to come in and he'll be paid $1 million by the time this is all over. $1 million. There was no conflict. They didn't need to hire out a hired gun. That's what they did. That's what he's doing. He's disgusting. He's the reason people hate lawyers. And if you don't admonish him publicly, Your Honor, I don't even know what to say. Listen to this again.
I'm going to see
Listen to the argument.
Now that you've shared your opinions, can I get back to my question?
sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at sidebar.
Yeah, she's given him a long leash. She's given him such a long leash, and he can do whatever the hell he wants. And he knows he's not going to be admonished. He's not going to be punished. He's not going to be smacked down in front of the jury. But every time the defense does one little tiny thing, even veers near the line, she's all over them. Hurry up, Mr. Jackson. Hurry up. Can you? That's it. One more question. That's it. You're done here. Telling the jury that she knows that they're fed up and that they're annoyed and, so sorry we're taking so long. And she forces, the jury's going out. Maybe he'll move for another mistrial. She's forcing the jury to watch them walk to sidebar all the time at the request of the defense. And maybe the jury's holding it against the defense for asking for all these sidebars. It's on her. It's her fault. It is her fault. Like in The Handmaid's Tale, your fault, your fault. You might know what I'm talking about if you watch The Handmaid's Tale.
So it will.
Let's hear what she's got to say for herself.
So it will be the luncheon recess, and we'll take an hour.
All rise to the court, please.
You going to take an hour? Good. Let them, the defense team, go and start preparing another motion for for a mistrial with prejudice. They're coming back at 145 because this is outrageous. This should not be happening. People write to me from other countries and they're like, you know, you guys say that you have the best justice system in the world. And we are now a worldwide joke because of what is going on in ass backwards Massachusetts. Fight me on it. Come for me in the comments. Tell me I'm wrong. And that's why I get mad, because it hurts my soul. It hurts my soul. Everything that I went to school for, that I practiced for decades, fighting for people with no voice, fighting for the victims who have nobody to fight for them, victims of horrific things that you can't even imagine. What is going on right now, what is happening to Karen Reed should not be happening to anyone. And I'm repulsed by it. I'm repulsed. I just got to find a banner here that I can make that says we're coming back until 1:45. They're going out until 1:45. Hang on. Let's hope they make another motion for mistrial because, you know, third time's a charm, right? Aren't we? Isn't 3 the magic number here? 3 is the magic number. Let's go to questions. Let me take your pulse, people. Let me see how you're doing. And you may need to go take a break. Go take a break. This is exhausting. It's exhausting for every single one of us who even just watches it. It's exhausting. Vet Girl says, thank you so much for your super generous 50. Did you ever see anyone step on an anthill? What does this have to do with Officer O'Keefe? It wasn't glass. It was polycarbonate, desperation, and trying to make hostile witnesses hold. Dr. Rentschler, hold. Hold. Keep it together. He's doing a great job. And he took the words right out of Judge Cannoni's playbook. Remember, during season 1, Karen was just like exasperated. And in front of a worldwide audience, Judge Cannoni said to Karen Reed, "Something funny, Ms. Reed?" And don't you know it? That was exactly the sound bite that was played by every single media outlet that night. "Something funny, Ms. Reed?" Isn't that what he just said to Dr. Rentschler? Something funny? It's like these two have mind meld. Where are the grave concerns now? Anybody seen the grave concerns? Thank you, Pearl. Says grateful 24/7 user. I just donated to the free Karen Reed fund. It's pinned. It's pinned in the chat. It's pinned, just like they're trying to pin it on the girl. Mama Shea, thanks, honey. Hanging paper straws all day, every day. No jury on earth, except maybe in Canton. Thinks Hank Brennan can out physics the physics guy, says Kurt Smith. I don't know what to think at this point. I don't know. It's going to be very telling when those alternates are picked. We have not lost one juror, and there are 18 of them. Only 12 will deliberate. So 6 at the end will be pulled from that bingo drum as alternates. We haven't lost one. That's very unusual. In New York, you go into the trial knowing that you're an alternate. They do it differently here in Massachusetts. I don't know if it's better or worse, because maybe if you know you're an alternate, you're not going to pay as close attention. But some of these people probably feel very passionately about what's going on here, and they really want to serve. And if they get picked as alternates, it's going to be devastating for them. Like it was for Victoria George, an attorney who was pregnant with twins during season 1 and was picked as an alternate and then was chosen by the defense team. She was hired by David Unetti's office, and she was with them during jury selection. Her name is Victoria George. And one of the witnesses from season 1 is going to be, I think, a guest tonight on Aidan Carney's show, right? I mean, I saw some rumblings of that. I don't know if that's still happening. Do you guys know? Thank you, Jamie. That girl says he's doing this on purpose, making the jury emotional so they forget what the testimony given. So they forget what the testimony was given for defense. Last witness, so he's going to make a show. Yeah, he's going to make a show. His show should be canceled mid-season. Chloe Albert's Revenge says Welcher dressed in full John O'Keefe drag and he's not reenacting the accident. I think he's unhinged right now. Yeah. Rebecca Stanford, if found guilty and appealed, what are the chances an appeal judge would overturn based on the conduct of Bev and Brennan? This is insanity. If she's found guilty, God forbid, she's convicted. There are so many appellate issues that it's not just the judicial conduct and the prosecutorial misconduct, although they are severe. There are so many issues here that I can't even count them I've lost count, Rebecca. I've lost count. So many ways. Let me count the ways that this would be overturned on appeal. And I'm not an appellate attorney. That is a very specialized skill. Andrew Burkhardt is. Other people out there on the socials are, and they agree. A lot of reversible error here. So much that we can't even count it at this point. Jennifer, the one thing that bothers me about these tests is the way they weren't done in a curvy street as Fairview Road. By the way, so far I've counted 18 sustained objections. For Brennan. Thank you. Doctor, what is the price of tea in China? Yeah, it's ridiculous. I'm so glad AJ just said that in front of the jury. Chloe bit me. I'm not sure exactly when that was put in there, but I'm usually behind on these, so I apologize. Tipwell wondering if the FBI is watching, saying, I see why we're investigating the KNPD. Hank and Bev should not have a job after the spectacle. Tipwell, we don't even know what they're really investigating. They could be investigating the DA's office. They could be investigating Norfolk County. They could be investigating the Massachusetts State Police. That's the surprise in all of this is when this case is over and when Karen Reed is acquitted, it may take another trial if the jury is hung again. And trust me, Massachusetts will try her again. They are not going to let this go because some very, very powerful people are pulling the string behind the scenes. What do they know? What are they hiding? Who owes who what? Right? We don't know. We don't know what they're looking at. We don't know who they're looking at. We don't know who they've been wiretapping. We do know that they uncovered a whole bunch of messages between the McCabe's and the Alberts that led to a lot of nuggets. Tell them the guy never went in the house. Just being one of them. The 5:07 a.m. phone call from Jennifer McCabe to her sister Nicole, who lives at 34 Fairview with her husband, Brian Albert, one of Boston's finest reality TV show cast members. Boston PD, he has since retired. When you retire, you get to keep your pension. We know about that 5:07 phone call now. Jennifer McCabe doesn't remember making it, or even if she did make it, she says her sister didn't pick up. But how long was that phone call, you guys? How long was the phone call between the 5:07 phone call right after Karen Reed called Jen McCabe, or had the niece call Jen McCabe, because Karen Reed didn't have Jennifer McCabe's contact in her phone because they weren't friends. What was said during that 5:07 a.m. phone call? Karen's freaking out. She can't find John. 36 seconds. Okay, I'm going to set the timer for 36 seconds. We're going to see how long a 36-second phone call can be. Ready? Here's what you can say in 36 seconds, because they're going to tell you, that you can't say anything in 36 seconds, and therefore must have been a butt dial. Must have been. All right. Oops, wait. I did minutes, not seconds, because I'm not a scientist. Hang on a second. And I'm just role playing here. This is improv. This is improv, okay? Ready? Setting the timer now. Holy crap, Coco. Karen just called me. Yeah, she called me. She's freaking out. She's freaking out. She doesn't know where John was. John didn't come home. Yeah, she's freaking out. What do you want to do? I don't know. What do you think we should do? I don't know. I told her to come here. I told her to come over here because, I told her that way I can have control over her. I told her to come here. All right. And then what should I do after that? I got to buy more time. Okay. I'll tell her we got to go back to One Meadows and look for him. Okay. All right. You guys set? You know what to do? All right, cool. All right. Got to go. All right. Yeah. I'll see what else I can get from her. Okay. Excellent. Okay. Bye. 36 seconds. And the timer just went off and I can't shut it off. That was 36 seconds. Okay. Oh, if it was 38 seconds, you get 2 more added seconds. Right. I said a lot. That 5:07 a.m. phone call to me is the key to much of this. Why? Jennifer McCabe changed her story like 10 times, and we know that because we've been over all of the original police reports. She changed her story like 10 times. And then when Karen told her, oh, I cracked my taillight, which she did not say, in my opinion, in that original 4:53 a.m. phone call, that was sometime later. Oh, got taillight. Let's think of what we could do about the taillight. She says she cracked her taillight. Maybe, perhaps. I'm writing a script right now. Okay, work with me. I'm writing a script. She thinks she hit him. You heard Dr. Russell say that's acute grief reaction. That happens a lot. People feel guilty when they find a loved one dead. They think, could I have done it? Did I do it? Could I have hit him? Did I hit him? Could I have hit him? We'll use that. Yeah, let's use that too. Because in none of Jennifer McCabe's original statements that she gave to the first responders, none of whom were called to the stand except Gallagher. I don't even think she spoke to Gallagher. Good point, right? Gallagher never interviewed Jennifer McCabe, did he? He never spoke to Jennifer McCabe. You know who did? Saraf, Mulaney. Who else? Changed her story multiple times. And then at 9:00-something a.m., she called Lanka. Didn't she call Lanka and tell Lanka to come back? Or did she call Proctor? I think it was Lanka. Told Lanka, come back. I forgot to tell you something. Come back. Lank, if you don't know. Ray Donovan, he's been the fixer of the Albert family for decades. Many, many incidents involving the Alberts, right? Called Lank and said, can you come back? I got to tell you something. She was still at 34th Avery. He ran right over there. You jump. He said, how high? Why? What's with Lank? Oh yeah, I forgot to tell you that Karen Reed said, did I hit him? Could I have hit him in front of one of the cops? But I don't know who, and I'm not sure if they wrote it down. So can you put that in your report? Never once ever did Jennifer McCabe ever tell anybody. Karen said, I hit him, the way she testified to in this trial. And then her phone at 2:27 a.m. searched up Haas Long to die in the cold. After Brian Albert butt dialed Brian Higgins, and then Brian Higgins butt dialed him back. How long was that message between Brian Albert and Brian Higgins? How long was that one? We'll time another one. We'll do another one. Let's do it again. This is a fun experiment. You see, I'm doing my own experiments like Hank Brennan says I should do. Okay, I think that one was made at 2:22 a.m. How long was the phone call that allegedly was a butt dial between Brian Higgins? 22 seconds. Okay, 22 seconds, butt dial. Okay, so Brian Albert, picture this, in bed with Coco. He says they're doing the deed, they're doing the nasty, and that he must have rolled over on his phone because he sleeps with his phone on his bed and his reader's glasses, by the way. They were doing it at 2:22 a.m. after he had been at a New York City cop's funeral the day before for 2 days. He's been probably drinking, maybe, I don't know, in my opinion. He and his wife were doing sexy time. He must have butt dialed Brian Higgins, and then Brian Higgins butt dialed him back. That's 22 seconds long. Ready? That's before the Haas Long to die in the cold search. Set, go. Dude, yeah, I don't know. It's cold out. I don't know, man. I just went over to Canton PD. I got the Faraday bag. What else do you want me to do? All right, what do you think? What if, Lucky, the guy who plows, right? Those injuries from Chloe could look like they were from a plow, right? Don't you think? They may think that. Maybe if we put him outside, they'll think he got hit by the plow. Okay, good. All right, cool, bye. 22 seconds. Think the FBI is like, looking into any of this, maybe? After that call, the 22-second call, that's when the search shows up on Jennifer McCabe's phone. Haas Long dying cold. Deleted search. And then maybe, just maybe, the next morning, it's scrolling along the bottom. They're coming back at 1:45. I'm sorry if I'm boring you. Then the next morning, Jennifer McCabe is like, holy F, I Googled that thing last night. Okay, I gotta delete it somehow. I gotta say it was that in the morning. 6:23, the Googles. How long? T-I-D-I and C-I-K-D. Oops, that's not the right spelling. It needs to go back to the spelling that I spelled it out at 2:27 a.m. or whoever made that search on her phone, because, might not have been her. And then at 6:24 or whatever, 6:23, 6:24, again, another search, Haas Long to dying cold, the same way it was spelled at 2:27. Okay, now I can say that Karen told me to Google how long to die in cold. But I don't want to say she told me to Google how long to die in the cold because that's too obvious. So I got to say something like, she said to Google hypothermia. Because if somebody told you to Google hypothermia, wouldn't you Google hypothermia? It's not hard to spell. And if Karen Reed wanted to know how long he could stay alive in the cold, wouldn't she have said, Google how long a person can stay alive in the cold? Think about it. Think about it. Be smart. Be smart. You're smart. Jury, you're smart. You're not stupid. You're smart. Why did Kerry Roberts lie to the grand jury to get the charges upgraded to murder and say, oh yeah, I heard Karen say that. I heard Karen tell Jen, Google hypothermia. I heard it. I was there. I heard it. And then she's caught on a lie. You're caught on a lie on the stand in season 2, saying, oh, no, I didn't actually hear Karen say that to Jen. Jen told me that Karen told her to Google that. Really, lady? Really? Because your testimony to the grand jury in April of 2022 helped Karen Reed's charges get upgraded to murder. And then we find out during season 2 that the FBI pays a little visit to Jennifer McCabe. The FBI pays a little bit of visit to Jennifer. When was that? When did the FBI show up outside her house and confront her in front of her vehicle? 2023 sometime? 2023? FBI shows up? Says, are you the homeowner? No, my name is Nicole. Pretends to be your sister. Runs inside the house. Scurries in like the Pink Panther. FBI calls her on the phone. It's Jennifer McCabe, and now she's like, oh, I'm busted. Yeah, we'd like to talk to you from the FBI. Okay, but I need 10 minutes to brush my teeth, okay? Can I have 10 minutes to brush my teeth? And then during those 10 minutes, I don't know if she brushed her teeth or not, but she made 5 phone calls. 5 phone calls, and then she lets them in. And the FBI says, the 10 minutes that we were waiting outside that you said you needed to brush your teeth, did you make any calls? Did you contact anybody? And she says, yeah, I called my husband, and I called, who did she admit to calling besides Matt McCabe? She admitted to calling 2 people. We're very collaborative here, chat. You can tell me. Did she admit to calling Kerry Roberts? Or did she admit to calling Peggy O'Keefe? Or did she admit to calling Brian? I was Kerry, right? Sue was saying that one juror almost fainted. What? The DA's office. Thank you, Be in Trouble. Did she admit to calling the DA's office? Brian, well, we're now, none of us can remember. I think it was Kerry, though. I think it was Kerry. Yeah, chat, the majority say Kerry. Okay, so she admits to calling her husband and says, come home, which, that's understandable. You would call your husband and be like, honey, the FBI is here. What do I do? Please come home. And Kerry Roberts to say what? FBI is outside my house. Have they come to you yet? What she didn't tell the FBI, and they already knew the answer to the question because maybe her phone was wiretapped. Who knows? I mean, anybody who watches like Law and Order SVU or the better show was like Organized Crime or like FBI. They're always outside in a van with all the guys and all the equipment, and they're listening to exactly what you're doing. Trust me, they don't show up not already knowing what you're doing or tracking every move you make after they're sitting outside waiting for you. Not only did she call Matt McCabe, her husband, and also called Kerry Roberts, she also called brother-in-law Brian Albert, whose house John O'Keefe was found dead on the lawn of, Boston police officer, member of the cast of Boston's Finest, also a member of the Fugitive Task Squad unit or something. Holy F, the FBI are here. What do I do? Tell them the guy never went in the house? And remember, this is in 2023. This is a full year and something later when maybe some of these people might have thought, we're good. We're good. Because, if she takes the plea, it's over. If not, it's a whole other episode. Brian Albert, she called the DA's office. We don't know who she talked to there. I'm sure the FBI knows. I think she said that she called her victim witness advocate, because, harassment. However, she was visited by the FBI before Turtle Boy even started reporting on this case, right? So there was no harassment. Did she call Michael Marcy directly? Because we know she's got a bat phone with a direct line to Michael Marcy, because they were stupid enough to post a screenshot in one of Aidan Carney's motions. Or Michael Marcy was stupid enough to attach a screenshot from Jennifer McCabe in his burner email to all the Stoughton court judges saying someone has lost faith in the Stoughton County clerk, and I can't have that. We know she's got a bat phone to Michael Marcy. She called the DA's office, and she called Peggy O'Keefe. She was caught in that lie by the FBI, or she maybe admitted it. Maybe Matt said, "Oh my God, you like the FBI, you better call them back." That's federal crime, babe. Federal crime, federal time. Club Fed ain't no joke. And it was brought out during this season that she did indeed lie to the FBI. I don't know if they knew if it was the FBI, but she lied. Could be a federal crime. Maybe they're waiting to charge her, and we don't know. We don't know, because if she lied about those things, who knows what else she lied about, maybe. Perhaps, in my opinion, somebody might think that. What are we doing here? What are we doing here? Thank you for coming to my TED Talk. So back to Tip Will's comment. That was a great comment. We don't know what the FBI is investigating. Helena Rafferty, the chief of the Canton PD, sent out on her letterhead a letter to all the trolls saying the FBI investigation is over. How would she know? Why would you take it from Chief Helena Rafferty of the Canton PD? The FBI investigation is over. Shortly after she released that on her letterhead, she announced her retirement or resignment or whatever she's going to be doing. Her resignation. So we'll see what happens, if anything, to any of these people. We'll see. Stay tuned. This is not over. Even after we hear the magic words of not guilty, this is not be over, and it will not be over for a very long time. And that's my prediction. We can ask the magic 8-ball, but could Hank's career be repurposed as a leaf blower for Canton PD, says deleted comment queen. Well done. His voice hurts my soul. Donation to the Karen Reed Fund incoming. Well, you're very generous. Thank you. Thank you, Sidebar Shenanigans, for your super sticker. A juror got sick, so Bev called early lunch. Is that true? Somebody said, Sue O'Connell said that, I think. What can the Commonwealth even rebut? Nothing new came out. Oh, no, they were told by mommy that they were allowed to bring Dr. Welcher in because it would only be fair because ARCA did some extra testing. And so Dr. Welcher was on vacation. He didn't have a chance to refute that testing. So he was given an extra chance to do that. And so she's allowing it, of course. Kat Randall, you're so appreciated for this hosting, for the hosting of this abomination. My soul is revived seeing the overwhelming support. This is a true mission from God. Yes, this is a mission from God. Thank you, and thank you, all of you, for supporting. You are the best. You are all the best, and thank you, Kat. Decorated dude pickup lines. Next time Hank asks someone how much they were paid, they should respond with, not as much as you've been paid by the Commonwealth Clown Show. Oh no, Brian Wilson just passed away? Like today? Like just now? Oh yes, Brian Wilson just died at 82. I got the New York Post alert 9 minutes ago. Well, that's sad. R.I.P. Brian Wilson. Great bare naked lady song about him lying in bed, just like Brian Wilson did. Thank you, Robin, for breaking the news. I can't read your name. Fizzle FMS. As a PhD candidate and scientist, the defense experts only planted reasonable doubt in my mind. It convinced me that there was. Oh, so here she says the defense experts not only planted reasonable doubt in my mind, convinced me that there was no collision. There was no collision. There was no collision. There was no collision. Thanks, Alex, for becoming a member. Kay says, what is the jury doing when Brennan is doing that? I don't know. We can go to Sue O'Connell. Mama Bees says, oh, thank you so much for your Australian super chat. Super generous. Thanks for donating to Karen's Defense Fund. Mel, I can't donate from here in Australia. Finally, a way to help out. Brennan's a piece of work. Can't wait to not hear his annoying voice and not watch his disgusting, disrespectful behavior. But we have to keep watching. Cupcake collaboration says Hank is nauseating me. I can only imagine how the jury's feeling. He's so rude and brutal. He'll never match the class of the defense who hype up when it's the right time with the lies. Well, let's see what Sue O'Connell has to say for herself. Hold on. Because she said something about a juror getting sick, somebody said. All right, let's see. I was laughing at something else. Joe Flipperhead, not that. What did she say? Early lunch to accommodate the juror. That was 32 minutes ago. Let me just scroll back a little bit. Nine jurors are writing as Rentschler testifies that the aperture paint test proves nothing. Most jurors paying heightened attention as Rentschler explains about how hybrid arms are used to test airbag injuries. Jurors now see a split side slide on the screen. One is a loop video of the hybrid arm being hit at 15 miles an hour. I was like, yeah, keep playing that, keep playing that. She says many legal experts say they are surprised the defense showed evidence that could help the jurors visualize how the Lexus could have hit John O'Keefe, right, and shatter the taillight. They are doubling down on that today, showing their video, the prosecutors are, and the prosecution's on a loop. Wait, the defense showed that or the prosecution said that? I mean, showed it. I don't know, because now I'm getting very dizzy. Let's see. Jurors are attentive. Some are taking notes. Blah, 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 blah. What's she saying about the jury? I mean, the juror who got sick. It's a very long thread, you guys. It is a very long thread. If you play on the cesspool of Twitter, go follow Sue O'Connell. But I just want to see what she's saying about a juror being sick. And if a juror is sick and they had to take the lunch and she has to leave, they may just excuse her and we'll be down to 17 because they can't stop the trial. This needs to keep going. Yeah, one juror asks for the court officers. So this was 36 minutes ago. One juror asks for the court officers. She looks sick. The jurors are taken out. She looked like she was going to faint, said Sue. Sidebar continues. The court is in session. She looked very still to me this morning, Sue says about the juror, and then says early lunch to accommodate the juror. Yeah, so that could be what is happening. That could be what is happening. Thank you very much, Cupcake Collaboration. Oops. There it is. Didn't she call Carrie to see if the ice cream truck was in her neighborhood? That is right, Judd Welcher crash test. Dummy. That's right. She said FBI being there was no big deal. It was like the ice cream truck when you're little, like, right? Toasty Bun. The doctor said he wasn't hit by a motor vehicle and the injuries on his arm are dog bites. End of story. Right. End of story. Justin said, Jen certainly seems to have to call and add things. Yep. Oh, good one, Camille. The absolute insanity of the Commonwealth brings to mind Hitchhiker's Guide to the Galaxy. Yeah, I remember reading that in college. Pure logical fallacies and gaslighting by Douglas Adams. Thank you. Can the judge overrule a verdict? Not if it's not guilty. If it's guilty, Karen can appeal, or the judge can set aside the verdict saying no reasonable jury could have ever found her guilty. Oh man. We thank you, Jessica. We saw that recently. Remind me, chat. It was a cop who was convicted of graping his stepdaughter and another girl, essaying her down by Fall River somewhere. Jury found this cop guilty and the judge threw it out, and he's now getting a second trial. His name is Souza, the cop, right? Think it was a Fall River cop. We got to get back and find out what's going on with that Souza case. Discussing Dartmouth. Hi, Kelly Reed. Good morning, Kelly Reed. You're beautiful, Kelly Reed. He was with Dartmouth PD. Yeah. Revolting. And they quietly let him out of jail too. It was weird. We went over that in one of my shows, like before this trial. Yep. I forget his first name. His last name is Souza. Why can't I think of it right now? Because I have a million things running around in my brain. Aussie Steve says, my lack of sleep during this trial and last is minor compared to the enormous burden Karen has had to endure throughout 3.5 years. The world is watching. Yes. And that's what I'm asking. That's why I pinned her defense fund in the chat. The team, although all the attorneys are working for free, they need to be fed. They need to be housed. They need transportation back and forth, flying back and forth. Experts are going to need to be paid when all this is over, because they're not going to know the amount of their final bill until they know how many hours they've put in, because many of them have been forced to change their travel plans and stay longer. Except we do know Dr. Wolf crashed Atty, drove home for the weekend, and thank God he did after the way his wife was trolled on the cesspool of Twitter. I'm glad he was there for his wife. Dexter, save us from the Commonwealth. Oh. Lily Allen's song with lyrics. Look inside your tiny mind now. Look a little bit harder, because we're so uninspired and so sick and tired of all the hatred you harbor. Thank you so much. Oops, there it is. Sean Souza, Dartmouth PD, says Hank Brennan's baby. Binky, Hank Brennan's Binky, Google it. You will be horrified. You will be horrified. He's out. He's out awaiting another trial. How could a judge do that? Listen, it's Massachusetts. Anything goes. Anything goes. Google it. Or watch my show on it later. Stacey Face Travels. Randy must be another name for Hank. 100% dummy. Kelly, could they choose jury nullification due to the fix being in? It's not a box to check, but they can say, I don't know what you're asking. They could find her not guilty, even if they thought she was, just because they don't like it. We're not supposed to know what goes on in the jury room, but jury nullification is not like a box that you can check off. So I'm not really sure what you're asking. Thanks, Margaret, for your super sticker. Thanks, Rentschler's ham sandwich. Listening to Hank Brennan is like listening to Elle Woods. Elle Woods was way better than Brennan. Are you kidding me? Love Elle Woods. Do not insult Legally Blonde like that. Susan, I'm actually kind of glad the Commonwealth gets to do a rebuttal, because it gives the defense a chance to call out Welcher for incorrectly saying there were no x-rays and misleading the jury, or for insinuating that perhaps Mr. Brennan did not provide him with the x-rays on point bis. Right, Susan? Mm-hmm. Cupcake collaboration. Are eating ham sandwiches in public against the law in Norfolk? Might be, but it was appropriate. Thank you, Britt, the ham sandwich bottoms, for gifting a membership. Jen McCabe's unused toothbrush says, yeah, thank you for keeping me laughing, because I'm not so outraged. Not taking notes to me means he's the smartest juror. Who knew this had been a sham from the start? Yeah, it could be. Could be. I took this one already. Thank you, Mo. Thank you, Rebecca Davis. Amy says, no collision, just collusion. Proud Mama, watching intensely. Any knowledge of, oh, that's the wooden pallet thing on Google Maps? I don't know anything about that, no. And who knows when that photo was taken? It would never be admissible. She's not even allowing in photos of the interior of the garage that were taken last week. And maybe because, they may not be in the same condition they were on the night in question. I could see that. But it makes it look like she's really, really hiding something about whatever's inside that garage from the jury. And I'm pretty sure they picked up on it. Devin, AJ Redirect, did you eat a ham sandwich for lunch today? Thank you, Colleen, for becoming a member. Sidebar Chick says, let's all donate our bodies to science and our money to defend the innocent like these people did. Donate free Karen Reed. Thank you, Colleen, for becoming a member. Melanie, thanks for becoming a member. A lot of Melanies in this chat. In my opinion, kickbacks for objections ruled in benefit of the state, says Odin's. I mean, I don't, I can't speak to that. My husband finally heard Hank, shock and awe. Jennifer McCabe famously said, we were in shock and horror. We were in shock and horror. Of course we were having a family meeting. You know what you didn't see in any of those family messages among those people? Oh my God. I miss John. I miss John. I can't believe what happened to John. Nothing like that in any of those group text messages among the McCabe's and Alberts, right? Nothing talking about John. I mean, it's just, wow. Sidebar shenanigans. Hank Pank can't break Dr. Rentschler like the Lexus didn't break John O'Keefe's arm. Yeah. Polydan, not impressed. Hank Brennan is definitely out of order looking for something. I'm not sure what that says. MT. More time. Thanks, Lamar. Say it, Dr. Rentschler. Yes, details matter, Hank. Great question, Dawn. Why is he so disrespectful to the witnesses? Because he can be. Because he can be. Because the judge lets him do whatever he wants. Because she doesn't reprimand him like she should, like she's done to the defense team many, many, many times. I don't know if you were here for preseason 1, but the grave concerns that she had one day when Hank Brennan lied and started waving around documents having to do with their communications between them and the crash daddies after the trial was over, gave her such grave concerns that she really had like a mental break, maybe, in my opinion, had to take a 30-minute timeout and came back shaking like a leaf. Hank Brennan lied and said, I had to get this from the feds. And really the defense gave it to him. So, mistrial motion is what you meant to say. Gotcha. So he's disrespectful to the witnesses because he can be. Because nobody stops him. Beckgirl says desperation when losing is not a good quality, Hank. Just my thoughts. Good job. Hold on. Dr. Rentschler. SMEAC, you, Jackson, Alessi, and others give me hope in the justice system. Then Brennan and Anti-Bev come and completely undo that, driving it down further. I know. It's very frustrating. Oh, FL Digger said it was Monty Python's Meaning of Life. Okay, it was not like, is Life of Brian a different movie? Mr. Creosote scene. I'm reenacting myself right now because of Brennan's vile behavior. Thank you. It's the Monty Python's Meaning of Life. The scene where the enormous man is in the restaurant and he eats and eats and eats and eats and eats until he explodes. And then he starts throwing up into a bucket and everyone throws up and then it explodes and it's everywhere and it's gross. That's what this is reminding me of. Diane says, Karen, love and peace to you and all your believers. Diane from Weymouth. Criminal, Fiona Apple. Maybe on there already. Melcha, maybe. Rescue Randy's Twisted Leg says, Mel, in theory, can Hanky answer a mistrial today so he can get a new trial? Maybe based on misleading evidence and so on caused by the Commonwealth? Thank you. Well, Hank wouldn't ask for a mistrial based on his own misleading evidence. I'm not sure what you're asking me. But I know, hello to Norway. I know that people were speculating that he was going to move for a mistrial today, but I don't know what his grounds would be. I have no idea. Kelly, your screen is black on YouTube. Interesting. Anyone? No, that happened the other day. There was like an outage of StreamYard and YouTube. Everyone went down at the same time. And so refresh your browser is all I can really say. Restart your computer, refresh your browser. Karen Reed. Oh, that means we if the Karen Reed link is not working, that means you guys crashed it. Last time I had it up here on my screen, It was at 1,055,088. Let me just take a look. 1,055,088. If I try and refresh it, sometimes if too many people try and get into it, it crashes, which is good. Now it's at 1,058,513. So it's it's about $3,500 up since it was last time. Keep trying if you so choose. I can't tell you what to do with your money, but I can tell you how much money it costs. Becky said Hank's entire cross is tearing down the character of witnesses rather than disputing facts. Pathetic. It's pathetic. It's pathetic. Hannah says, yeah, I can now donate to the defense fund. It's not directly possible for me from the Netherlands. Thank you. Thank you, Hannah. Laura, I appreciate you for watching from the Netherlands, for being interested in this case. Does anyone see the signs from Bev? It says Bewitching Beauty. A lot of people have pointed out that they think that she's making signs. It's hard when we can't see the whole courtroom. Rescue Randy's compound fracture, $400K for Aperture's services. Every criminal civil case in Massachusetts involving Aperture's forensic analysis should be reopened. It's looking real funny out at Aperture's Northeastern Boston division. Yep. Agreed. I agree. $100%. So since today is like a Big Bang kind of day, you know, why don't we listen to a little Paris Ray and the Crush to get us through the lunch break? I can't play a lot of music on YouTube. This music I can play because one of my kids, and I'm not going to tell you which one, happens to be in the band. And so we can play Paris Ray and the Crush. You're going to love them. Here's their entry for the Tiny Desk contest. The song is called Big Bang. And after that, we'll play another song from Paris Ray and the Crush so that you guys can enjoy it. Please go subscribe to them on all socials because they're amazing. They're saying what we're thinking, just coincidentally, really. This song was written, it had nothing to do with the Karen retrial or anything else, but listen to the lyrics. After this, maybe we'll play Horoscope. I know you guys love them. We love Paris Ray and the Crush. And if you disparage Paris Ray and the Crush, you were getting booted out of here like faster than you can say jump. I can't play a lot of music. I can play this. You're going to love it. I'll be back. I got to eat some because I'm getting dizzy. But we have 9 minutes to kill. And this is one of the greatest ways I can think of to kill it. Love it. Enjoy it. Follow them everywhere. Stream them on Spotify. The new album is amazing. It's called Oversharing on the Internet, and it's fantastic. I'll be back.
New York had an earthquake, a whopping 4.8 on magnitude. Just fault lines and friction, but it got me thinking how I didn't know what to do. This lack of preparedness is making me anxious, so what else is new? A solar eclipse or the apocalypse, and I still wouldn't turn on the news, 'cause que sera, sera. Just do whatever you want. If today is our last day, I hope we go out with There's wildfires in the north and they turn the sky orange. The whole thing looks like something from a movie. Felt like we were doomed. We just all carried on with our lives. Not sure what to do when you're feeling like Truman and nothing feels real. Don't know what it says, it bracing for moment I ever feel. 'Cause I'll just do whatever you want. If today is our last day, I hope we go out with I spend more time in my car than I do in my bed. Less time in my body than I do in my head. Oh, something's gotta give real soon. I spend more time on my phone than I do in my art. I listen more to the assholes than I do to my heart. Oh, something's gotta give real soon. Hope I'm not sounding unrealistic. Isn't there some rule with statistics saying eventually my luck is gonna change? Something's gotta give real soon. Baby, aren't you feeling this too? There's something in the air and it's new, and I knew it was coming. No chance I'm letting this go to waste. I'm seizing the fuck out of this day, so I can look back and say I knew I was something. Oh, something's gotta give real soon. I tell myself to be grateful more than to be great. If I spend all my time comparing, there's no time to create. Oh, something's gotta give real soon. I spend more time on my past than I do on the present. Now the present has passed, okay, I learned my lesson. Oh, something's gotta give real soon. Hope I'm not sounding unrealistic. Isn't there some rule with statistics saying eventually my luck is gonna change? Something's gotta give real soon. Baby, aren't you feeling this too? There's something in the air and it's new, and I knew it was coming. No chance I'm letting this go to waste. I'm seizing the fuck out of this day, so I can look back and say I knew I was something. Something's gotta give real soon.
Awesome, right? Hey, if you had a kid, you would do it too. Don't out which one is my kid. I'm not here for that. But I got a platform. I'm going to use it. They're still on break. Let's do, and so many of these songs are so appropriate to this trial. Shockingly, but not really. Something's got to give real soon. Don't worry. If court comes back, I'll break. But let me eat a couple more spoonfuls of my yogurt and granola and blueberry parfait that I made myself. Look at this. You can buy these jars on Amazon. They're awesome. You can make salads in them too. Maybe one day we'll do that for fun. Let's listen to Green Flag right now. Also, Paris Ray and the Crush made the official Miller High Life Spotify song playlist for the summer. Is it Green Flag? Paris Ray and the Crush. That's on the Miller High Life official playlist from you guys. Awesome. All right, let's listen to Green Flag. We got more time. It's the only music I can play, but I don't care. I play it anyway. Here you go.
You're like a breath of fresh air. I love a man who's healing. Baby, you're so self-aware and in touch with your feelings. No holes in your bedroom walls. Nobody's makeup in your bathroom. You always answer my calls. Nothing suspicious about you. Babe, I think you're just my type. Feeling high when I'm stone cold sober. Got me staying up at night, thinking about the next time you'll come over. You're a walking green flag, and I want you so bad, so bad. The way you're communicating, ooh baby, it's making me wanna get naked. Telling me how you feel. Oh my God, are you real? No vices and no trouble. You're working through your trouble, getting me hot and bothered. Oh, I really wanna. You know you're turning me on when you post me to your story, where you admit when you're wrong. Oh, it's really doing it for me. Babe, I think you're just my type. Feeling high when I'm stone cold sober. Got me staying up at night, thinking about the next time you'll come over. You're a walking green flag, and I want you so bad, so bad. The way you're communicating, ooh baby, it's making me wanna get naked. Telling me how you feel. Oh my God,
You like it so far? You like it so far? Court's still on break. We still got some time to kill. We could play the whole new album because it's pretty awesome. Pretty awesome. Oh, court's back. Okay, we're going back. We're going back to court. Everyone get on over there and sub to Paris Ray and the Crush because it's a shame that they only have 185 subscribers on YouTube. It is just wrong on many levels. Get on over there. Do your girl a favor, meaning me, proud mom. Thank you all very, very, very much for your support. The jury cannot take their notes to deliberate. Oh, yes, they can. Yes, they can, Catherine. They can take their notes to deliberate. Sure, that's the whole reason that they're taking them. Massachusetts does not allow readbacks of testimony, which is something very bizarre. New York allows readbacks if the jury is deliberating and they're arguing about what was said during a certain witness's cross-examination, let's say. They can send a note and say, Your Honor, we'd like to have Officer so-and-so's cross read back. The judge will alert the stenographer to go prepare that portion of the testimony. The jury will come back into the room and the court reporter will read the testimony back and then they will go back and deliberate some more. The problem here is these jurors have to rely on their notes. And I know from my own notes that they are chicken scratch. And sometimes I write notes and I go back later to tell you guys what they say. And I have no idea what I meant when I wrote it. I have no idea what I meant, what I tried to write down because they've been there for 31 days. And again, if we are trying to get at the truth, don't we want the jury to have all the facts, the accurate testimony, the evidence that accurately went in, not be squabbling about, oh, wait, I wrote down that Buchanan said this. No, but I wrote down that he said this. And then the loudest voice wins. It's not the way it's supposed to be. Not the way it's supposed to be. Right? Thanks, you guys. The whole album, Oversharing on the Internet, is great. Desert Baby is a great song. I was going to play that next. Also, The Notebook is a great song. Every single song on that album, and I'm not just saying it because one of my kids is involved here. I'm saying it because it, like, really every day is a different earworm in my head. One of their songs is playing in my head every day. And I wouldn't just say that because I'm biased. And it's biased, by the way, with an ED at the end, not bias. You're so biased, BIAS. Like, come on. We'll see what fresh hell awaits us this afternoon. Court's on a lunch break until 1:45, allegedly, but it's already 1:50. So what is time? Time drifts. Who knows what the courtroom clock says? Because we don't get to look at the clock. We get to look at the fan. No, they didn't rest. Crash Daddy. Or what are we calling him now? Squash Daddy, because he's squashing their case. Rentschler, Andy is still on the stand under cross-examination by the child catcher from Chitty Chitty Bang Bang. Children, oh children, do you want some candy? Yes, you know what? Maybe Lisa, it could be on a case-by-case basis. Says, my sister is a stenographer, real type, has given transcripts for readback in Massachusetts. Maybe it's not allowed in criminal cases. I thought the entire state is using this new FTR system where they speak into what looks like an athletic support. If you can't be an athlete, be an athletic supporter. I thought the entire state was on this FTR system. Are there still some real stenographers in Massachusetts, or is that are you talking about something that happened a long time ago? So I don't know if it's only criminal cases. I don't know if it's only this judge, but I think maybe in some cases, Smash Daddy. I don't know, Kev, you got to stay tuned. Ended at lunch with them heatedly going back and forth. Will we hear anything about that? Hold on to your hats. Tether back your head, and we'll see. We will see. You never know. You never know what's going to happen here. It's like a box of chocolates. Things are overlooked. Time drifts. Evidence is hidden. Evidence is proctored. It's the whole thing, man. It's the whole thing. Shouldn't be happening, but we're watching it happen, so. It is happening. I should probably find Jackson. No, I doubt it. She can't find him. I mean, he's pretty fine, but you can't fine him. Susan wants to know, why is Hank so focused on trying to find out if each defense witness talked to the defense or anyone before their testimony? I understand intent. He's trying to show that they are biased, that they are bought and paid for, and that the only reason they are testifying in a way that smashes the Commonwealth's case is because they must be biased. That's what he's trying to show. I don't think it's working. I think the defense fund site is back up again. Pinned in the chat if you choose to partake. As far as I know, do you remember? It's September by Earth, Wind and Fire, the song's opening line. Do you remember the 21st night of September? Yes. Yes, it is. That's a good one. How does it relate to this trial, though? 21st night of September? I don't know. Oh, bias, like you mean the judge? Yeah, kind of. Kind of, maybe, some people might say. Brian says, Brennan, if Chewbacca lives on Endor, then you must find Henry guilty. Yeah. Every day's a new day. Oh, Sidebar Check said, let's all donate our bodies to science and our money to defend the innocent, like these people did. Donate to Free Karen Reed. Thank you. I think I read that earlier. Thank you, Stephanie Flynn. I'm finally back up to live after 90 minutes due to issues with my 80-year-old mom. I hope she's doing well. Oh, is she in hospice? But she's a fighter. Hospice nurses are amazing. Everyone that works for hospice is amazing. You say she's on end of life, so I'm just assuming hospice. Maybe she's not in hospice, but I'm sorry. My prayers and thoughts go to you and your mom. Spend every minute with her that you can. The Goodmans are here and they've gifted 5 memberships. And look at their logo. Their logo is my logo. It says, I went to Cancun with attorney Melanie Little. If you know, you know. If you know the lore, you know the lore. We have merch. We have merch. You too can go to Cancun with attorney Melanie Little. And the Goodmans are awesome. And they are a husband and wife. And they actually watch my show while they're on date night. I don't know. It's crazy to me too. But hey, listen, whatever I can do to help, I'm here to help. Thank you, Smash Daddy's Ham Sandwich, for changing your name and for your super sticker. Sue B, if it comes out that Hank didn't give Blue Man the x-rays, will that be a Brady violation and another move for mistrial? Well, a Brady violation occurs when the prosecutor does not turn over exculpatory information to the defense. So him not giving it to his expert is not a Brady violation. It's specific to prosecutor's obligation to turn over evidence. A lot of evidence automatically has to be disclosed, but especially exculpatory evidence. And I don't know how the defense team got those x-rays, whether they came from the hospital records. So I just don't know if they were not turned over by the prosecutor. So I can't opine to that other than to tell you that that would not be a Brady violation, them not giving the x-rays to their expert. Doesn't look good for them if they withheld information from their expert, and it will not look good for them on his cross in rebuttal. And I look forward to it, every minute of it. MCKT, someone should totally DoorDash a ham sandwich to Brennan. Thanks for keeping me laughing, Mel in chat. Love you too. And don't do that. Don't do. It was a joke. It was a joke. Don't anybody do that. APB Bolo for Bev's grave concerns. What do you truly think Bev's attitude was yesterday? I have no idea. I have no idea what makes that woman tick or not tick, or what makes her clock drift or tell accurate time. I really have no idea. It would be not smart of me to speculate. I gave up a long time ago. Here's the thing about when you turn 50. When you turn 50, and those of you in the chat can back me up on this. When you turn 50, you all of a sudden have no more F's to give. It's like, I have no more F's to give. I don't care. I don't care what other people are doing. I don't care what people are saying about me. I just genuinely have no more F's to give. And I also decided at that age that I was just going to stop trying to figure out what other people are doing and why they're doing it. Because you will never, ever, ever get a satisfactory answer to yourself. Why does this person behave that way? Why does this person treat me that way? You'll never figure it out. It doesn't matter. But I really have no idea why she was acting like that yesterday. Bee in her bonnet?
Now open, you may be seated.
All right, while the jury is on their way in, I need to see counsel at sidebar.
Oh, Sounds like she has some grave concerns. She's asking to see them. They didn't ask to see her. Alicia, do you think Hank knows he's lost all credibility? No, I think that man's ego is so far inflated that you ever deal with a narcissist? You ever deal with a narcissist? Anyone get their narcissism degree from Instagram too? He thinks he's the smartest person in the room. He thinks he's the king. He thinks everyone's believing every word that he's spewing. And the louder he speaks, the more he's trying to prove a point. Alicia Joe says, I think he'll regret selling out to prosecute this. I wish him luck being hired in the future. I don't wish him any luck at all. Alicia Joe, you are far kinder than I. I think karma knows some people's address. And just like the Final Destination movies, you can't cheat death. You can't cheat karma either. Unless he's up and he's ready. And I don't know if he's going to get to the podium and argue something or if he's just waiting to let everyone go by so he can get his seat. But he's got papers in his hand. Well, I guess not if the jury's coming in. Scout November Light says, is Brendan's theme song on the playlist? I believe it's called How Low Can You Go? Oh, we don't have How Low Can You Go on there. Tracy, if Hank keeps up with his badgering, AJ and he will be going to blows like John Lewin and Joe Tecapina in the ASAP Rocky trial. Oh my God, that was great. The judge had no control of the courtroom, but at least he was fair. Joe Tecapina is such a character. To see a true New York guy like that, bada bing, bada boom, in an LA courtroom. And although I didn't get to watch much of it, I did try and watch little bits and pieces, or bits and bites, as we like to say. And
All right.
he's a New York character. He's
Mr.
been around a
Brennan,
long time.
jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
I bet instead of paying that guy $1 million, you upgrade your ventilation. How about that? They just got Wi-Fi before trial 1, by the way, in case you didn't know.
Dr. Rentschler, you wrote a report back in February 2024,
That's correct, yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes,
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references,
just gloss
did you
over
look
that
up
part.
the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
Wow, he actually read the articles.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
Want to allow that?
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report and PowerPoint. That's the extent.
The
yes.
question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Keep saying 60s, 70s, and 80s.
Well, I think there were,
We got all day. Well, at least until 4 when she calls this whole
26,
sham
I think.
off.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 cites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 cites, in fact, those are the only cites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of cites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cutability and its Relation to Lacerations Severity Indices. You know that, you cited that.
That's correct, and it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather,
We are all
and Napa
Dr.
goat skin.
Rentschler right now.
Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it
Doing it
say
again.
that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
No.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
You're from New York? You're
How
from New
about
York? Do you know a guy named Joey Bag of Donuts? You know that guy? Big Petey, Little Petey, Repeaty? You know them? You know those guys? You're from New York? Big Petey, Little Petey, Joey Bag of Donuts. What are we doing here? Listen.
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash
Isn't
test
that
dummies?
Ethel Mertz's
He is,
husband?
yes.
Right.
That was Fred
Would
Mertz.
you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in
We
that
need
manner.
Flat Stanley. Can
Do
we
you
use
have
Flat
any source
Stanley?
that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
Not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Don't you misrepresent him.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit Do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent,
It doesn't matter because it didn't happen. Just repeat Dr. Queen Elizabeth's testimony from yesterday. It doesn't matter because it didn't happen.
the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Why did he do
Again,
the
I just
experiment?
described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that the arm was positioned.
I think we understand your perspective is that the only test he performed, but what I really want to get at is
It's not his perspective, it's the truth. Did he do a whole bunch of other tests that he forgot to put in his report because the results didn't support your wackadoo theory? What's happening here is a whack job, right? Michael Proctor loved to call all women whack jobs, not just Karen Reed. He called Irene Scortibello a whack job too. This is actually a whack job. This entire proceeding is a whack job. He's a nut job and this is a whack job. And we've officially collectively lost it. We've lost it.
your conclusion. The only
How he believes that the arm was positioned.
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welch ever represent that he was trying to?
I didn't think that I could possibly love this man any more than I do. But that answer right there, I'm overflowing. Listen to that again. One more time, because we're going to need a clean soundbite of this.
There was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welch ever represent that he was trying to describe the actual
Just being
body
kind.
of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm
represented.
asking you, you've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer.
Yeah.
Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Rentschler, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
Do
You're
you
correct.
know whether Dr. Welcher has been clear that he does not know? Let me say this a different way.
Do you know the
You would
muffin man?
agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
But you know what you can do? You can prosecute a woman for vehicular manslaughter, and then you can convene a sham of a grand jury, upgrade her charges to murder too, try her twice, and let her sit there and lose everything, and face life in prison. You can do all of that without having any details about how this accident didn't happen, Mr. Brennan. Wow, this is rich. This is rich.
If you don't have the
You can't-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
You would
You can
do
prosecute someone
a
for murder.
crash reenactment,
No evidence.
but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision. That wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
Land of the Lost. Chaka is our mascot. He's up there.
So, if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm going to,
Approach, please.
very briefly.
Very briefly, yes. She's blaming it again, once again, on the defense. Why are we here if we don't know? Michael Proctor had this thing solved in 16 hours, everyone. He knew John O'Keefe was killed by Karen Reed's car within 16 hours without ever going to the scene of 34 Fairview, without ever seeing that taillight. Never took a picture of that taillight when it was in her parents' driveway in Dighton. Seized her phone, seized her car, all based on the say-so of 1 Jennifer McCabe, 2 Matt McCabe, and 3 Brian Albert. Let that sink in. There was no evidence of nothing about nothing, and they were going to pin it on the girl within 16 hours, and here we sit 3.5 years later. Well, this woman, Karen Reed, has lost everything. She lost her job, sold her house, $5 million in debt to the attorneys who are now working for free, liquidated her 401ks, living with her parents.
Reports and in reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision.
He did not state that. That's correct.
So when you've made your criticisms, that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement by him that he was trying to reenact the actual collision.
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter.
This matter.
If he did not recreate how he was positioned, if he did not determine the speed of impact,
why did he
if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again.
Then why did
My
you do the
detailed
test?
question is,
Why'd you pay him close to 400
there is nothing in
grand?
Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that, is it?
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
Here he goes again.
The answer is no.
Deep breaths, everyone.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying, in part, on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in tests E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift.
Are we talking about Randy now? Are we talking about Randy now? Now you're calling him a crash test dummy? And the other day you're like, I'm talking about Randy now.
It does not allow the crash test dummy, after being struck, to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
Wouldn't be any throw.
If a crash test dummy is restrained by a forklift,
Karma has no loopholes, says Vivian James. I love that. Shout out Dedham Fire Department passing through.
if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
You've seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move. Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
Now he's
When
fighting with the
crash
witness.
test
Okay.
dummy,
Let's hear that exchange again. This is like a tennis match in one sense. And in another sense, it's like a train wreck that you can't turn away from. Listen to that exchange again.
before the impact. Crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash test
Wow.
dummy is held
Speak slower.
by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision, isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Rentschler's PowerPoint, please?
That'd be cool. When Karen's acquitted, can you collab with Cupcake Wars champ, New York City chef Chloe, to sell Snark Tank themed cupcakes to celebrate? That'd be awesome.
In your
Alba.
PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes,
And you put snippets up on the board?
yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
I don't think so, no. Those are the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet, and these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about
He just
front-end
rolls right
collisions,
through
because
that.
that is the majority of pedestrian collisions, the front end, isn't it?
The majority, it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct, and that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
Allegedly. He
So
keeps
let me
saying
get back
allegedly,
to
and
my
I love it.
question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the 24?
miles per hour.
No,
Just
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no.
You
I
don't-
don't know the position of the arm at impact because it wasn't hit by the car.
You don't know
Yeah, hold
the
on.
angle of his body.
Line of the day. I'll timestamp it for us. Here we go. Nobody knows. His arm wasn't hit by the car. Again, what are we doing here? How many days is he going to drag this cross-examination on? It's not helping him. It is making him look like more of an idiot in front of the world and God and the jury and everyone. And they're over it. The judge even told the worldwide audience, the jury's over it. They're done. They just want to get this case and go home. But keep going on with your bad self because you're going to get more answers like this one.
His arm at impact, do you? Don't know the position of Mr.
Here it
O'Keefe's
is.
arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no.
Boom.
I don't know the position of the arm at impact because it wasn't hit by the car.
You don't
Wasn't hit by the car.
know the angle of his body at impact, do you?
The alleged angle,
It wasn't hit by the car.
So
How many times do you want to say it
ask the
wasn't?
question again.
Okay.
Deep breaths, everyone. Deep breaths. Namaste. Namaste,
You
my
have no
friends.
information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
we have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
Keep asking.
When
Keep
you
asking.
talked about force equations with this jury, you cited a
He's
number of
insane.
pieces of literature, didn't you?
I did, yes.
And when you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please?
Scarpetta is coming out in October. Maureen, Amazon Prime, Nicole Kidman. I can't wait. Can't wait.
Let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
What kind of load is
When you gave your
this?
charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
But we're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand.
So
But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
Okay. There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead,
We'd love to do that right now.
it may or may not leave
To
a mark.
you.
But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
It's not
Did
called
you consider
health-
phone
it's-
temperature?
Okay. It is not called healthcare data. Healthcare data is your medical records, your insurance card. Anybody know what it's called? Apple Health data. It's not Apple Healthcare data. I wish he would correct him on that because he's making us crazy.
Battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again, did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Were those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos, E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's in a...
Excuse me, sir.
When the music's over, turn out the lights. Turn out the lights.
In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your video, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Can I
an
have Exhibit
individual.
73, please?
For the love of the traveling Mary.
Do you see that, sir?
He's not supposed to be
I do.
watching
Do
this.
you know what that is?
Welcher.
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these
don't think
different
it is.
things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't, was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Your ample
Yes.
study.
what I'm asking you is, when you were looking at all the available evidence,
How about your ample?
did you look at this photo of this alleged
taillight chart on the front lawn of 34 Fairview Road. Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened,
Right.
then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary
Nothing
to
else
what you're
matters.
attempting to conclude.
Nothing else matters.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the
was
front lawn
planted.
of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have
she would say
exhibit
it was
76A, please?
She would say it was planted. It's planted. Well, part of that, don't you know? You want the witness to say that, so you can scream about a
Did you see this
mistrial.
photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies
Andy.
that this taillight shard was found
We're counting on you, Andy.
in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found?
Yeah.
And where that was found with respect to Mr. O'Keefe?
Oh, yeah.
With respect to a reference point?
Did you consider this, sir?
There is none, so, no, I did not consider that.
Bam.
Do you know how this taillight?
Can you give me a precise point where that was found? Can you give me a precise measurement of where that? Listen to that again. And Hank just blows him off. And then Andy says, because you can't. This is beautiful. This is beautiful. This is everything we've wanted it to be, and then some and more. I hope he says it was planted. Listen,
Your biomechanical studies, the light shard?
biomechanical
It
studies.
looks like it, yes.
Did you consider this in your biomechanical studies that this taillight shard was found
It's beautiful.
in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none, so, no, I did not consider that.
He laughed.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There
Nobody
are
knows.
certainly different possibilities of how that actually occurred.
Exhibit 99D.
Tell us some possibilities, Andy. Tell us the possibilities. I mean, there's
You know
no
what
way
that
the
is,
feds
sir?
aren't watching.
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
Yeah, I did.
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may
He did
appear
it.
in a yard.
Who
He
do you
did
think
it.
put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us?
Or someone could have put it there. You want to keep digging? Let's go. Bring it. Remember what Karen Reed said? Do your worst. Listen, this is beautiful. Is one way that it could have been a collision with a Lexus? Listen,
There's a number of ways a hat can end up in a yard.
yep.
Right. Is one of those ways being in a collision with a Lexus?
Look who's in the screen.
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to
Yes.
when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir?
Oh, is he looking for a mistrial, Brennan?
By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please.
I wish the floor would open and suck Brennan down with it. You betcha
Have you
he
seen
wants a
this
mistrial. He's baiting
I have,
him.
yes.
Okay. In your studies or your testing, Did you determine how Mr. O'Keefe's shoe ended up near the curb?
Yeah,
No, sir.
Could have been put there. Just like the hat. Could have been put there.
Exhibit 201A, please.
You have a theory you'd like to share with us, like planting evidence? Brennan said that. And he just told the jury, Brennan told the jury, that
Have
a
you seen
theory
this
could be that it was
photograph
planted.
before?
I've lost my mind, officially. I've officially lost
I
it.
don't know that I have.
If you find my mind, please return it to me.
Have you ever seen any container that had taillight shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt?
No.
Have you ever seen any container holding those?
I haven't, well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please?
Great. He's going to have a better answer for this. You better want what you wish for,
Have you seen
Hank,
this photo?
with this witness.
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that were recovered from Mr. O'Keefe's
When?
sweater or shirt?
They were
I'm
not.
gonna allow that. Did you consider that?
They weren't.
I'll try. I'd rather
Those were
try
not.
to reformat
Those
than
were not
try
found
to-
on the shirt. Hello. Okay. Am I wrong?
Did you know that taillight shards
That did not happen.
were collected after Mr. O'Keefe's sweatshirt and T-shirt was scraped?
I'm gonna allow that.
They're not.
Jurors, this will be brief.
This will be brief, jurors, because I already know what I'm going to rule, and I'm already going to rule that it's coming in. Wow, Brennan is a fool. He's the worst trial lawyer maybe that I have ever seen in my life. This man does not know when to stop. He is asking question upon question upon question, and he's getting the witness to say such things as like, could have been gotten there a lot of ways. Somebody could have put it there. Somebody could have put it there. Can you give me a distance, a measurement from where Mr. O'Keefe's body was allegedly found, that this taillight piece was found? No, you can't. It doesn't exist. So no, it doesn't matter. It doesn't matter because he wasn't hit by a car. It doesn't matter because the car never hit his arm. What are we doing here? When he is allowed to, without any ramifications, get up and say, do you know these were found on the sweatshirt? No, they weren't. That picture was not of things found on the
In your
sweatshirt.
extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his T-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis, to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Could have been in the same bag with the taillight.
I'll try again.
Okay.
For the same reason I just explained to you at sidebar.
Look at these taillight shards that were projection.
He keeps calling them taillight shards.
Go ahead, Mr. Brennan.
When you look at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes? Objection. Same objection.
I understand the objection. Word it differently.
I'm sorry. Are we annoying you, Judge?
You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes?
I do.
And you understand
Superficial abrasions would be highly unlikely.
So every day at this time, the same thing happens. YouTube skips ahead We're a little few scooches behind and it wants to skip ahead because the world does not want us watching this. More of the same.
Move, body move, knowing Indians look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
That's right. Putting the cart before the horse. May not have gone back far enough, but
Could I have Exhibit 201D,
might have only put
please?
a sentence or two. And he's really making me mad now. Melanie's getting upset. Melanie's getting upset.
Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car?
Did I go back
Do you
too far?
understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well, if
that?
that's what you're
I don't,
telling me, then
I don't want you to rely on me. If you didn't see them, it's
We
okay.
don't want to.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to consider in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before it. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact
Alleged
occurred.
evidence.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They're sharp.
They look sharp.
Do you disagree? Do you think they're not sharp?
Well, I don't have an opinion as to that, sir.
We'll take a look.
Take a look
Sustain.
over here.
If you look at that for me kindly, can you tell me whether you think those pieces are broken plastic?
You can't without examining them.
I'm going to allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Okay, let's go back to
Been looking at the normal
20D.
eye.
Perhaps that can help.
Perhaps that can help you. He's trying to make him miss his son's
Not
birthday.
under a microscope. If you pay particular attention to the larger
Emma?
one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
yes.
Shark's tooth.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth
Thank you.
of less than half a millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could
Lodged in
cause
his sweater.
an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm.
Right.
That would be, I suppose, that could be a possibility.
36 abrasions on the arm, 9 holes in the sweater. Make it. The math ain't math, and Hank. Let him talk about it some more. Go on.
In your testing, not to belabor it, I'm just going to show you one.
Exactly.
I want to show you video E. Could we go to video E, please?
All right. Hank had no friends as a kid. He never had a birthday party, and he wants to keep this man here overnight so that he can miss his son's birthday party.
Stop.
How much you want to bet me?
In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no.
A drinking glass, no?
No.
Randy, he's back to Randy now.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Those are the walls
Continue a
coming
little bit,
crumbling
please.
down on you. When the walls
Stop.
come crumbling down.
Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this
Yeah.
test, but you moved the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
He asked that 100
Well-
times already.
No, I'm going to allow that.
Assumes
You do not
facts.
know
not
how
history.
John O'Keefe was standing that night, do you?
If he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his
Nobody
arm angle
knows.
was, would you?
Trouble.
No,
You would not know the exact speed of any vehicle that hit him that night, would you?
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
what do you mean consistent or
Is it
different?
all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please.
Also don't project onto the lawn. But how many
Stop.
times do you want to beat this to death?
Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the tail light, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Not without no
Well,
damage to the ankle.
There's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please?
He's never
Can you
going
see
to
the
win,
feet, doctor?
Yes,
Hank.
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
Staggerly.
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, sneaker come off, and then stagger backwards and fall on their head?
Could somebody plant the sneaker? Could somebody plant the taillight? Could somebody beat a man to death and then drag him into the yard?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
Do you think John O'Keefe did somersaults in the front yard of 34 Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking you.
Yeah.
if he did
I don't even think he got hit by the car, sir. You may have to turn up your own volume. I'll try and be quiet so you can hear what Hank Brennan has to say because he knows when he's going to make a fool out of himself. He moves as far away from the mic as possible. But this witness just said, no, I don't even think he got hit by a car, sir. He just does not know when to stop. A good lawyer knows when to stop. A good lawyer knows when no good is going to come from any further questioning. This is not a good lawyer. Okay?
somersaults in the front yard of 34 Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that.
That's why we're here.
He did somersaults into the front yard.
No, there's no evidence of what he did.
Your Honor, to come sidebar quickly before I start. the next
Okay.
subject.
Oops.
If he drags this out to make Smash Daddy stay until tomorrow and miss his son's birthday cake, I didn't think I could get much madder, but I will get madder. It is currently now here on the East Coast, 3:05. This judge doesn't like to go past 4. You think this SOB is going to try and drag this out past 4? Although I think he said he lives in Pittsburgh. He could go home and come back tomorrow because he would not miss his son's birthday cake. Like the Alberts didn't get home in time for midnight to have any cake with Brian Jr., despite the fact that they wanted to celebrate their birthday with their son.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
I'm going to allow that.
Karen said that in an interview, but he wants to ask Dr. Rentschler that question. There was a clip that he played for the jury.
I'm going to allow that. So, hold
Your
on.
Honor,
Let's get an answer, Dr. Mitchell.
Alan Jackson,
Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
again,
Are
objection.
you aware of that?
No,
So,
glass.
Hold on, Mr. Jackson. Mr. Brennan.
I can
do you have a
reword
quick-
it.
Okay.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Maybe somebody threw a glass at his face
We have Exhibit
when he was getting
52A,
beaten up
please.
before he got bit by the dog or attacked by the dog. Maybe that happened.
Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
Look at the blood.
And could I have Exhibit 195, please?
Ask for measurements again.
You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please.
They found it with a leaf blower. Did you know they found it with a leaf blower?
B. C. D.
He's just calling out letters, and we're not
And
seeing
in your
the photos.
assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Sorry, what?
Yes, sir.
98, please. A little more, please. Do you know what that is, sir?
The drinking
It's
straw.
hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
Okay. And you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
Well, was it
After the interview
before you
aired
came
on
and
television?
testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
While I evaluated certainly for my report for this case, I don't know if I had known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay.
No, I won't address that. I don't know anything about a plant on the jury. I'm Monge, but I hope you're feeling better from your spinal surgery. Don't know anything about it. No admonishment or instruction from the judge to Brennan. Or to ignore his comments, no. But it was good that Alan Jackson did that in front of the jury to the judge. You need to admonish him.
Yes. 124 lines.
I don't know. He's over there talking to defense about what he's going to try and impeach him with
Yes.
next. Some page in line of a transcript of some sort.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
That was the April voir dire.
On April.
And his part of that voir dire was very short, as I
2025,
recall.
did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes. Or
He's
yesterday.
such a close talker. Get away
Now,
from him.
When I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you
Right.
for clarity.
Yes. And he moves away from the mic, Lena.
You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
The FBI did, not the defense attorneys.
Page 125, line 7.
He was already questioned about this.
I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question.
We all need to
This is your
sage our
answer.
homes.
The answer.
Massachusetts. Get out the
You
sage,
asked,
everyone.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
Which is what he said today. Right. He has no soul, what he said in the chat.
I have no further questions.
Praise
Right,
be.
Mr. Jackson?
May the Lord open.
Okay.
Coming to sidebar for something again. All right, we're a little bit behind, so we have a little bit of room. To scooch, to real time. Before we get to redirect. And the great smooth as butter.
Yes.
Thank you. Dr. Rentschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
He opened the door.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information, and again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for that.
To get through this, I'm going to let you just
you.
answer the question.
Sorry,
And-
Your Honor.
Rentschler.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay. Wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. Thank you.
Love the jerky
You
boys.
were asked
Pamela.
about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up, if it was coming right at you and it hits you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not.
Let's go.
No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not, no.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered?
That's right.
And the area was initially searched?
Bring it home.
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself in the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Rentschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred, if the injuries don't match up. If you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the foreman question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
Bring
I
us
do.
home.
Objection.
Yeah,
Bring us
I'm
home, Andy.
sustaining that beyond the scope.
I'm sorry, what? Beyond the scope? His opinion about a
In your
collision?
view, was there evidence of a collision with John O'Keefe?
Sustained.
She's not going to let it in? In your opinion.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you, Doctor.
Hallelujah. Brought us home. John O'Keefe was not hit by a car, in his opinion, and a car did not hit John O'Keefe, in his opinion. And what the F are we doing here again? And of course, hang on.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m., is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
You just showed him a picture.
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
Thank you.
Okay. Judge, could I come sidebar?
Okay.
Oh, okay. We don't have any photograph of him holding a drinking glass, do we? He walks out of the bar holding something. A lot of people think it looks like a beer bottle. I thought it looked like a beer bottle. I zoomed in on it in the parking lot, and to me, it looked like a beer bottle. And I love how Andy is handling himself on the stand. I mean, my goodness, he is amazing, composed, holding his own. He's fabulous. Thank you, Welcha, for gifting 5 memberships. A lot of new members today because of the generous gifting. Ali Oxen, Frey, are we done yet? OMG, thank you for thanking me for doing this every day. Thank you, Kimberly. One of the best experts I've ever seen. Chloe Albert's revenge. The glass was like the loogie that hit Keith Hernandez on Seinfeld. Yes. Krista says, we did it, Joe. We did it, Joe. He's the closer. He's our closer. What do you think so far? I love Rentschler's sassy tude. Says rescue Randy's test E in midair, mind you. Says I'm more of a lessee. For the love of everything that is holy and good. Says Piney Woods. Free Karen Reed. Janet Taylor, this is the judge allowing him a robust cross because of her grave concern of how ARCA entered the case with the defense. Horrible. Yep. Horrible. Welch just says that taillight shard looks like a fruit roll-up. Happy birthday, Kai. Daddy's coming home. Thank you, Rhonda. Help me, Rhonda. Rescue Randy's compound fracture. Hank holding up. Regarding Hank holding up Andy from his son's birthday. Remember, just when you think Hank can't go any lower, he hits the ground and starts digging himself into a hole straight to hell. Go to hell, Hank. You know what? We have a shovel emoji in there for members. It's one of our favorites when people try and either dig themselves in a hole, when they dig themselves in a hole, or they dig another person, but with their comments, maybe trying to dig out of prison after this. The handcuffs are one of my favorites. Yo, Kelly, Karen said he had a glass in his hand when he left the car. Karen said that on Netflix. Yeah, she did, right? She said he grabbed my vodka tonic or something. But again, there's no evidence that he was holding a glass when he was hit by the car because he wasn't hit by a car right? I think that's the point they're trying to make here. And so lots of snow under that glass. Not much snow before 1 a.m., says Canton is the twilight zone. Give me the book now, please. Now, Stephen says that tail light shard, meaning the clear one, is the reflector underneath. Can I confirm or deny? But we've been told through the other crash daddy that there's no way an impact of the arm would have, thank you, Lenita, would have shattered that reflector underneath, right? There's 2 layers there, 2 layers of acrylic. We found out it's acrylic. I think wants to meet Andy out back after proceedings, says Ms. Holmes. Pokey says, I want to thank you for letting me be myself again in memory of the great Sly Stone. I want to thank you for letting me be myself again. That's a great song. Thank you, Pokey. I'll get her done. I'll get her done. I can see clearly now. The rain is gone, says Mikey D's new mascot is a clown. Miracle Archives by Stan Diego. I'm not going to have a chance to get to all of the super chats today, so I'm just going to warn you in advance that I may have to leave when this is over. So do not get like upset with me if your super chat is not read to the class today or put on the screen, because like I said, I got a date tonight. Very important date. I got a place to go. No time to say hello, goodbye. I'm late. Andrea, thank you so much for the very generous Venmo. Watching you since first trial. Got my identical twin sister hooked. Our texts and conversations have our heads popping off. That's awesome. She's on Hilton Head. I won't dox you, but thank you, Andrea. Kathy, thank you, says Free Karen Reed.
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
What search?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall.
Show me the measurements.
So when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Why can he go way outside the scope?
Well, we have the abrasions and then a 1/2 centimeter abrasion, and then we have the laceration and scuff on the left side, and then the skull fracture. It's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 1/2 centimeter. It's not a bruise. It's a 1/2 centimeter abrasions, about an 1/8 of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection.
That's the line in the documentary that you were all laughing about, that you were celebrating, isn't it? Isn't it? Objection, objection, objection. And he keeps going. What? The line in the documentary that you were all laughing about? Oh, you mean that cutting room floor footage that you're alluding to? But what, during the lunch where he was eating his ham sandwich? Listen to that again. You might have to turn it up.
They didn't flinch or they didn't put their arm up. that's kind of the smell test, bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that tail light break, sir? How'd it break that night?
How did, oh, I don't know. There's no evidence of how it broke.
I have no further questions.
Yeah.
All right. You're all set, Dr. Rentschler.
Thank you, Your Honor.
Also, Dr. Rentschler, happy birthday to your son. And thank God the Lord.
Is there
Hold on. For the love of the traveling Mary. Hold on. Alan Jackson is saying something. We thought he was done. She said he was all set, but what is he saying?
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I'm going to see counsel for a couple of minutes over here.
He's trying to get something into evidence. We're not sure what it is. But she doesn't want to, rule on it right now, I guess. She wants them to come to sidebar. If anybody heard better than I did, let me know. She's telling the jury it's going to be quick. I think the defense is going to rest after this, right? If he's done. He probably wants to play. He doesn't want to rest. That's it. He doesn't want to rest right now because he still might want to play whatever it is, that clip that Hank Brennan was alluding to about them laughing about something at lunch with the ham sandwich. That's my guess. It's like, I can't rest until you rule on this because I'm not done yet. I'm not done. It ain't over till it's over, and it ain't going to be over until my case is done to my satisfaction and I get all the evidence in that I want. There was no collision. Can you dig it? Thank you, Sandy Barth. Beth Allen said, I thought the Emmy said there were no shards on his clothes. The Emmy said she did not receive the clothing. She did not receive the clothing, correct? The only clothing that she received was were the socks, apparently. And we don't know where the socks went because, they may have had dog hair on them, but we don't know where the socks are or went. And nobody's ever asked. And I'm still screaming about the socks. And the Emmy did say the clothes would be very important for her to determine what happened to him, but they didn't give her the clothing. They seized it from the hospital and took it with them. That was Buchanan and Proctor, and maybe the clothing was proctored. Catherine, oh my God, what am I watching him in the hospital while my daughter undergoes chemo for her leukemia? I'm so sorry. I hope she's doing well. And Brandon Cross is such comedic relief. He's an absolute moron. I mean, I can't say enough about how absurd this trial is. Prayers up for Catherine Smith's daughter. Thank you very much for being here. I'm glad that we can make you laugh during what is not a funny time for you and your family. Steady Breathing says, I'm only jumping in now. I was listening all day. Brennan, all day. He's only short of asking, do you know the Muffin Man? Yeah. People within, I had to make sure that this was on. Everyone looks frozen on the O'Keefe side. One person eventually started to move, but I thought I thought Court TV's stream was frozen. Thanks, Neil. What happened to an hour, Hanky? Oh, that was hell a lot longer than that. Sweatshirt evidence. Not sure what you mean. Sue posted on X that the doctor said he did get hurt by a collision. I didn't hear that. Fitzgerald, no taillight bulbs in the housing for evidence, but the brake light worked and illuminated red upon loading onto the tow truck. Yep, we've seen it. If the jury gets the case on Friday, will be Amanda from Scotland. Cheers from Scotland. Hi, Amanda and Eddie. If the jury gets the case on Friday, will they be deliberating through the weekend? Not in this court, they won't. Hell to the no. Some courts do. In other jurisdictions, this court won't. Hell no, because that means the judge would have to be on standby or in the courthouse, and she's not staying there. It's Cape weekend. It's the summer. It's the summer. Shout out to Sarah Townsend, the best hospice nurse out there. Free Karen, says Eric Townsend. Thank you for your 20. Paula, thank you for your Venmo. How does Welcher justify his results after the ARCA expert's testimony? You know, some people are paid hacks and they just say, I'm not saying he is one. Some people are, and they'll say whatever you want them to say for the right amount of money for 400K. They'll say what they want them to say, maybe. Thanks for this coverage of it, my coverage of a Shonda of a trial. Thank you. Thank you, Wendy, for loving the show. Thank you, Kathleen. Says she's watched both trials with me, loves my passion, keeps me sane, thought she was going to lose it. Thanks, Kathleen. Catherine, what if the real reason Albert and Higgins weren't called as witnesses is per the Department of Justice request? I don't know, Catherine. Listen, anything's possible. Holly, thanks for the coverage. Justice is coming, says Holly. Another Holly, you're amazing. Love you with all of my heart. Linda, thanks for doing what you do. Thanks for watching, Linda. Tammy, free Karen Reed, thank you for your coverage. Thank you for watching, Tammy. Marie, when Karen's found not guilty, it's been said that no one will ever get convicted. Could the O'Keefe family call for the case to be reopened? I don't think the case is closing. I don't know. I don't. It has been said that there may not be enough physical evidence because an investigation was never done, but
For the day. We will see you tomorrow morning. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
All right, so the jury.
Emily loves the song Green Flag by Paris Ray and the Crush. That is the name. That is the name of the song. Green Flag. Stephanie says Brennan's theme song is Last Breath by Creed. Oh, well done, girl. Well done. I think she wants to talk to the attorney, so we're here for it. At least for now. Lynn says, in so many ways, you're the best. No, Lynn, you are. You are. Corin, thank you, Corin, says free Karen Reed.
You may be seated.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
What PowerPoint?
All rise for the court, please.
Judy, thank you so much for the matcha latte that you bought me today and yesterday. And she's thanking me for introducing her to Paris Ray and the Crush. Loves them now. We'll be watching on Spotify. So she needs a little 10-minute break to go and look at a PowerPoint. Anybody know what this PowerPoint's about? Obviously, it's something that Alan Jackson wants to get into evidence before he rests his case. Sharon bought 3 matcha lattes. Thank you so much for the demonetization fund. Well, I think we're okay so far today. I think we're okay. Thank you to Cheyenne for sending me a video. Boots on the ground. Please share this. I'm not going to share it because there's people in the photo who may not want their photo on the internet, but there's a person dressed in like a Blue Man Group costume. And on the back is a sign hanging from her back that says, but what happens when I spread my load? And she's got her arms out wide. Shout out to Boots on the Ground. That is very funny. DBK in Maine, thanks for your matcha latte. I only stayed sane because of you. See you in post-production. Oh, we're here for it. We're here for it. This is the longest season ever. Thank you, Jessica, for your matcha. Taking a 10-minute time out while the judge goes back and looks at some sort of PowerPoint. So they did not rest. No, the defense has not rested. They will not rest their case until whatever it is that she's going back there to look at for 10 minutes is ruled on. Because he will rest, when he rests, he will rest in front of the jury in open court. He will say defense rest. The defense has been sent home. The jury has been sent home for the day. Thank you, Leanne, for thanking me. Thank you for watching, Leanne. Anne says Spanky is the devil. Good time to point out that the opinions of my viewers are not always my opinions. A lot of times we share our opinions. Teresa, thank you very much. Just says for Karen Reed coverage. Thank you. Motion to have Paris Ray and the Crush write the movie soundtrack. I'll allow it. I will allow it, Kaylee. Thank you. Cindy from Virginia, the sweatshirt evidence after he lied? You think that's what they're discussing right now? Insane with the sustain. Get me a Dr. Pepper and a ham sandwich. Sarah Boone really wanted that Dr. Pepper, remember? She made a motion to get Dr. Pepper during the trial, and they said no. No Dr. Pepper for you. Yvette says Arco was amazing. Justice for John and Karen. Miranda, thanks for your 10 spot. Appreciate you. Cat Randall pointing out the obvious. Mr. Brennan, you are no Tom Cruise in A Few Good Men. Oh no, he's not. Unless he's rage. Says, why didn't Squirty Bello mention x-rays during her testimony? Her office would have been the ones to take the initial x-rays, right? Yeah, it would have. Was she ever asked about x-rays? Did she mention x-rays? I thought she said there were no fractures, but she didn't say how she came to that conclusion. She did say that she did open up the legs to determine there were no fractures. So, no, they didn't rest. Thank you, Daniel. Thank you, Daniel. Removing the text message from the PowerPoint. He said that Welcher even corrected himself after he said no x-ray. If you caught him, he started saying that I recall, and I think so. He was wrong. Marcia, I missed why they couldn't point to Colin Albert as a third-party culprit this time. Well, there's an entire stream that I did on it. We went over the decision on the motion to dismiss. And it's in there. It's all in the papers. There's a very, very long pre-trial playlist. It's in there, Marcia. She said they could point to Higgins and Brian Albert if they produce evidence of that, but they were not allowed to use or point to Colin Albert. However, I have the proposed jury instructions, and the defense did not submit a proposed jury instruction on third-party culprits, so they're not using it anyway. So kind of moot at this point. If anybody remembers exactly what she said about Colin Albert not being able to be used as a third-party culprit, you can put it in the chat. We're very collaborative here. Tina talks, when did you first talk about cops in Boston on the take with the truckers and getting their CDL licenses without testing before the retrial? It was before the retrial. And I remember that it was a show that I did on my channel with Brian from LTL. So if you look for that thumbnail, that's an easy way to find it, I think. Thanks, Tina, for being interested in that. That was a long time ago. Misanthrope, is Welcher allowed to be watching this? He's not supposed to be because he's sequestered. In certain jurisdictions, experts are allowed to watch other experts, but I do think it is the court rule here that he is not allowed to be doing that. Have I read the journals of Vinnie Bombats? No, Whiff and Glue, should I? Whiff and Sniff and Glue, that's hilarious. No, I have not read the journals of Vinnie Bombats. What was Hank like as a kid? Dear God, says Sea Dragon. Barbara Childs, to the mom sitting with her child getting chemo for leukemia. My son was diagnosed with leukemia, 85 at 3 years old. He just turned 43. Never give up. Thank you. Thank you for that, for supporting each other in the chat. You guys are awesome. It's the clips that he wants to play, that Alan Jackson wants to play. Okay. All right. I got to take a quick break here, but I'm going to leave this on. But everyone, take a quick break. I'll be right back. Just talk amongst yourselves for a minute, knowing, full disclosure, if you're super chatting me right now, I may not have time to read it or put it up on the screen. Please don't be mad at me. Super chat at your own risk. Here's the last one. Miranda Morris. I'll be right back. We're waiting for them to come back. Talk amongst yourselves and be good, everyone. I'll be right back. Okay, I'm back. Here's what I think is happening. I think that Miranda Morris, thank you for your 10. Hot Stuff by Blue October for Crest Daddies. I think that they are back there. She's back there looking at a PowerPoint that the defense wants to introduce to put context around the clips that Hank Brennan has shown throughout this sham of a prosecution. And I think he's got to. I think it's got to be done. I think they need context. All of those ridiculous clips. Well, they're not ridiculous clips. I mean, they're clips that do not paint Karen in the best light. And when I watched most of those documentaries live, I thought to myself, oh my God, this is exactly what they're going to clip. And those are exactly what they did clip. Things that did not look great for Karen. And apparently they did a PowerPoint and the judge has to now look at it to decide whether or not she's going to let it into evidence. They did not rest. I'm telling you, they did not rest. I don't need to rewind to tell you that. They did not rest. It needs to be done in open court in front of the jury. The jury's been excused. The defense did not rest and they will not rest until all of the news stations are saying that the defense rested. Then why are they looking at the PowerPoint? All right, I will rewind it. It's got to be done in open court. Everyone is saying that they did. Okay, maybe I'm wrong. But we'll listen. Was the mic off at the time? All right, here's Rentschler is finishing.
And
You're all set. Let's hear your all set.
scientifically.
He's still in the stand. Sidebar. They did not rest. I know. Why is all the media reporting it, though? This is why you don't watch mainstream media, folks.
Please do not discuss you tomorrow morning for the day.
I mean, she says we're
Jurors, we're going to release you for the day.
jurors, we're going to release you for the day. Why is all mainstream media?
Tomorrow morning, those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation.
Because the media is dumb.
Please,
The
if
media
you
is
happen
dumb.
to see, hear, or read anything about this case, please disregard it and let us know.
Bev
We'll
told
see
Hank
you
to watch a
tomorrow
10-minute video.
Rise to the jury.
Yeah, and I think Alan Jackson was like, look, I can't rest. I'm not resting. We are not resting until we get this evidence in. They got to put context around that.
Be seated.
Around
All
the
right,
clip.
so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10
right.
minutes regarding the PowerPoint.
Right. So Brennan has to review the PowerPoint because he's going to object to it. And so she's going to hear his objections after he has 10 minutes to look at it. Because he's going to say, I just was given this PowerPoint today or yesterday, and I object because I didn't have enough time, mommy, mother, may I? Boston fake news as usual. No, we're waiting to see if Hank Brennan is going to have any objection to the PowerPoint made by the defense. And so I know. Boston people are reporting that the defense has rested. I am saying no. I did not hear it. Hank has to listen. He has to watch the PowerPoint. That is still defense evidence that they want in their case in chief. So I do not know what to tell you, but I'm not spreading information that I can't verify, and I don't watch mainstream media, and this is exactly the reason why. Not fake news, just inept news. Well, if it's fake if they didn't rest, and that's what they're reporting. So we'll hear from them when they come back. I imagine that Alan Jackson is going to say to the judge, I cannot rest until I know. Well, none of us can rest until Karen Reed is not guilty. I cannot rest until we get an answer on the PowerPoint. Okay, that's great, Martina, but I'm not going to spread it. She said 10 minutes. We're waiting. We're here. Let the media assume that they rest because one picks it up and then they all pick it up. And that's what happens. You know what else spread like wildfire? On the day of January 29th of 2022, mainstream media reported that there was ring camera footage of the incident of Karen Reed hitting John O'Keefe with her car. That spread like wildfire. Well, I forget who it was that it reported on it first. Boston 10. Everybody picked it up. It was throughout it was in the Daily Mail had it in the UK before you could do one of those 250 millisecond blinks. And it's still out there. You can still find it. Is there ring camera footage of John being hit by Karen's car with her vehicle? No, there's not. It's still out there. You can still find it. It was never retracted. Remember the game Telephone? Yeah. Remember, I'll tell two friends and you tell two friends and so on and so on and so on and so on. I'm sorry, but I've been a lawyer for over 3 decades. And typically, I mean, in real court, in real life, the judge will say to the jury, the defense has rested. It didn't happen here. Okay. Maybe I should just go. Because if everyone can't like control themselves in the chat from just reporting misinformation until the court comes back, if you just can't help yourselves, let's talk about something else right now. Let's talk about something else. What can we talk about? Anything else? Let's talk about anything else right now. It's the clips that he wants to play, says decorated dude pickup lines, right? So he couldn't have rested if he still wants to put in evidence, right? Decorated dude pickup lines. Thank you, Miranda. Pure wet Randy needs a vac. This is like the Truman Show. I can't get away from my TV. I need to eat, shower, and get back to work. Prayers for LA. Yes, Edmund. Prayers up for LA, everyone. It's Narnia. It's the Inside Out Hunger Games. We are so far back into the wardrobe in Narnia that it's insane. Amy in Arizona wants to know if Dr. Rentschler prefers Dijon, sweet honey, or French mustard on his ham sandwich. Praise be for the good doctor. Let me just say something, Amy, and you can tell me whether you agree or not. People who put mayonnaise on ham sandwiches, I can't. I could never. Could you ever be with somebody who put mayonnaise on a ham sandwich? No. No. How about like mayonnaise on corned beef or pastrami? No. You can't have it. What do you prefer? I'm a Dijon girl myself. I like the Dijon. I like the Grey Poupon. But you tell me, mayonnaise on a ham sandwich? I can't even do, like ketchup on a hot dog is disgusting to me. Disgusting. Ketchup on a hot dog is gross. It's gross. Burning Queen can't be with anyone who uses mayo, period, full stop. He did say it. I just went back and heard it. With that, the defense rests. Well, then how would they be able to put in any more evidence? I'm not saying I'm not saying it's the rest of the chat's fault. And I didn't, oh my gosh, people are so sensitive. So sensitive. I love mayo on all of my sandwiches. I mean, on roast beef or like a steak sandwich, I get it, but I'm not on ham. No tomato and clam chowder. I'm a New England clam chowder girl myself. I don't know. Did they decide if tomorrow's a half day or a full day? I don't know, because originally it was a half day. Then she said, jury, we were ahead of schedule, but we want you to be, we are asking if you can work a full day on Thursday. And then we don't know what she ever decided after that. Sunrise, South Dakota became a member. Kiki Marie became a member. Kiki says, I'm so shocked that Bev is so blatantly showing her bias, knowing the world is watching. Secondhand embarrassment for sure. For sure. I know. It's true. It's true. Everyone's on their last nerve today, I think. Everyone is on their last nerve today. Like, it's insane. Sue O'Connell just confirmed that the defense rested. Do we believe everything that we hear on Twitter? Do we? I mean, I just told you that they also said they had ring camera footage of the incident. Do you hear what I hear?
Right, and then
Roll
the
it back.
skull fracture, it's a little bit to the right, but it's mainly on the back
Do
of
you
the head.
see
bruise
what
on his
I
knee.
see?
That's the half centimeter. It's not a bruise. It's
Dr. Rentschler
that's kind
on
of
the stand. Fast forward.
For a couple minutes over here. Jurors, I want to see counsel for a couple minutes for identify.
Hold on.
No. Subject to discussing.
Let's hear if we can hear what he's saying. Because
Thank you,
he's
Your
all
Honor.
set. Now listen. Turn it up.
Is there an objection?
Your Honor, I moved for the admission of the PowerPoint at this time. Is there an objection? Yes. Hang on. Let's hear it again.
That Dr. Rentschler.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. It's not coming in right now. Okay.
He did say, okay, then with that, the defense rests, or subject to that, the defense rests. Listen to it again.
Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay.
With that, the defense rests. It's hard for me to hear.
They've been marked for identity. Jurors, I want to see counsel for a couple minutes over here.
Right, she didn't announce it to the jury that the defense rests, so.
They've been marked for identity. Jurors, I want to see counsel for a couple minutes over here.
I mean, it's iffy, but she did not announce to the jury that the defense rests. And so I think we have to wait and see what happens when they come back. He did say something like maybe subject to that, or after that's decided, then the defense rests, just to give her an idea of whether they're on schedule. And so it's not official until I hear it officially. And so subject to that, the defense rests, or when, if after that happens, the defense rests. I mean, you can't rest until you know whether or not that's getting in. Because you can't trust her, and then she's going to be like, oh, well, you can't put in any more evidence because you already rested. So I don't know. I know that people are reporting that. I cannot confirm it, and so I'm just not going to report it yet. That's me. That's how I run things here.
Tomorrow morning, those same cautions, please.
I mean, she
do not
let them go.
discuss this case with anyone. Don't do any independent research or investigation into this case.
Yeah,
If
they
you
also said-
happen to see, hear, or read
They're
anything about this case, please disregard it.
She would have said it in front of the jury. So yeah, I'm not going to believe it until I see it with my own, or hear it with my own ears. And so I think what he meant to say was, subject to that, we're going to be resting after there's a decision on this. And then, there's a big show of it. The defense rests. It's not something that is not said into a microphone while Jim is coughing into the microphone and somebody else is rustling their papers in front of the microphone, and whatevs. We're here. We're waiting for them to come back. The Lori Vallow case rested. Okay. He said subject to that, we can't rest, said J.R. Kuber. Okay. But they're going to run with it, and they're just going to report it out there as if it's true, just like they reported there was ring camera footage of the incident. That wasn't true. Right? Did we determine whether mayonnaise is appropriate on a ham sandwich? Ooh, that traffic jam. Got more cars evidence than the beach. Thank you, the other Karen. Ham sandwich poll. How do you like your ham? Says Bex. I don't have time for a poll right now. Thank you, Natalie, for loving and appreciate me. I love and appreciate you too. Is David Jones Beach Night going to see him in the Big Sky in August? Ooh, at Big Sky? He's in Montana? Oh, yes. Yes. You need to look further than the actual as such tour list, but I have a date with Dave tonight. No mayo on pork products. Please tell Melanie that Karen Reed said yesterday that the Commonwealth had the x-rays. Thank you, Sherry Prince. Thank you. hot ham and cheese with horseradishes. Cubby cat. No, I'm not ending the stream because people don't understand the law. I'm just, I don't like to spread misinformation or have misinformation or disinformation or unconfirmed information in my chat. And when it runs rampant like that, it's like, come on, let's all just take a break. Everybody take a step back. Everybody's on edge here. Green-eyed Southern Girl says, Melanie, did you already know that you're my hero? Well, tomorrow, if this PowerPoint is admitted into evidence, it will be shown to the jury, I imagine, if he wants to publish it, because I think the world needs to see the context behind the clips that were played in court without context. And then the defense will rest. And then Hank Brennan will be able to put on his rebuttal case. And I think he wants to call Welcher back, and he wants to call the DNA tech, Maureen Hartnett, who swabbed the clothing, and wants to see. Krypton says Dr. Welch is going to redo his analysis with yellow paint this time. Google Adele. I don't know who that is. She's on Google talking about fake news. I'm not gonna. I don't know what that. I don't know what that means. I don't know. This is the longest 10 minutes ever. Ever, says Plum. Couldn't find the civil trial playlist. Can anyone help me? I wondered if it's not available in the UK. Let me see. I'll take a look. I'll take a look for you. Sure. We got a few minutes here. Why not? Playlist. It is called, what is it called? Oh, good. They're back. Praise be. Under her eye.
Court is back in session. You may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
It's exactly the substance of this. Dr. Welch's part.
Which was not objected to, right?
Alan, find the mic for the love of God, for the love of the traveling Mary.
The substance of this. Dr. Welch's part.
Which was not objected to, right? But did he object to the PowerPoint coming in?
We're all under pressure.
Everyone's under pressure. Under pressure.
That's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay, a discussion, opinions or thoughts, thought processes. These are all tests that were completed and done, exactly as Dr. Wolf's PowerPoint is done. Dr. Wolf's PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are, most of the videos are included. Oh, no, I'm wrong. Things have been slowed down. So there
Listen
are
to her
videos
size.
saying, but the videos that Dr. Rentschler used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, about which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me. Okay, whether they're in evidence or not, and which ones are not, regarding the videos.
Is the court suggesting that it's not going to let just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welcher's. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. only a select amount of documents were allowed. I wanted the whole thing in. I was precluded from
Jury's gone, yeah.
using it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have imposed that objection before it was displayed for the jury.
Well-
The jury has now seen the entire PowerPoint. I mean, it's tactical. It's not strategic. It's tactical. They just don't like it because it hurts the case. If they didn't want to get certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing it before the jury. Given the fact that it's been displayed in, not in part, in whole, as it now sits before the jury, sits before the court for quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess. It's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to.
Apparently, this is not about the clips. This is about Dr. Rentschler's PowerPoint presentation. And Hankey's crying that, you objected to mine. I'm now going to object to yours. And he's saying they've already seen the entire thing. We just want it in evidence. And the reason for that is because the jury gets to bring it back with them while they're deliberating. And now they're whining. Hank Brennan's whining that it shouldn't be allowed in. Meanwhile, the jury's already seen the whole thing. What's the harm? It's not hearsay. Hank can't formulate an objection because there isn't a valid one.
Put in evidence the videos, just the videos, and you want to put in evidence the videos, just the videos. Let me know that, and if need be, I'll hear you all on this tomorrow morning as well.
She just wants to get the hell out of there.
All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witnesses putting on any further.
After the defendant rests, we will not be calling any witnesses. What? Did you just say that? So the defense has not rested, okay? We can put that to rest. The defense has not rested. What did he just say?
After the defendant rests, we will not be calling any witnesses putting on any further evidence.
There will be no rebuttal case. He just said there will be no rebuttal case. We are not calling any more witnesses. I think they realize the jig is up. The news is out. You finally lost the damn case. Congratulations, Katie, on your first super chat in this stream from Australia. The defense has not yet rested. Thank you if I'm the only one reporting it accurately, other than the mainstream twidiots out there. And Hank Brennan has just announced, because a lot of people might have shut it off after they thought he rested, they are not putting on any more witnesses. There's no rebuttal case happening. I heard that right, correctly? We're going to play it again for the third time. Because this is what I do. I like receipts. Okay? Listen.
After the defendant rests, we will not be calling any witnesses putting on any further evidence.
That
Okay.
no rebuttal case, no
All right.
Welcher, no dog DNA. It will be done.
Your Honor, it's late in the day. We would like to review our motion for required finding of not guilty at the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers when we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it?
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So,
The only other technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence, right?
They're trying to mark as exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor, I mean, ruling that they're.
Are they,
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification.
so I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, they're exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this court's parlance. Yes, It's YYY, ZZZ, AAA, BBB.
So that means there, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Wants to move it into evidence.
My whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
Thank you. He wants to move them into evidence, Your Honor.
What number are we at, Madam Court Reporter?
Exhibit 230.
Okay, and we'll do A, B, C, D.
230.
So is it Y, Z, A, and B? I think I have.
Tiffany says she called it. No rebuttal. Praise be. Praise be, Tiff.
I don't think I have. Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow, we need to physically put the sticker on those. Yes.
230A.
I'm sorry, say that one.
230A through C. 230C.
Steady breathing needs sun and a cocktail and therapy after this. You're right.
All right.
They didn't rest.
Council, there are 4. A through D.
Because you got to have proof. Maybe.
Triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. As soon as we do that, I'm good and I'll get out of here.
I'm good and I'll get out of your hair. I'm going to wash that man right
We will
out
do
of my
that
hair.
first thing tomorrow morning.
That's fine.
All right?
Name that musical.
We will, so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay.
I'm not
All right,
interested
so
in
we'll give you
arguing tomorrow.
tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow
Okay.
morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
Yeah, that'd be better.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay?
23.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing arguments. Last year, we were relegated to 1 hour. I would ask for an hour and a half.
He wants more than an hour for closing. Praise be.
No, I got it, but now you can go.
I would ask for. I would ask for an hour and a half for a final summation, given
At least.
the length of the case, the amount of evidence that's been adduced. I don't think that's outrageous. I mean, the court normally allows only an hour.
You might get an hour and 15 minutes out
Oh,
of me.
for the
Let me
Lord.
see about an hour. Let me see. You would not have
bullshit.
got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the same?
I don't have a position. I'll take whatever the defense gets.
Let me think about it. All right.
Let me think
So
about
we
it.
will see.
Thank you.
All right.
Let me
so see
think about
everybody
it.
At 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you, Your
All
Honor.
right, we'll
Yeah,
see you
your
tomorrow morning.
future on the bench.
All rise for court, please.
I said, Your Honor, we'd really like more than an hour for closings. There's no way that an hour is enough. We'd like to ask for 90 minutes for closing. And she said, maybe I'll give you an hour and 15 minutes. There's a woman facing life in prison on a sham prosecution. You know it. I know it. We all know it. Maybe I'll give you an hour and 15. I'll think about it. We've seen cases where the trial is 5 days long and they're given 3 hours for closing. There's no way an hour is enough. I don't even think 90 minutes is enough to close on this case, but he only asked for 90 minutes. Brennan doesn't care, but she's going to think about it. When you think about dismissing the charges, directing a verdict, that's not going to happen either. For the record, the defense has not rested. I don't care what you're reading on Twitter. I don't care what the Twidiots are spewing. I don't care what those networks out there that call themselves mainstream media are saying. The defense has not rested. That is fake news. The defense will rest in the morning after it is determined whether or not the PowerPoint presentation is going to be admitted into evidence so that the jury can bring it back. The jury is being called right now and said, you don't have to come in tomorrow because they're going to have the charging conference tomorrow, which is where they discuss the jury instructions that we went over the other day, some of them anyway. Charging conference is where each side comes in and says, this is what we want you to instruct the jury. And then they decide the judge makes the final determination on what the jury instructions are going to be. And then Thursday, the jury will come back. No, wait, tomorrow's Thursday. Friday, the jury will come back, hopefully at a normal time. There will be closings. The judge will charge the jury, and the jury will get the case by Friday lunchtime. Will they come to a verdict on Friday? I don't know. The charge conference will be televised. We'll be covering it tomorrow. We'll be here. And it's a late start tomorrow, 10 a.m. Make sure your bell is set. Make sure you have your notification set. Make sure that what about the DNA crap Hank asked Russell about? Well, I think that there's going to have to be an instruction on that. I think they are going to argue for an instruction on that. Hank Brennan has announced he will have no rebuttal case after the defense rests. All of that nonsense about Colin Welcher back and the dog DNA that he crossed somebody on. I forget who now at this point. I think it was Lopesada that he said he was bringing rebuttal witnesses on. He decided not to have a rebuttal case. And so therefore, there will hopefully be a not guilty verdict by Monday afternoon, and Mr. Reed will have a very, very, very nice Father's Day. The missing witness charge will be discussed tomorrow. That is part of the charge conference. The charge conference is where they talk about what the jury instructions should be. And so we will be here for that tomorrow. It will be televised. We will be covering it. So I will see you tomorrow. The jury is not. Court TV said no court tomorrow. Again, don't listen to Court TV. Don't listen to them, okay? The charging conference is always televised. So I'm going to be here. If you guys want to come, come. If you don't come. I don't know what to tell you. It's always televised. If for some reason it's not, we'll find the Zoom link. Don't worry. Don't worry. We're going to be here. We ain't got no quit. We need to hear them argue about what the jury instruction should be. We need to hear her ruling on the PowerPoint presentation. We need to hear her ruling on whether or not she's going to instruct the jury to disregard the fact that Hank Brennan brought up the dog DNA with the witness. There's a lot of things that still need to be ironed out before Friday when closings will happen and the alternates will be pulled and all of it will happen. Okay. I think we've all had a very long day. I think we all need to go and take a break. I have a date with Dave Matthews. Thank you all for tuning in. Thank you to the moderators for keeping it classy. This was a hard day. It was hard. But Andrew Rentschler brought it home. He was our closer and boy, did he deliver. Do all the things that YouTube likes, please. Smash the like button, respectfully comment, be kind to each other, stay cool. It's Friday the 13th. Wow, that's great. It won't be until 10. You will see me at 10, not 9. They're coming at 10. Stay cool, stay kind, stay classy, be a good person. Don't spread misinformation, and come back and see me again tomorrow. Thank you so much. Yeah, he did. I'm not reading any more super chats. I told you guys that earlier. After that, he'll rest, but he will rest in front of the jury. Okay, in front of the jury. That's how it's done. He'll make the motion for the directed verdict. He will be denied. They will do the closings, and then as such like that. They just said they're not bringing the jury in tomorrow. I got all the information. I'm keeping it tight here. That's why we stuck around to hear it from the as such horse's mouth. Okay, be cool, be kind, stay cool, classy, all that stuff. Good night, everyone. So damn lucky. Crash into me and Gray Street. I'll see you soon. Good night.